Behind every crime lies a story waiting to be uncovered, from chilling mysteries to untold truth. This is where the darkness comes to light.
Roaring buzz lights up the air, faces tense as stories tear, truth and lies like a tango dance. Justice here takes no chance. Gavel strikes, hearts beat fast. Witness takes, stand shadows cast. Whispers loud like wildfire spread. In this game, none's ahead.
Hello, good morning. I need to test if my mic is working. Hi. Let me just test. Yeah, it is working. Hi, everybody. Sorry, I was just testing the microphone because over the weekend I disconnected everything because I took my laptop to my sister's-in-law and to see if it would if I had time to do any work, but with a newborn baby, there is no time because they are so good. But good morning, Denise. Good morning, Paula. Hello, Zizzy. Hi, William. Good morning. Hi, Lois. Good morning, everybody. It is Monday. Happy Monday. I hope everyone had a great Easter. I know we did not have the greatest news this morning, but not like it is very sad losing someone. So it is very sad news that about the Pope, but we're not going to go into that. But yeah, so guys, I am so in love with my niece. She is the cutest thing ever. I've been posting a lot of pictures on Discord. I do have some new pictures. There's like she hasn't changed much yet, but you know me. I am in love with her. She is the gorgeous thing, the most gorgeous thing ever. She is it is very sad to hear about like even especially like just talking about like in general that he did the service thing yesterday. It is very sad to hear that he has passed away. Obviously it's always sad when someone it's not longer with us, so it's very sad to hear that. Good morning, Stephanie. Hi, good morning. Happy Monday. I hope you all had a good Easter. I I don't really celebrate Easter, but I had a wonderful weekend with the baby girl. She's so cute. Like with everything that has happened in the past, right? With my nephew and everything, just hearing her cry, we were all happy. Just hearing her struggle and like moving and everything is just a great joy that like honestly one on because I'm gonna tell you the story. Obviously, on Wednesday night we were already a little bit in like on standby because my sister-in-law has started the contractions, but we don't know did not know if it was Braxton Hicks, if it was something else. So we were like, okay, still no baby, that's fine. I'll wake up in the morning on Thursday night. I was having breakfast with Garden Bot, and I get a text from my brother-in-law saying, well, we are in hospital, she's in the delivery suite, we are on full effect. And literally, and kid you not, me and Garden Bot dropped everything, drove to the hospital, which is like about 10 minutes away from our house. Um, Drove to the hospital, and we were still there outside of the delivery room because obviously only the mom and the dad and maybe one more person could be in the room, but they have decided only them will be in the room, which is absolutely fine. It's a decision. So I was outside pacing backwards and forwards, just waiting on news. Then my in-laws arrived as well, and then Jed Gardenbot had to go to work. So it wasn't we were so nervous. We were trying to, talk, decompress a little bit, but it was very, very nerve-wracking. I'm not gonna lie. Then we received a message from my brother-in-law saying that she was born at 8:38 a.m. Obviously they left a little bit time to, making sure that she was okay. And yeah, and then they just waited a couple of hours, obviously, for my sister-in-law to recover and everything. So we were actually, me and my in-laws, we were on the way to the restaurant because we were hungry. And I said, oh, okay, they might still take a little bit of time, let's go to the restaurant, let's have some food, and yeah, we'll go. So funny enough, hi, good morning, hi Sissy, hi. So I'm just literally telling the story of the birth of my niece. So we were, funny enough, we were going to the restaurant to have some food in the hospital, and we pressed the button on the elevator, and it came, but it was busy with the patient. So we were like, okay, we'll wait for the next one. We could have gone through the stairs, but I don't know. Something must have happened because we called the elevator again. And when we called it and when was still not there, I get a message from my brother-in-law saying, "You guys can come in." So I almost ran. My father-in-law and my mother-in-law, they just walked because they cannot run anymore, sadly. So we were like, let's go. So then we got to meet up. Oh, it was the most precious thing. I cried. And you guys know I cry a lot. I'm a crier. You know that. Everyone that is here know that very well. So I cried my eyes out. I even talking about that, it gives me a little bit emotional, just talking about it, which is wonderful. She's amazing. Of course I cried. Exactly, Paula, what else is new? Zio, hello. Good morning, good evening, good afternoon to you. I don't know, whatever time. So thank you very much for popping in, girl. I am a crier for sure. I'm already crying. I'm like kind of crying already right now, and it's I'm just talking about it. um but has hi so yeah, so it's just literally we met her and we just stood there for, I wanted to stay there for the rest of the day, but is it wasn't possible. Hello, good morning, Emily. How are you feeling? How are you? How was your weekend? I hope you are feeling better, my friend, because I know you weren't very well last week with the no, I don't even, I can't even say the word. No, how do you say? I can't, I'm gonna spell it. Um, I think that's how you spell it. I can't even it's
Pneumonia?
like that. I hope you're feeling better with. I'm sorry, I can't spell it or say it. I need English lessons apparently as well. Um, so yeah, so then obviously we spend the whole day together on Thursday, just hanging out and enjoying the baby, and as together as a family, kind of celebrating that everything went fine. And then on Friday we went back to the hospital, and then we went home, they went home, and obviously I pneumonia. Oh, okay. Thank you very much for the phonetics. Thank you. Pneumonia. See, thank you very much, you guys. You guys had me helping me speaking. So, oh, hello, Sick Injustice. Hi. Good morning. Great to see you. Very, very good to see you. Okay. Oh, that's good. I am so glad that you are feeling a little bit better. Oh, it's enough to go to work, but be careful. Take it easy if you can. Make sure you drink lots of fluid. I actually do need the water as well. But I am very, very glad that you feeling better. So yeah, so I recorded they coming out, like I literally was obsessed uh, with filming. So I filmed them getting out of the room and walking on the corridor of getting out of the hospital. And then I recorded them getting out of the hospital wing. I recorded them getting into the car. And then when we get back to their house, I recorded them from the car to their house and walking in at home, like as a family of three. So it was emotional. I think we all cried. What a surprise. So it was very, very good, and still now, I mean, it's very, very great to have our niece and the little milestones that she's already achieving, it's a celebration due to everything that we went through. Everything we find as a celebration, and we celebrate that she's doing little things, just so yeah. So it's great. I after work today, I went there obviously to get my cuddles in. But I need to readjust. Well, it's only 3 days a week anyway that I work in the mornings, because I'm hoping our next trial it's going to be a more time friendly trial for me, not like a late evening one. So I'm scared. I'm still gonna get my cuddles, because obviously I need my cuddles to survive now. Um, but it's going to be a bit tight, but we'll make it work. Everything is going to work just fine. If I have to do some research at lunch break, I'll do research at lunch break, or I can just ask my good friend Zio to do it for me. No, I'm joking. I know she would help me. She's amazing. So but so yeah, so that was my weekend. And then obviously Saturday and Sunday I spent 99% of the time awake there, with the baby and everything. So I know you can, and I really appreciate that. I really appreciate that. So because it's awesome to to have you as a lean on, and I know I can lean on everybody else. I know Stephanie, Zizi, Lois, Paula, they all help, and your guys are a great addition to the channel and everything. Even Seeking Justice helps us. So okay. Oh, I'm going back to your pocket. No, I'm joking. I'll see you soon, Zio. So shall we get back to started with court? So today, oh, I need. Don't forget to play the verdict game. I can put the form, because we are on the verge of finish with the Lori Vallow case. Hey, yay! I'm kind of excited to kind of see her go. Um, because the time of the case, I'm not like, I could do this trial a little bit longer, but it's just the fact that the time zone that she is on, it's absolutely incredible. So I know I came on. Hi Maria, good morning. Hello, hello. I hope you're okay. How was your week and how was your Easter? I hope you guys had a good weekend as well. Um, I know we said, and we did not do this on Thursday. Because jury instructions, yes, they are boring. They are the most boring thing. But because we can watch at 1.25 speed, because apparently it was rather interesting, because obviously Laurie did not know what she was doing. And they did discuss a bit of the next trial, so I thought that we could come in a bit early and hang out a little bit more. Because I've missed you. I am very thankful to Rubber for what she did on Friday, on Thursday. Was it Thursday? Yes, Thursday. I don't even know. That she spent the whole day with you guys watching the, well, newish trial. Um, but I really appreciate that. She's a great friend as well of the channel. Uh, and so really appreciate what she did at. And obviously, I didn't want to do instructions live because it's boring, but we can catch up on them. Oh, thanks, Seeking Justice. It's something that we've done since the beginning in the channel, and I love doing it. So, oh, nice. That is good, Maria. Like, I'm very glad that you had a good time, and spending time with family. It's always the best. Um, oh no, I'm so sorry, Stephanie. Are you sure it wasn't because it was the eve of 420? Wink, wink. I know, like when you're rushing around, it's like, what did I do? It's just complete. Oh, you're welcome to for you too, and a hug for you too, Maria. So yeah, so it was. I am like that as well. Sometimes when I'm in a rush, it's like, what did exactly did I do that day, or like. So I absolutely am the same. So I thought that we could start watching that. The jury instructions, like do the jury instructions very quickly for the Dingbell trial, Daybell trial, sorry, slipped there. Don't forget to play the verdict game to see. I think we're gonna have a verdict today. I don't know. I know the closings don't start until 1 o'clock. Trina said she was gonna take like an hour for her closings, Lori said it's not even that much, so she might see. Oh, ugh, she might take about half an hour, 40 minutes. So I don't know. I know. Talk about that. Oh, had enchiladas, not Lori's enchiladas, but the legit. Oh, I am very jealous about that, Maria. You that is good. I I don't think I am ever gonna try green chili enchiladas. I like the normal enchiladas. Hang on. Your prediction is guilty, Denise. Hang on, I'm writing it down. Denise, guilty 4 to 6 hours. All right. I will have a clock for when we're gonna go for the. Oh well, I hope to have. I haven't tested it out. I hope to have a clock. Otherwise, I will invent something. Um. Oh, okay. All right. No worries. But if you play in the verdict game and if you do want to do it on chat, tag me so I can see that yeah, something is coming up. So I was I was saying I don't think it's gonna like I was so an hour for trainers closings. Daybell should be about uh half an hour. She said not even an hour she was gonna take, and I don't think she is gonna take that long anyway. So I think we might have a couple of hours of verdict watch, but I don't know. What do you think? Do you think oh, guilty 1 hour, Zia. Nice. I'll put you down. Guilty an hour. I think she's gonna be quick. It's gonna be a quick verdict. I don't think we are gonna take much longer on verdict watch on this trial. You're in your pocket's watching, so your pocket is texting. Get you. Right. But so I don't think it's gonna be a long verdict. I mean, I'm not gonna lie, it would be nice to still have a little bit of verdict watch today because I mean we are not gonna be covering the Karen Ray trial. I don't know which trial we are gonna cover next. Um oh, you were in bed watching. We all in bed with Maria. Sorry, Maria, that was awkward. Joking, my friend. So oh no, what? You need to get up. It's still school holidays, I'm sure. It's still oh, it is bank holiday in England. So you still not have to go to work today. No, school is all it's closed. No? Maybe for us English. Well, I'm not English, but you know what I mean. So yeah, I don't think verdict is gonna be very long. So I'm just setting up this to see. I'm setting up. We are just gonna speed watch the jury instructions. Uh, yay! School is closed today. Whoop whoop party. Nice. Oh no, that is not good. No, no, not good. Not good. Um, so we are just gonna speed watch the
All right, we're on the record.
just gonna speed watch the jury instructions of the Lori Daybell case. We're not gonna be watching at real speed, real life, because we have no time for that. Nobody got time for that. They are boring as well. Hey, I know, Logan, than that you do, but thank you very much, Zizzy, for the support. You are an amazing friend. Thank you very much for your support and for your work for the channel and the support you give us every single day. And I really appreciate that. But thank you very much, everybody. So yeah, so let's watch. I think 1.25. It's speedy enough. So let's try that one. That speed.
All right, we're on the record on CR 2021-001704, State of Arizona versus Lori Daybell. The state is present, the defense is present, the jury is not present. This is the time set to discuss the final jury instructions. Let me confirm with the defendant that is it still your intention to not put on any evidence?
Right now, Your Honor, yes. As
Well-
of this morning, I mean.
Well, do you anticipate that changing?
No,
All right. Because that does affect how these instructions will be read to the jury. So for now, we're assuming you're not putting on any evidence. let's just go through page by page. I think it's probably the easiest way to do it. On the cover page, I did correct, I had 2001 instead of 2021, and I corrected the case number. The first instruction on the top page 2, duty of jury evidence to be considered and rulings of the court. These are standard instructions in Arizona. I'm assuming there's no objection to those from the state,
No objection.
from the defense?
On page 2?
Yes.
No, no objection.
All right. Then on page 3, I did remove the stipulations because I don't think there were any stipulations. So on page 3, direct and circumstantial evidence, production of witnesses and evidence, redacted exhibits, those are standard. Any objection to those from the state?
Your Honor, I did object to the production of witness and evidence.
I want to hear about that because that's a standard given when we have a situation where we've heard about people like JJ, Tylee, Alex Cox, we've heard about Summer, we've heard about Detective Moffitt. None of those people were called at trial. So I think this instruction simply says that neither side is required to call, basically everyone that's mentioned in the evidence.
Yes, as long as the defendant is okay with it. Obviously, I've not seen that previously included in an instruction. My concern was the burden shifting potentially, saying that neither side is required, and that seems to imply or in opposition of the fact that the defendant need not present anyone anyways, ever. That's my concern with that instruction.
All right, before we talk about that one, let me hear from the defendant. Any objection to the direct and circumstantial evidence and then the redacted exhibits on that page?
No, those are fine. Your
Okay,
Honor.
what are your thoughts on the production of witnesses and evidence?
I tend to agree with the prosecutor, but
That it shouldn't be in there?
correct.
Well, if the parties are stipulating that it's not in there, I'll remove it. Is that the case?
I believe so, Your Honor.
Yes, Your Honor.
All right, by the stipulation of the parties, I'll remove that instruction. I probably should have brought my hard copy because you guys are working off a hard copy on my computer. This is kind of maybe paginate different. So now my next ones are indictment is not evidence, self-represented defendant. Any objection to those from the state,
No, Your Honor.
from the defense?
No.
All right, then on the comments are not evidence. The reason I highlighted that is it was to alert everyone that I did change the language in that a little bit because the defendant's self-represented. It mirrors what I did in the opening, what I read to the jury before opening statements, more or less, in changing it from the attorneys to the prosecutor and the defendant talked to you about the law and the evidence. Are there any objections to that instruction from the state,
Not as changed, no, Your Honor.
from the defendant?
No, it's good.
All right, then we have credibility of witnesses, and on my page 4 is testimony of law enforcement officers, but that might be on your page 5. Any objection to those two from the state
No, Your Honor.
defense?
No objection to the ones that are in there.
All right, then we have expert witness. Any objection to that from the state,
No, Your Honor.
from the defense?
Nope.
All right, based on the defendant's indication that she's not going to be presenting evidence, I would remove defendant's testimony. I would keep in defendant need not testify, and I would remove defendant witness prior conviction if that remains the case. So any objection to that from the state,
No, Your Honor.
from the defendant?
Nope, no objection.
All right.
Can we add in there something?
What's
Is this the
that?
time to ask to add something in there?
Go ahead.
The standard 19, the defendant statement voluntary.
Voluntariness of defendant statements.
Mhm.
Right. That probably should be in there. What's the state's position?
No objection.
I will add that. I'll add that right after defendant need not testify. Just making a note. All right, then we have jury not to consider penalty. Any objection to that from the state?
No.
Defense?
Nope.
All right, the state email this morning, I think the state wants the alternative presumption of innocence, burden of proof in the Raji's. Is that correct?
Correct, Your Honor.
You want to make a record on that?
Your Honor, the current version the court has in here discusses the various levels of the burden of proof for preponderance and clear and convincing, which are not relevant to this. Case law is very clear under Portillo that the court is only required to present the Portillo instruction, which is partially on the next page in my hard copy. which explains to the jury the burden of proof for a criminal case. I think that going through other levels of burdens of proof without understanding or being provided context for that is confusing to the jury, is not necessary, and Portillo does not require it. So we're requesting the court just provide what has been mandated, which is the Portillo instruction.
What's the defendant's position?
We agree. It's confusing.
Okay. So I think that's just the last two paragraphs, right?
Yeah, from the three standards through the preponderance and the clear and convincing. So it would still have, the presumption of innocence, and then it would go to the beyond a reasonable doubts portion.
Okay, I will, by stipulation of the parties, change that instruction. So it'll read, the law does not require a defendant to prove innocence. Every defendant is presumed by law to be innocent. You must start with the presumption that the defendant is innocent. Then I delete until the last two paragraphs. So then it will read, the state has the burden of proving the defendant guilty beyond a reasonable doubt. The rest of that paragraph. And then the next paragraph, proof beyond a reasonable doubt is proof that leaves you firmly convinced, in that entire paragraph. Is that the agreement?
Yes, Your Honor.
Yes.
Okay. So my pages are not going to be the same as yours at this point. So we'll just go through it a couple at a time. Evidence of any kind, voluntary act, and then absence of other participant. Any objection to those three from the state?
Yes, Your Honor. And the evidence of any kind, I had sent in my email that we should remove acting with the advice of an attorney. Defendant is her own attorney, so she is. I think it should just be a period after evidence is left to the defendant, period.
You're right. I will remove that sentence. So what I would propose is it would read as follows. The state must prove guilt beyond a reasonable doubt based on the evidence. The defendant is not required to produce evidence of any kind. The defendant's decision not to produce any evidence is not evidence of guilt. Is that what the state requests?
I would have left the decision on whether to produce any evidence is left to the defendant, period. And then the next sentence, cutting out acting with the advice of an attorney, and then have the last complete sentence as well.
I don't have a problem with that. What's the defendant's position?
I agree.
You agree with the state's
I agree
wording?
with, yes, just to cut that part of the sentence off.
Okay. I already deleted it, so read it back to me, state, please.
Sure. So the state must prove guilt beyond a reasonable doubt based on the evidence. The defendant is not required to produce evidence of any kind. The decision on whether to produce any evidence is left to the defendant, period. Then the defendant's decision not to produce any evidence is not evidence of guilt.
So the decision on whether to produce any evidence is left to the defendant. Okay, when we're done, we're going to print out another copy and make sure everyone's on the same page. All right, let me turn to the defendant. We've addressed evidence of any kind. Any objection to voluntary act and absence of other participants?
No objection.
All right, then we have motive. Any objection to that from the state?
We did have flight or concealment in the ones that we
I'm
have.
sorry, you're right. I should have stated, I did delete flight or concealment. I don't think it's applicable in this particular set of circumstances. So then we just have motive.
No objection to motive, Your Honor.
And from the defendant?
Yeah, no objection to motive. No objection.
All right, here's where mine's going to change a little bit. I did the charged offense, each instance where it says first degree murder, where it used the numerical first, I changed to a capital spelled out the word first in that, and then in the definition of first degree premeditated murder. And the reason I highlighted in here, there's a couple highlights, a person, and under premeditation, she or a co-conspirator. Those are changes I made to the standard because the standard just says defendant. So let's just talk about the charged offense, the definition of conspiracy, the definition of first degree premeditated murder, and then the definition of premeditation. Any objection to those with the changes that I've stated from the state?
No, Your Honor.
From the defendant?
No, no objection to that.
All right, then where it's altered a little bit, so there was an accomplice based on liability, based on the result of the crime that I had here. I've deleted that and instead put accomplice, the traditional definition of accomplice, in the definitions section. And I think what I'm gonna have to do is we're gonna print out a fresh copy and give it to you guys when we get there. And what I've inserted here is elements of a conspiracy, scope of proof of conspiracy, proof of membership in conspiracy, which in my original draft only had the scope, I think, of proof of conspiracy in a different spot.
Correct.
But does the defendant need those printed out to review? Because I have
I was
changed
going to
it.
ask for those to be added, so I
Okay.
did review them with my advisory council.
All right, I want to make sure though that you are literally on the same page with what's going to be read.
Yeah,
So-
I would like them to be printed so I can see them.
All right. We'll come back to that when we get you a hard copy. What I wanted to ask the parties was I initially included the Raji 4.04 for self-defense justification. But in a second look this morning, I think 4.05, which is justification, self-defense, physical force, and it specifically talks more about threatening or using deadly physical force, I think is more applicable. So what's the state's position on that, inserting 4.05 in place of 4.04?
I would agree, Your Honor. This relies mostly on physical force. Obviously, we're discussing deadly physical force here. So otherwise, the jury has to try to implant deadly physical force throughout this entire instruction.
I think they should both be in, but
Well, while we're on the subject, are you requesting any other justification instructions?
well, I was going to ask for that for 2.04A.
For what?
The 2.04A, 2.0401A.
What's that? I don't have them all memorized.
Oh, the Arizona 13204.
Is that a Raji you're referencing or a,
Yes.
hold on, let me bring them up. What's it called?
It's the Cashion. Is that what that is?
So
I was on the wrong one. So we are going to be asking for those, but
I don't think I'm clear on what you're asking for.
so we were going to ask for the 4.06, the defense of third person, the 4.07, defense of premises, the 4.11, crime prevention,
What was the crime that was being prevented?
the assault on myself, on my daughter, on my brother.
Defense of third person, defense of premises, and defense of, or
The,
crime prevention,
correct.
in addition to justification, deadly physical force.
Correct.
All right, those get really convoluted and long, and there's a lot of repetitive information in those, but the case law says if there's even the slightest bit of evidence, then it's error for me to not give those. So what's the state's position?
Your Honor, I think understanding the case law, the defense of third party would be appropriate. The defense of premises,
I don't have it in front of me, but I think the defense of premises requires that the person be forcing in or trespassing.
correct,
On the
rather than
property.
being invited into the home. So I don't see that justification in defense of premises is appropriate, given the facts that we have here.
Let me look at it, because doesn't it also say or remain unlawfully if they were asked to leave?
I guess we have no, let's see.
There's no evidence of that specifically, but I guess it could be inferred, and I would hate to risk a reversal on something like that. So let me take a closer look at it.
I think the other question is on that, goes to then the lawful possession or control of the premises, given that Charles Vallow himself was paying for the premises, which we have admitted evidence of.
The evidence also admitted is that he flew into town and came over to that house, not living there at the time. So it does infer it as well.
Well, he's on the lease. That would seem to have some apparent authority to be there, but let me take a look at it.
It refers to criminal trespass, which I think the point here is you cannot be criminally trespassed off of your own property.
So I will give the 406, which is justification for defense of a third person. I'm not going to give justification in defense of premises. It requires that there be a criminal trespass. I think it's confusing to the jury also if there's an argument that's made that he committed a criminal trespass because he was on the lease, he had authority to be there, and he was, even if he didn't have authority to be there, he was invited in to get his son.
In lieu of that, Your Honor, then we would ask to add 418, 4.19, defensive residential structure.
Record on 4.11, which is use of force in crime prevention.
Sorry, I was looking at 418 that defense just raised. Let me go back to 411.
Skipping this part. Hang on, bear with me a moment.
To 418.
There you go.
Well, 418 it applies to home invasion type situations, and it talks about threatening or using deadly physical force. If the person against whom the physical force is threatened or used is in the process of unlawfully or forcefully entering or having unlawfully or forcefully entered a residential structure or occupied vehicle. So there's no indication that Charles forcefully entered the house. So I'm not inclined to give 418. Does the defense want to be heard further on that?
No, Your Honor.
And then was there another, you said after 418?
I just said 418 and 419. I guess that's the presumption of that.
Or, so 419. That's applied to the residential structure, so that one wouldn't be applicable if 418 is not applicable.
Okay.
So I'm not going to give 419. Did the state look at 411 yet?
Just found it, sorry. Your Honor, I think probably given Carson and the allegations that the victim used a bat, we would have to give that as well as then the instruction for the crime that they are indicating they believe Charles was committing, as is required per the
So you agree that 411 needs to be given? So that's my reading as well. So I will give 411, just so we're clear, I'm removing 404 self-defense justification. I'm adding in 405 self-defense justification, deadly physical force. I'm going to add in 406 defense of a third person. I'm going to add in 411 crime prevention. Okay, I think that brings us to the definitions. I removed deadly weapon. I think I had it in there initially because I thought it was in the justification statute, but closer read, it's not. So in the definitions that I have right now, I have intentionally with the intent to, and then intent may be inferred. Then I have knowingly, willfully, knew. And if the state is required to prove the defendant acted knowingly, that requirement is satisfied if the state proved the defendant acted intentionally. Then in the next paragraph, a defendant is criminally accountable for the conduct of another if the defendant is an accomplice of such other person in the commission of the offense, including any offense, and the rest of that paragraph. Any objection to those from the state,
No, Your Honor.
from the defense?
No, Your Honor.
And then here is where I've inserted the traditional definition of accomplice because I deleted the completed act definition of accomplice. So this says accomplice means a person who with the intent to promote or facilitate the commission of the offense does any of the following: 1, solicits or commands another person to commit the offense, or 2, aids, counsels, agrees to aid, or attempts to aid another person in planning or committing the offense, or 3, provides means or opportunity to another person to commit the offense. Any objection to that from the state,
No, Your Honor.
from the defense?
No, Your Honor.
Then I have a few more definitions: act, conduct, physical force, and a definition of deadly physical force. Any objection to those from the state?
You said something else I don't see in here, so sorry. Oh,
Act.
act was a previous page, sorry.
I kind of did it in alphabetical order. So accomplice went in, then act. So act, conduct, physical force, deadly physical force.
No objection.
From the defense?
No objection.
While we're in the definitions section, I'm going to have to look at when we're adding crime prevention and defense of a third party, whether there's any additional language in there that would require additional definitions. But other than that, are there any other definitions the state's requesting that I didn't include?
Other than, obviously, the state hasn't looked at either of those, either new instructions requested by the defense to see if there's additional information. So I would have to look at that prior to approving these.
Okay. But other than that, you don't have any that come to mind?
Not off the top of my head, Your Honor.
All right. How about from the defendant?
No, Your Honor.
So then the rest of this is pretty standard. It's the jury foreperson and the closing instruction, and then I have a form of verdict. Any corrections, objections to any of those from the state?
Just the form of verdict, changing that 1 ST as well to first degree.
Okay. There's no, we don't need any interrogatory on dangerous. It's automatic, right?
It would not be automatic.
It's
I don't
not.
believe so, because it does not require the use of a weapon. So we would actually need to have a penalty phase to
Okay,
have that
so
determination.
that would be done in the second phase, if there's a second phase.
Correct.
Okay. Let me turn to the defense. Those last, first of all, any other definitions that you think need to be included that I didn't include?
Hold on one second. Your Honor, we had missed one that we wanted added, was mistake of fact, 205. Sorry, I don't want to backtrack.
Oops. The revised jury instructions from 2 years ago don't have a 205.
Sorry, it's 204. I apologize.
Causation, ignorance of fact. Is that what you're talking about?
Correct.
2.0401A. Ignorance or a mistaken belief as to a matter of fact does not relieve a person of criminal liability unless, one, the ignorance or a mistaken belief as to a matter of fact negates the culpable mental state required for a commission of the offense, or two, the ignorance or a mistaken belief as to the matter of fact establishes a defense of justification. So what's the mistake of fact that you think exists?
Your Honor, it's mostly the mistaken of fact that have been presented as evidence in this case, like one shot versus two shot. You were being attacked, you weren't being attacked. It's things that the state is proposing that I'm denying.
Well, you can deny those and you can argue that, but that's not really what is meant by a mistake of fact. It refers to a misunderstanding of the facts that would somehow negate any criminal liability. In other words, you have to be under a false belief about a fact. I think an example might be if someone's breaking into your home or someone's coming into your home, you thought it was a burglar and you shoot them and it turns out to be your spouse. That might be a mistake of fact. So a dispute as to what the facts are, what the facts mean, wouldn't warrant this instruction unless you have something else.
That was all. That was what I was thinking.
Okay. What I think I'm going to do is I have to go back to my office in the central courthouse. I have to edit this a little bit. I'll add in those instructions. If you guys can wait here, we'll get you a clean copy by noon. Review that copy over the weekend, make sure there's no other additions, corrections, or mistakes. And then the procedure will be on Monday. When the jury comes in, I'm going to ask if the defendant's ready to proceed, and I'm assuming you're going to say that the defense rests. And when that happens, we'll hand out the final instructions, and I'll read the final instructions, and we'll go right into the closing arguments.
Your Honor, then I'd asked defense previously, there are officers who are under subpoena still, that they be released at this point?
That's fine, Your Honor.
All right. And well, anyone at this point can be released from your subpoenas. Is that correct?
That's correct.
Okay. I'm just trying to decide the best start time. I'm thinking read the instructions at about 11, break for lunch, and go into the openings early at 1, or you can start and have it broken up by lunch.
I would prefer the court's option of reading the instructions, going for an early lunch, and then not having my
All right.
closing.
I'll have my staff contact the jury and tell them to report at 11. And then we'll still meet here at 10:30, make sure everything's good on the instructions and the defendant's intentions to rest. And then I'll read the instructions before lunch. That may mean we break a few minutes early for lunch, but we'll have them come back at 1 and go into the closing arguments. You have the second case.
It's up to you.
All right, while we're here, I'm going to call the other case as well, CR 2022-001242. And the state is here, the defendant's here. I'm going to go ahead and set the official trial date to begin May 30th at 9:30 a.m. Actually, 10 a.m., May 30th at 10 a.m.
Your Honor, are we still meeting though the 29th to do strikes?
Yes, I'm going to get to that. I will set a final trial management conference to discuss the remote questionnaire and confirm we're all good to go for the second trial. for May 14 at 10 a.m.
And Your Honor, I will say okay for now. Obviously, we don't have the victim here and we didn't notify him of this hearing. So if that does not work for him, then I will ask to move that.
Right. For now, we're setting the final trial management conference May 14 at 10 a.m. At that time, we'll discuss modifications, if any, to the previous questionnaire. We'll discuss the exact timing of that questionnaire going out, but it'll go out probably May 21st and end sometime on May 26th or 27th, because the 26th is a holiday. And then we will meet on May 29th to go over those responses that the remote questionnaire produces. I'm going to set that for 1 p.m. on May 29th.
Your Honor, I received a notice from the state this morning, actually, about notice of 404B information for that trial. So are we going to set a 404B hearing for that as well? Would that be at the same time, or do you want to do that at a different time?
Let's discuss that on the 14th.
Okay.
I did see that come in as well a couple of days ago. So the anticipated schedule for trial, let me confirm with the state. You think the second trial is similar in length to this trial?
I believe so.
So my proposed trial schedule that we talk about is going to be June 2nd, Monday through Friday, June 6th. We'll shore up those hours and where we're going to be physically located, because I don't know if we're going to be in the same courtroom or not. But tentative schedule, June 2nd through 6th, Monday through Friday, June 9th through 13th. Depending on how far we get, I may cancel that Friday the 13th, but I'll let you know at the start of the 9th or the 10th. And then I have to be dark the 16th through the 20th. And if we need June 23rd through 25th, I think that should be enough time. So that's what I'm going to screen through, is those dates for the remote questionnaire.
Not the next June, you said June 23rd through the 26th, but not the 30th through the 3rd?
Yeah, and here's why I'm thinking that is you completed the state's case in this case in
It'll be
7 trial days, 7.5 trial days, 8 trial days. And the 2nd through the 12th is already going to be 9 trial days. And then if something goes wrong, we still have the 23rd, 24th, and 25th. So that's going to be 12 trial days. And some of those trial days I can make longer depending on everyone's schedule. We might be able to start earlier.
All right. The state will ask that we screen them through July 3rd. I just think there is always things that happen, and I would much rather have a jury prepared to stay longer and have them end late than have a jury angry at us because we told them that they would be done on the 25th and something happens and they are not done on that date, or they're deliberating later. So I would ask they be screened through July 3rd.
11, 12, 13. That would give us over twice as many trial days as we had in this trial.
We had screened these through the 15th, I thought, of June. So
What's that?
didn't we screen these jurors through the 15th of June? So
No, May.
I'm sorry, of May. So
We screened for 6 weeks and we did it in 2.
I understand, but I guess I don't see that as twice as long as this screening.
We had 21 trial days scheduled in this first trial, and you did it in 7.
We had 28 days scheduled in the other one. In any case, that's all I'm asking, Your Honor. You can do as you wish. That's my proposal.
We can confirm it on the May 14th when we meet at the FTMC. I'm open to it. My hesitation is if we go all the way into the 3rd, I think we're going to run into losing a bunch of jurors who are going to go out of town for 4th of July, and they might be leaving on the 2nd or the 3rd. And I think we're going to lose a lot of jurors just based on that holiday where people go out of town. With that said, the current last day is May 11 on that trial. So as defendant, want to make a record because I am going to exclude time. I know you object to the exclusion of time.
I object to not having it by May 11th. Correct.
You want to?
What?
Do you have anything further than that?
No, just that, yes, that I would like to have my speedy trial by May 11th.
All right. Well, we screened the first trial through May 15th. You can't do, and the state can't do, and I can't do 2 trials at the same time. Additionally, the state indicated they need to make arrangements for out-of-state witnesses to come well in advance of the trial. There's scheduling issues for myself. I'm out part of the week of May 19th. I'm out and coming back early the week of May 26th to do jury selection. Additionally, I guess the delay is of minimal prejudice given the current sentences that you're serving. For all those reasons, the court will exclude time from May 11th. The new last day will be June 30th. All right, let me get these jury instructions, an up-to-date draft for everyone. Please stick around. I'll have my staff drop that off hopefully in the next 15 to 20 minutes. And then again, when you review those over the weekend, please alert staff through your advisory council or your paralegal if there's an issue, because we're gonna have those all printed out Monday morning if we don't hear from anyone by about 10 a.m. Again, we'll ask my staff to contact the jurors and have the jurors report for 11 a.m. on Monday.
And Judge, is the court able to just email those to me, or do you want me to stay here and wait to get a hard copy?
I will email them to you and advisory council and the paralegal, but if you want, you want a
I'll
copy?
wait for a hard copy.
Yeah, I'll print out a hard copy for the defendant to take with her here today.
Thank you. Thank you, Your Honor.
All right. Are you signed up for that? Okay. All right, thank you.
All right, so that was the jury instructions, speed version of the Lori Daybell case. So it literally took us what, half an hour to do it about the same time. Like, well, not that much. Oh, sorry, I meant to remove. So it's no, saying she's gonna still be pro se, Maria. So same attorney for the prosecution, same attorney for the defense, same judge, different jury, different victim. That's the only two things they are gonna be different. It's going to be the victim and the jury. Pretty much the same is gonna remain. So what's for lunch? Well, Paula, Garden Bud does need to go make dinner because it's almost dinner dinner time here. Well, it's already past dinner time in England, but yeah, so it's gonna be c'est tout le même cause. It's gonna be all the same thing in the second trial. That's why I like in terms of coverage, I'm not gonna cover the second trial. First of all, because of the time difference. Second of all, because it's gonna be exactly the same circus of things. So it's gonna be the same. Definitely, I like that, clown Zizzy. Oh, it's 12 there. Nice. Definitely lunchtime. You had a caprese potato salad. Oh, that sounds very nice, Zizzy. Oh, by the way, I replied to your email. My apologies. My email decided to log myself out, so I could not see it. So, but I saw it. Thank you very much. I did a reply back. But yeah, sorry, my phone battery is dying already again. That sounds very nice. I think we're gonna have like a bolognese style food for dinner, which I might have to have while, or maybe just in the bed, because court is about to start. Court starts in about 10 minutes, I think. I think court starts in about 10 minutes with the half an hour delay. I think. I'm not sure. It might only start in an hour. I don't know. So I am gonna scour to see what we can do. Meanwhile, we can talk someone if you wanna come and talk to us, you are more than welcome. Otherwise, I'm just gonna find something else to for us to watch, because I was scouring the yeah, no, it doesn't look like he's making dinner, does it? He's just right behind me. I think we are full swing on searching for a house. We are starting to look for houses and everything, because that's one thing we want to accomplish this year. He is very comfortable, and I'm glad that he's comfortable. He's enjoying his time, even though he still has plenty of work to do, sadly. Which I know we are very excited. It's a big grown-up decision, and a very big decision indeed. But we are excited. It's very. But my days, it is a lot of work, like looking at mortgages, reading like the little letters that they have and everything. So yeah, there's a lot going on. New baby, new home. Well, not my baby, but still, I still love her. But it's very, very exciting things happening for sure. Um, but and I can't wait. We're trying to make year 2025 to be a good year. Our channel, our community is growing, which is also amazing. Oh yes, indeed, Maria, always. That's where they get you. It's in the fine print. That is for sure. So definitely doing that. And it's the one thing that both me and Garden Bot we like to do. It's read the um read the fine print. So I'm just scared to see. Oh, by the way, I keep forgetting that if you have any suggestions for our next trial, just let me know. What would you like to cover apart from Karen Reid? Obviously. But also I was asking, is um so after Lori gets found guilty, right? Um does Arizona has penalty phase? Because I was thinking that, like, do they have straight away a penalty phase, or is it like a normal sentencing that she gets? Because I'm just like really interested to find out if it is that or not, because that would be very, very good to know, because that will affect what we watch next. But I mean, penalty phase, we know that she's gonna get. Is she facing life again in Arizona? Because it's a conspiracy. So it is it. One, one second. Because I was just a bit interested that if it is conspiracy theory or not, or a life sentence or not. So yeah, sorry, just looking for some. Oh, I know. I think I saw a video that gives a bit. Where is it? Now we're gonna probably catch up on the our trial. Do you want to carry on watching the other trial that we started on Thursday with Rubber? Kind of, because we could skip to the moment that the guy testified. Not today, obviously. I'm not talking today. I'm talking when we don't have a trial or we are in between trials. We can catch up on the other trial, but watch the other guy testifying. I forgot his name. Morales. That's his name. We can watch him testify, because he testified in his trial. But I don't think I'm gonna count him for our statistic, because I don't know what you guys feel. Let me know. Like, literally, you need to tell me what you feel. If we should count him, we should not count him. Should we just do him as a normal trial and then we can count him? Because I don't know what the rules are. I know I did the rules, but literally I don't know. It's complete complicated. I'm just trying to see if we can find something to watch while we are waiting for the closings. Well, it's not going to be closing straight away. It's going to be jury instructions, which gonna be a little bit boring. I'm not gonna lie, since and sadly we cannot speed watch that either. Um, and then we're gonna go for lunch, which is gonna be interesting. It's gonna be quick, and then after lunch we're gonna get closings from the state and then from the lorry, and then we're gonna go on verdict watch, which is crazy. Um, I don't. Oh, hang on. I no, sorry. I just. I know the instructions are boring. I wish we could kind of skip it. We can skip it, but um, I don't know. I don't know. It's just I'm not sure if what we could watch instead. We could watch the Morales testimony while we are on it. I could find out how long it is, and then we could come back from from uh, lunch and go to closings. I don't know what you guys think. Do you want to skip instructions on her, on Lori Vallow, and do the testimony of Jose Morales from the bathtub trial, and then after lunch we could just do the closings, because we could do that. That's literally very easy to do. I could find where that is, which day did it testify, and then we could just watch that, and then it would be rather quick catching up on that trial then. I think he did. I don't know. I need to I need to find it when he did testify. Because we did the first 4 days. We were about to go on the fifth day. I don't know. Does anyone know if when he testified? I think it was the 8th. Let me have a look. I can actually have a look now. No, that's still, yep, that's still not him. That's lunch. I think that's an investigator. Yeah. Okay. I absolutely agree. Yeah. Okay, Maria. Thank you very much. Yeah. No to Jose statistics. Yeah, because it's been more like a time filler, if you know what I mean. So, oh, it's in a sentencing hearing gives the punishment. Oh, okay, cool. Awesome. That's fantastic to know. That is great to know. Thank you very much, Zizi. I really appreciate you. That will be good. That's good to know. So I'm trying to find where does he testify, because I know he testified for quite a while. That court did definitely took a lot of breaks. So here you go. He testified on day 8, on the start of day 8. Not on start on day 8, like nearly halfway through the okay. Awesome. Okay, good. All right. We'll follow that, the hearing, the scheduled hearing. That's good. That's good to know. That is great to know. So we will do that. Obviously we'll see the sentencing hearing for her. I think we have one coming up. I need to look at the calendar, because I think we have a sentencing hearing coming up or not. I don't know. I don't remember really if we do or not, but I think we do. Like Jason Levesque, I think it's in June or July, so it's not yet. Nicole Rice was found not guilty, so she doesn't have a sentencing. Like that's what I'm thinking. Oh wait, yes we do. What's her name? Linda. Linda is in May. I need to find the date. I forgot the date already. I need to find the date for Linda Stammer. Linda Stammer, that's her. I think it's in May something. I need. See, this is why I need a calendar in front of me. Linda Stammer sentencing day. I think it's in May at some point. Linda Stammer sentencing. Need to look for that. I did not put the dates on the spreadsheet, sadly, but that could be an idea, actually, Zizi, to put the calendar dates of the sentencings in the spreadsheet, and then I can just delete when it's already happening. That is a great idea, actually. Thank you for that. I appreciate it. I will implement that. Thank you. But talking about May, I actually need to see. I might have to ask for Robert or Zia to cover me, because I have a few days off booked. Oh, May 19th, actually. Awesome. Oh, Josh, thank you. Wait, thank you, Zizzy. Josh, I really appreciate for the idea, but I've got it. We've got one, very detailed indeed, of a spreadsheet with all the cases that we've been following. Really appreciate that, friend. Thank you. But yes, spreadsheet is my zone, my side of things. Thank you, Denise. Appreciate that. And Stephanie as well. See, you guys are on a ball. I appreciate you guys. Yeah, we do, and it's actually quite detailed. Which I know we're not gonna put the Jose Morales case on there, but we could have had a new state. But we'll get Connecticut again. Don't worry, we'll be fine. I'm sure we're gonna get another case from there. 11 a.m. Eastern. Oh, Zizi, that is amazing. 19th of May, 11 a.m. That is great. I'll be back because the only 2 days that I'm gonna miss is the 15th. I think it's the 15th and the 16th of um May. Me and Garden Bot, we have a concert booked, which is very exciting. And then we're gonna stay over where the concert is, which is gonna be amazing. But if we are in the middle of a trial, obviously our friends Zio and Robert, they might cover. Hopefully. I'm already asking them over on stream, but I'll still talk to them. But if they are okay, they will. But if we're not on trial, well, we all have a day off from TCA. Sorry, I've heard my phone buzzed, but uh, so yeah, so that's the plan. But mine's still, well, it's not that far away. It's just around the corner. Um, but it's very close, and I don't even know which case it is going to be our next case. I have a couple possibilities looking, but I just need to make sure that there's going to be a feed in the court docket. They say they have been approved for media, so don't know. They might have media, we might not have media. We'll see what happens, and yeah, and then we'll see. Sorry, give me just 1 second. Oh, nice. So yeah, so new question, since everybody's here. Do you want to watch the jury instructions for Lori Vallow, or just the closings after lunch? And between now and after lunch, which is still a couple of hours, we can watch the testimony of Jose Morales on the other case we were watching the other day. So I'm gonna do a poll. That's probably easier. Hang on. What to do? What to do? Because jury instructions. Do I even know how to spell new instructions? Lori or Jose Morales testimony. I probably is gonna have a lot of misspells, but ignore myself. Oops, apologies for that. Card and bot. Oh, thank you. I appreciate that. Um, I will mark you down for no. Don't worry. Okay. So I'll put you down for Jose Morales for the testimony. We'll see what we do, because I know that jury instructions is, yeah. Ooh, May 27th, SARS in Milwaukee County. Oh. Ooh, Stephanie, we might need to talk then. We might need to talk, my friend. By audio, we can add things survive. We need to talk, girl. Oh, you know how to DM me. You can DM me, and we need to talk then. Absolutely. Talk to me. Definitely. Talk to me. Definitely talk to me, and it's very exciting. We might have our first boots on the ground. Uh so definitely. Oh wow, yeah. I know that's definitely. I think Stephanie already spoke to me about it before, but I completely forgot when it was supposed to be. But um, maybe they've improved it to it. Do you think? Do you think they could have improved for the case? I mean, we can always see, and if it is very horrible, we might jump and just hear from your side of things, and we'll see what to do. But definitely, that's a very high possibility. And Milwaukee, it's a very good time zone. It's perfect time zone. Does that give us a new state? I'm obsessed. So, um, what have I been doing? Well, we've watched the instructions for Daybell, sorry, and now we are deciding to what to do. Deciding to see if we're gonna do the Jose Morales testimony while the the thing the jury instructions are going, because we all hate instructions, is they are too boring, and then just watch the closings. So I'm sure they will. So I'm sure they will. I know the Darrow sounded very, very good. It was very good. The courtroom. I love that. Um, I don't, I don't think we have one on the spreadsheet. Wisconsin. Let me have a look. Let me open the spreadsheet. 1 second. Um, so and I've been talking as well, Zio. You know how I talk, like there's no end. So oh, hi KM, good morning. Oh, thank you, appreciate that, girl. Thank you very much. You guys are so, yes, I know, but I didn't never put him on the books, on the thing. Oh no, Wisconsin is not on the list, guys. So no, we could. So um we definitely could put I mean, we never really finished Daryl. I know we did him. That sounded bad. That sounded bad. It's different county. Well, hopefully it will be okay. Uh Fingers crossed that there will be a miracle and they will replace their sound system, Stephanie. Hopefully. Otherwise, we can just have to connect your phone to the system and give us a better sound. So, yeah. Um, yeah. Oh, yeah. Oh, no. It's absolutely okay, case one. I understand. I can name better as Dingbell. I like it too, so definitely. Oh, you have to us lunchtime, definitely. Okay, back to pocket. I should be back soon as I can. Good. Okay. All right, Zay. I'll see you soon, friend. Make a Stein's trial. I think they will stream it because it's a very high profile case. Kentucky does sometimes stream cases, so um will so yeah, so it's, I don't think it's federal yet, Maria. Zizi, sorry, I don't think it's federal yet. It might get upgraded federal, like the Luigi Manzioni got an upgrade to federal, but exactly, we'll see what we have to do and what we can do, Stephanie. Definitely, I really want to watch it as well. They did had a hearing scheduled for soon, um but definitely that's an eye, but I don't think it's gonna be just yet. I think it's gonna be, I think, in 2026, that case, the Mickey Steins one, because considering it just happened in 24, normally they take about 2 years to go on trial if they waive the speedy trial. So we'll see. Um, yeah, the P trial. If it was federal, they would, exactly. You are correct. If it was federal, they wouldn't have shown, and they did show the probable cause one. They showed the pre-trial, and all the hearings have been going on. Has actually been, well, either streamed or recorded. But I think because of the media attention that case is gonna get, I'm sure it's gonna be covered somehow, um, into the trial. But I don't know what to do, guys. In a way, I don't want to watch the Lori Vallow instructions. We'll watch the, right. Okay, we'll watch the Jose Morales testimony until Lori Vallow is back from jury instructions for after lunch. I'll keep the feed on my phone. Anything that happens to this spicy, I'll move it. um Yes, I think many people will saw that video, definitely. Oh yeah, I know, never. Oh, is it? Oh, Ouch, I did not know about that development, Zizzy. Thank you very much for keeping us informed. I did not know about that. That could give definitely a different spin on the case even. Oh man, that's gonna be such a good case. Well, I guess we're gonna have to see what happens. So like I was saying, we're gonna do the Jose Morales testimony while the jury instructions are ongoing, and then join Vallow for the closings. So that's what we're gonna do. um because it's boring, jury instructions are boring, but I mean, since we are so close, hang on, where are we? I just want to see if Lori will rest. If she rests, we're gonna go back to Jose Morales. If she changes her mind, we'll say obviously. So yes, thank you very much, Denise. I just was just saying that. Thank you. I appreciate it. Thank you very much for keeping me right, and I appreciate you always. We definitely need to make sure Lori did not change her mind. Yeah, definitely we're gonna have to do that. Thank you very much for reminding me of that, and we have exactly the same idea at the same time. Oh, so yes, please, we definitely need to to hear her rest. I agree. Oh, hello, Plum Awesome Puce. Hello, good to see you. Hello, good morning, afternoon, good evening. Hi, so good to see you, my friend. So good to see you here. Um, oh, you were doing the dishes. Do you want to come over and do ours, Denise? Cutie Pie will enjoy that you are, to do some. So yeah, so we're gonna just wait a couple minutes until they actually come, and we're gonna hear Lori Vallow rest. If she does rest, we are gonna stay for there and watch the Jose Morales um testimony, because jury instructions are not interesting at all. So we'll our plan is to jump on that and go to him for the remainder of time until closing starts. So yeah, so we'll definitely do that, and it's going to be the plan. And then um oh, I thank you. I say Jose like I say it in Portuguese, but I need to learn to say like that. Jose. My apologies. I do say it. Yeah, that's. Oh, I absolutely agree. Case one, time zones. This time zones are definitely as well messing with me. I'm like bored because I got home from having some cuddles with the baby, and I came home and I was like, oh, okay, like need to get ready for streaming, and it was like only 2 p.m. for me, and I was like, okay, I still have a few hours to wait, which is like I am bored now. I want to get on with it. I want to stream. I miss you guys. So I was just like, oh no, I can't. I was like not doing much, and then I was just like, okay, now I am chilling, I'm relaxing, watching a bit of a show and everything, and then I watch, oh no, I have to stream. I'm very happy that I get to do it, but I was like, no, I was relaxing. I have to actually do something. I don't mind so much the late nights. Well, to be fair, we haven't had that many anyway, I don't think. Oh, we have a feet. We have some movement, indeed. Um, Oh, oh, I know. I'm so sorry. It's the time difference, and indeed that time delay as well is hard. Um, the it's Arizona is already bad enough for time difference for me, at least. So, and it's just the delay and then the time zone. Those two things combined, it's not good. But at least I am glad that before they come, very quickly, Verdict is only going
All
to be
right, we're on the
5
record,
minutes
State of
delay.
Arizona versus Lori Daybell, CR 2021-001704. Why don't I have the state announce? And the defendant?
Lori Daybell?
All right, we met on Thursday and went over jury instructions. In the meantime, since Thursday, there was a few modifications sent out. We put drafts on your desk this morning. Last week, let me just pull up that email. Last week, the state requested some modifications that were made, and then on Friday, Advisory Council also requested a correction to the presumption of innocence, which I did do, as well as a mere presence instruction. Does anyone want to make a record on any of those changes that have occurred since we met Thursday? I forgot, I don't know if my staff told you, I did add, I realized standard number 9 was not added, which is defendant need not produce evidence. So I added that this morning as well. Have you had a chance to review the latest draft, or do you need more time? We told the jurors to be here at 11, so we have time if you need more time. Any other record you want to make on mere presence? All right, has the defendant had a chance to review the final instructions?
Yes, Your Honor.
Any additions or corrections?
No, Your Honor.
All right, we're still waiting for a few jurors to show up. The plan this morning, well, let me ask the defendant, you still plan on resting?
I do.
Okay, so when the jury comes in, I'll remind them that the state rested last Wednesday, and then I'll turn to you and you'll presumably say the defense rests. I'll read the jury instructions and we will break after I read the jury instructions. Depending on what time we break, I'll tell them what time to come back for the closing arguments, approximately an hour later or around 1 p.m. While we're waiting, I had my staff email the parties about any potential aggravators. I didn't see a response to that. So in addition to, if there is a second phase of this trial for aggravation, in addition to a dangerous finding, does the state know what other aggravators it might be pursuing?
Potentially the emotional harm.
Anything else?
The presence of an accomplice.
Okay. And in the event that happens, would you be producing testimony or evidence, or would it just be argument?
Potentially testimony from Mexican.
Okay. All right. So how many jurors? You can go ahead and print out.
Your Honor, I have two issues I'd like to bring up real quick.
Go ahead.
The jury process of the jury alternate selection. Can you tell me what that process is going to be today?
It's literally drawing two numbers randomly out of a container.
Okay. And when is that going to be done and how does that
Not
work?
till after the closing arguments.
Okay.
So the alternates are told that they're still alternates, they're not released, because I have had in the past jurors become sick or ill or not be able to deliberate, and we have to call back an alternate to deliberate. So they're still under the admonition until they're released.
So we're keeping all of them, basically.
But only 12 will go back and deliberate.
Okay.
If one of those 12 becomes sick or is unable to deliberate, we would bring in an alternate and release the person that can't deliberate. Does that make sense?
Yes.
All right, what else?
So it came to my attention this weekend that the exhibit number 286 that the state put into evidence that Detective Inkland testified to was the full interview is only about 21 minutes long, and the actual interview is about 55 minutes long.
Remind me, what's 286 is, whose interview?
It's my interview, I guess, with Detective Inkland.
I think that's been redacted because the full interview wouldn't be admitted into evidence for the jury to review. Is that correct?
Correct.
All right.
So is it just the snippets that were played all together?
It should just be the parts that were played in court. Is that correct?
Yes, I mean, they're all connected.
All right.
The state redacted out the beginning, the end discussions of Tylee. That would be hearsay or not.
Right. So did you have a question about that?
Yes. So is it just the snippets all put together, or is it the interview for the first 21 minutes?
I think it's just the snippets that were played in court that are put together as one exhibit.
There's connectors in all of it, but it does not include any of the beginning or the end of the interview.
Right, portions have been redacted out. But it's just more or less what was played during testimony.
Correct.
Does that answer your question?
Kind of, but Detective Inkland testified that it was the full interview. So what does that mean if she's testified that it was the full interview?
I don't know. It's something you could have cross-examined her on, but now it's probably too late. If you wanted clarification on that, but the jury is going to know it's redacted, and they get the redacted exhibits instruction as part of the instructions. So either side can point that out to the jury that it's redacted. Anything else?
I was just assuming that that might have been an error to say that it was the full interview when it wasn't the full interview, and it was admitted into to reflect the record that it was the full interview. So are you telling me that the jury is not going to be able to go back and watch the full thing?
Your full interview?
Correct.
No, because it was never admitted into evidence.
But that's what they said was admitted into evidence.
I don't remember if that's what was said or not. I would be surprised if someone said your entire interview was being admitted, but I don't remember the
Well,
exact
my advisory
testimony.
council checked the FTR, and that's exactly what was said. That was exactly what I was shown, that it said, is this the full interview? Yes, this is the full interview, and it was admitted into evidence.
Was
So-
there sometimes they enter in the full interview for appeal purposes only, but that's not the one that actually gets shown to the jury. Was that the case?
Was not for appellate.
Okay.
The full interview, the defendant talks to the detective in the beginning about Tylee, does not include that. She talks to the detective at the end about Tylee and victim services. It doesn't include any of that. She's sitting in a room for review about what happened.
Okay. So the state's closed their evidence.
I'm just trying to find out what the jury is going to be seeing. They have all that evidence in the evidence when they deliberate. Is that correct? They
Whatever
have
was,
access to that.
whatever was admitted into evidence, which portions of your interview were not admitted into evidence, it sounds like.
Okay, but from what I'm understanding from the state, just correct me if I'm wrong, it's not just the snippets that were played, but it's a partial part of the interview and some of it was redacted. Is that correct?
That's what I'm understanding. The parts regarding what Tylee said or did or didn't happen, the hearsay parts were the start and the end were redacted out.
And then what was meant by the testimony that this is the full interview?
I don't know. I guess that's something that someone could have asked that witness. Maybe it was the full interview of your version of what happened.
So we have
There.
our exhibit 20, the defense's proposed exhibit 20 is the full interview. Can we replace that one with the full interview since it was entered into evidence as the full interview?
No,
Why not?
your full interview won't come in because it's a significant amount of hearsay within that interview that's not admissible evidence.
It was admitted as the full interview.
Well, if a witness testified that it was a full interview, either side could have clarified that with that witness. I don't know what that witness meant when they said that. Anything else?
That's it.
All right, we're getting the sufficient number of the jury instructions copied. As soon as that's done and our jurors get here, we'll read those instructions. All right.
Oh wow. Oh wow. Yeah, I know. She's making her case now. Like too late, Lori. You said you were gonna rest. So this is absolutely bonkers. I know. That's why I stayed a little bit longer. Because I was getting notifications and I was like, okay, this is gonna be good. Good morning, Nancy. Hi. Hello, good morning. I know it's like Lori, move on, girl. It's just like you had a time. You had your time. You lost it. It's my days. This is crazy. She's absolutely crazy. Right now, I want to see at what time did. All right, we are on a 5 minute delay. I don't know why. I don't think this is good, guys, but this is not good. We are on a 5 minute delay because you know that we are on a normal half an hour delay, right? On this court, on this trial. And for closings, we're still supposed to be on a 30 minute delay. But somehow we are on a 5 because 5 minutes ago, someone is in a courtroom, right? But that now we wait for the jurors to report. Um and that was 5 minutes ago, and that's already happened for yourself. So yeah, yep, indeed. Remember, definitely, indeed, Zizzy. We are on a 5 minute delay for verdict. I thought that we are going to be on a 30 minute delay for the closings. So yes, Paul, I do have the link. The link should be posted soon anyway, but I can get you the link and post the link there. So yeah, I don't know if it is like a moment or if we are correct, but so see, there you go. Thank you very much, Zizi, for doing that as well. But play the verdict game. There's the link there. I already have some of them written down. So just to know what you think of play the verdict. It's a fun game that we like to play in here in the channel to see who's wrong. And of course, I'm always wrong. That is always. No. You don't have to go to the link. If you want to say in the chat, you can say in the chat. Just make sure you tag me in it so I can see it. because sometimes chat goes a bit quick and I don't see it and I don't want to miss it. So just make sure you tag me in the chat and so I can see it. So you don't need to play on them on the form. So yes, I have already yours. Yes, I do have, Maria. I have it. Yes, indeed, I do. I've got yours. So yeah, so you can play. So now I no well, probably that is a the good thinking, Denise. That is a good thinking. You know that the judge might have changed his mind on delay, but we still are on like at least 5 minute delay, which is not bad. It's better. Could have been worse. Um, you know, you could still say the 30 minutes including the verdict. I think that would spoil a lot for a lot of people because as soon as that verdict is gonna come in, at least tweet X or whatever you want to call it, it is gonna blow up with everyone tweeting about it. So I still want to kind of hang out a little bit just to see Lori saying that she's resting, or you guys are okay to move on now? Because she's not gonna change her mind. I don't think she's gonna change her mind between now and then. But just to keep a bow on her case, we could just hang on for a minute and see. Well, I don't think she's gonna change her mind. So stay. It's okay. We'll stay. We'll stay. Don't worry. We'll stay. Yeah, we wait for the bout. That yes, agreed. I absolutely agree. Um, so definitely someone could call. Hang on, I need to find the link. Um, if Denise calls, she's gonna tell me off for something. Not to obviously spoil anything, but she's always tells me off when she comes up. No, I'm joking. I mean, just make sure you can call. It's free. It's over the internet. So the only thing that you're using is internet. You don't need to have your camera on. You can just have audio. It's absolutely fine. If you feel comfortable, you just can have the audio. It's no obligation. But you can chat with me and chat with the chat. But before we do, like if someone calls and before like if someone calls, I want to show you a picture that I have made my screen my oh, thank you, Nightbot. You're a little bit late with that. So my screen wallpaper now. It's got I got a notification. Hang on, let me swipe that across so it's not a spoiler. So that's Garden Bot, and that's my little niece. Look at that gorgeousness. So that's my little niece. Oh, my little niece and Garden Bot holding sick. So that's my wallpaper now. I absolutely love this picture. It is my home screen now because it's I know as it's she's gorgeous. I am a very proud auntie and she's only like 4 days old. But she is gorgeous. Yes, I think it's Anya. I will spell her name. And Maria, I now remember the way I say the name of the defendant of the trial that we've been catching up, right? Oh, hello, Garden Bot. Good morning, good afternoon, good evening to you. Good morning, hello. Um, I am. Oh, thank you very much, William. I absolutely it's been already been spoiling, and she's only 4 days old. It is not gonna my wallet is gonna suffer. But it's okay. She deserves it. I was gonna say the way that I say the name of the defendant of the trial we've been catching up, I say it in a Portuguese way. I say it José. I know you guys say Jose, and I will try to say it like that, but I say it Jose. But I will try to say it the proper way that you guys say Jose, and I just need to get that inside of my mind. But yeah, thank you very much. We appreciate that. I think he's eating dinner because dinner is ready. I've just been waiting for court to start. because I want to hear the. I thank you, Sherry. I really really appreciate that. Um, appreciate that. Oh, I know, but it's just yeah. Just oops. Hello. Hello, Stephanie. You forgot the wave to garden bot. Oh, thank you. I appreciate it. I can say both. Jose. Oh, I forgot already. I am. Uncle Bot. Oh, that is a great name, Uncle Bot. Yes, it's the best comment, definitely. Uncle Bot. Oh, that is not gonna get complicated. I think we need to change his name from Garden Bot to Uncle Bot now. He has been promoted. Oh yeah, definitely. It's just because it's the accent or just how the name is said as well. So yeah, I know. I like Uncle Bot. I think we should change his name, Crunklebot. Crunklebot. That is ah, I appreciate that, Stephanie. Um William Uncle. I think Uncle. Yeah. Oh, Brazilian Maria. Brazilian names are the wildest names that could there be ever be. Sometimes they go grab the most oh, Denise. Thank you, baby spoiling fun. Thank you. I will definitely get Anya something from that, and I will definitely tell her that it's from Auntie Denise, Auntie D from America. I've already told her that she's already had a lot of people, you know, uh, saying congratulations and saying that she's the cutest baby ever. Thank you very much. I really really appreciate it. She's definitely gonna be spoiled. That girl has no chance with me. Oh, hang on. What happened there? Oh, the feed just went down. So Nemo, yes, definitely. That's also her and the nickname, her Nemo. Definitely. Oh, thank you. This you guys. Thank you so much. I'm definitely gonna have to. Oh yeah, she's already has a following indeed. I appreciate that, Zizzy. Thank you. You guys are gonna make me cry, aren't you? You guys are amazing. I really appreciate it. Now I can buy you two more baby grows. Actually, I'm gonna go. I have to go and buy some more baby clothes. Like she doesn't have enough. She does not have enough because we thought that she was gonna be bigger than she actually is because she is 7 pounds 4. She was 7 pounds 4 when she was born, and we thought that she was gonna be big like her brother was, but no, she decided not to be, and we did not plan. We only we bought baby clothes from 0 months to 3 months, thinking that she would fit on that straight away. No, we had to get newborn clothes and diapers and everything because she did not she was literally swimming in the other in the other clothes, which was absolutely hilarious. She her little hands like flops around with, which is actually still a good thing because it protects from her scratching and everything, so she doesn't really need the the mitts because everything is so big, so it doesn't really she doesn't really need the mitts at the moment because everything is so big. But we did grab a couple like baby grows that does actually fit her, and she's not like literally swimming in it. Oh, case one, they are so cute. It's absolutely. Oh yeah, she will fit soon enough. Absolutely. With thank you, Maria. Oh, definitely more baby clothes. I'm gonna definitely go shopping for her. That's like especially because where I work. Stephanie, thank you very much for the gift of membership and for the support as well. No matter what they go from, I really, really appreciate you guys. Definitely because where I work, right, we have baby clothes, and oh, refresh my stream, or you guys can hear me, yeah? Oh, I don't know where the feed gone. Hang on, sorry, feed is gone. Ah,
a correction to the presumption of innocence, which I did do, as well as a mere presence instruction. Does anyone want to make a record on any of those changes that have occurred since we met Thursday? I forgot, I don't know if my staff told you, I did add, I realized standard number 9 was not added, which is defendant need not produce evidence, so I added that this morning as well. Have you had a chance to review the latest draft, or do you need more time? We told the jurors to be here at 11, so we have time if you need more time. Any other record you want to make on mere presence? All right, has the defendant had a chance to review the final instructions?
Yes, Your Honor.
Any additions or corrections?
No, Your Honor.
All right, we're still waiting for a few jurors to show up. The plan this morning, well, let me ask the defendant, you still plan on resting?
I do.
Okay, so when the jury comes in, I'll remind them that the state rested last Wednesday, and then I'll turn to you and you'll presumably say the defense rests. I'll read the jury instructions and we will break after I read the jury instructions. Depending on what time we break, I'll tell them what time to come back for the closing arguments, approximately an hour later, or around 1 p.m. While we're waiting, I had my staff email the parties about any potential aggravators. I didn't see a response to that. So in addition to, if there is a second phase of this trial for aggravation, in addition to a dangerous finding, does the state know what other aggravators it might be pursuing?
Potentially the emotional harm.
Anything else?
The presence of an accomplice.
Okay. And in the event that happens, would you be producing testimony or evidence, or would it just be argument?
Potentially testimony from Mexican.
Okay. All right. So how many jurors? You can go ahead and print out.
Your Honor, I have 2 issues I'd like to bring up real quick.
Go ahead.
The jury process of the jury alternate selection. Can you tell me what that process is going to be today?
It's literally drawing 2 numbers out of randomly out of a container.
Okay. And when is that going to be done and how does that
Not
work?
till after the closing arguments.
Okay.
So the alternates are told that they're still alternates, they're not released, because I have had in the past jurors become sick or ill or not be able to deliberate, and we have to call back an alternate to deliberate. So they're still under the admonition until they're released.
So we're keeping all of them, basically.
But only 12 will go back and deliberate.
Okay.
If one of those 12 becomes sick or is unable to deliberate, we would bring in an alternate and release the person that can't deliberate. Does that make sense?
Yes.
All right, what else?
So it came to my attention this weekend that the exhibit number 286 that the state put into evidence, that Detective Inkland testified to was the full interview is only about 21 minutes long, and the actual interview is about 55 minutes long.
Remind me what's 286 is, whose interview?
It's my interview, I guess, with Detective Inkland.
I think that's been redacted because the full interview wouldn't be admitted into evidence for the jury to review. Is that correct?
Correct.
All right.
Sorry about this, guys. I'm literally checking that because I was like, hang on, am I like having a deja vu moment again, or I was like literally all the feeds? Yeah, all the feeds are literally saying this. So it literally she reiterating the same thing over and over again that we already hear. So because we were live earlier, do you remember when I was saying that that we were not on the time delay, was like a 5 minutes or 5 minutes behind, and we were only 5 minutes behind, and we are supposed to be half an hour delay, but now they are repeating it again, so we are on the half an hour delay. Robert, you absolutely are fine, my friend. I really appreciate your help, and you are amazing. You're doing a great job. um this is literally already happened. But yeah, so I'm literally eating. That's why I'm not on camera right now, is because I'm literally having my food right now, because I'm like, I need to check if the feed is the correct one and make sure that we are doing the correct stuff. I'm trying to scout up, but every feed that is out there with the Lori Vallow case, it's literally doing this. So yeah. I don't know. You guys can hear it, but then it's gonna be looping. I don't know if it is gonna be looping or not. So I don't know. Let's carry on watching and see what
Interview, and
happens.
it was
I
admitted
guess.
into to reflect the record that it was the full interview. So are you telling me that the jury is not going to be able to go back and watch the full thing?
Your full interview?
Correct.
No, because it was never admitted into evidence.
But that's what they said was admitted into evidence.
I don't remember if that's what was said or not. I would be surprised if someone said your entire interview was being admitted, but I don't remember the
Well,
exact
my advisory
testimony.
council checked the FTR, and that's exactly what was said. That was exactly what I was shown, that it said, is this the full interview? Yes, this is the full interview, and it was admitted into evidence.
Was
So-
there sometimes they enter in the full interview for appeal purposes only, but that's not the one that actually gets shown to the jury. Was that the case?
Was not for appellate purposes.
Okay.
It is the full interview. The defendant talks to the detective in the beginning about Tylee, does not include that. She talks to the detective at the end about Tylee and victim services. It doesn't include any of that. She's sitting in a room for I don't know how long while Tylee's being interviewed. It doesn't include any of that. It is her interview about what happened.
Okay. So the states closed their evidence.
I'm just trying to find out what the jury is going to be seeing. They have all that evidence in the evidence when they deliberate. Is that correct? They
Whatever
have
was,
access to that.
whatever was admitted into evidence, which portions of your interview were not admitted into evidence, it sounds like.
Okay, but from what I'm understanding from the state, just correct me if I'm wrong, it's not just the snippets that were played, but it's a partial part of the interview and some of it was redacted. Is that correct?
That's what I'm understanding. The parts regarding what Tylee said or did or didn't happen, the hearsay parts were the start and the end were redacted out.
And then what was meant by the testimony that this is the full interview?
I don't know. I guess that's something that someone could have asked that witness. Maybe it was the full interview of your version of what happened.
So we have
There.
our exhibit 20, the defense's proposed exhibit 20 is the full interview. Can we replace that one with the full interview since it was entered into evidence as the full interview?
No,
Why not?
your full interview won't come in because it's a significant amount of hearsay within that interview that's not admissible evidence.
It was admitted as the full interview.
Well, if a witness testified that it was a full interview, either side could have clarified that with that witness. I don't know what that witness meant when they said that. Anything else?
That's it.
All right, we're getting the sufficient number of the jury instructions copied. As soon as that's done and our jurors get here, we'll read those instructions. All right.
All right, so we should be now okay and not loopy again. Let's check this feed. What's happening? Okay, this feed is not like I'm just checking. Right. Okay. Now the feed is showing. The other feed is showing exactly the same thing, but let's just change a couple of bits. Sorry about this, guys. This is very loopy. We were listening to both things at the same time. Hang on, which one? That one. That one is the one. That one. I think hopefully now we are on the 30-minute delay for the for the thing. So no, it's not lunch, pickles. It's we are waiting for the court to start. That was just a loop of what we already had watched. Yeah, yeah, Garden is just there behind me. Sorry, I have my camera off because I'm still eating, and in true fashion of me, I spilled on myself, so I need to change. So loopy over loop. Yes, indeed, loop of a loop. So hopefully now we are fine in terms of feed that it's gonna be live. Well, with the 30-minute delay, I don't know because now I'm scared to change to the other trial and then lose our place because I just want to make sure that we have the correct place for the feed and not mess up and then we don't know where we are when we get back from lunch break. So I think sadly we might have to abandon and listen Jose Morales testimony just to make sure that we don't lose the place with Lori Vallow, which I'm not too happy about because I'm like yeah. So hopefully it will be fine. I mean, if one poll has a loop, every poll is gonna have a loop. So yeah. Um well, hang on, they are back. All right. Okay, this should be fine then. Share this tab instead. Okay, let's close that one. Sorry, Denise. So keep in mind that there's only one camera feed. Yeah, everyone is plugged into that feed. I have a feeling. Yeah, I think they weren't supposed to. I think I agree. I agree with you. They weren't supposed to, and we watched, and now they did took down that other feed we were watching with like no delay, and they now took it down and played the whole thing again. I agree, absolutely agree with you, Denise. So now I think we are in a proper time of the delay. I am still just scared, and we're gonna keep chatting in chat, but I think we're gonna have to listen to the jury instructions. And I am sorry. I know it's not nice. I know we don't like jury instructions, but I'm just a bit scared, and you know that I am a little bit perfectionist or a bit too perfectionist to lose the Lori Vallow place, and I don't want anything to mess up. But that doesn't disagree. That what I'm gonna do is I'm gonna just play a bit of a music because I'm literally finishing my dinner and the food is getting cold. So I'm just, or if anyone wants to come up and entertain everybody, you can for a little bit while I have my food. You can come. I'm just winking at the screen if anyone wants to pop in, just to help me out so I can finish my dinner. I mean, you can just talk away with people like I do all the time. But it's very. By the way, before I do say, um, good morning, Pickles. Nice to see you, my friend. I hope you had a nice Easter, a nice weekend with the family and everything, and as well as you, Journeys, as everyone in chat. Jed, I know you had a very good weekend because we had the same weekend. So that's the good thing. So if I'm gonna play just a little bit of music so I can eat. um shall I play the verdict music? Shall we just play? No, I'm joking, we don't have a verdict just yet, so I'll be right back. I'll try to eat as fast as I can and change, because yeah.
Courtroom buzz lights up the air. Faces tense as stories tear. Truth and lies like a tango dance. Justice here takes no chance. Gavel strikes, hearts beat fast. Witness takes stand, shadows cast. Whispers loud like wildfire spread. In this game, none's ahead. International eyes on the scene. Lines of right, blurred and lean. Arrested dreams, shattered glass. In this court, who holds the past? Lawyers dance in verbal fight. Day turns into darkest night. Every turn, heart skips a beat. Justice tango on repeat. Families watch, soul torn apart. Courts drama quick to start. Chains rattle, futures bleak. Yet in silence, justice seeks. Around the world, eyes new gaze. Every trial a twisted maze. Judgment passed through smoky gates. In this court, no room for haste. International eyes on the scene. Lines of right, blurred and lean. Arrested dreams, shattered glass. In this court, who holds the past? International eyes on the scene. Lines of right, blurred and lean. Arrested dreams, shattered glass. In this court, who holds the past? In this court, who holds the past? Lawyers dance in verbal fight. Day turns into darkest night. Every turn, heart skips a beat. Justice tango on repeat. Lawyers dance in verbal fight. Day turns into darkest night. Every turn, heart skips a beat. Justice tango on repeat. Lawyers dance in verbal fight. Day turns into darkest night. Every turn, heart skips a beat. Justice tango on repeat. Lawyers dance in verbal fight. Day turns into darkest night. Every turn, heart skips a beat. Justice tango on repeat. On repeat. On repeat. On repeat. No repeat. Families watch, soul torn apart. Courts drama quick to start. Chains rattle, futures bleak. Yet in silence, justice seeks. Around the world, eyes to gaze. Every trial a twisted maze. Judgment passed through smoky gaze. In this court, no room for haze. In this court, who holds the past? In this court, who holds the past? On repeat. On repeat. No repeat. No repeat. No.
She's a Portuguese soul in the UK, rolling dough at the bakery day by day. Sugar on her apron, flour on her face, but when evening comes, she steps into a darker place. Grab the keys to the car for that Costco run. Loading up on snacks before the work's all done. 'Cause once she's home, it's time for the show. True crime on YouTube, spotlight aglow. Late night trials and conspiracies. She's digging for truth for the world to see. Documents on Discord. She's on the hunt. In the hush of midnight, she's on the front. She's got her boyfriend by her side. Together they host this chilling ride. Nightbots watching, chats alive. Everyone's hooked, ready to dive. Her days are sweet and filled with bread. Her nights are dark, deep in her head. From morning glow to midnight files, she dances between the day and trials. Late night trials and conspiracies. She's digging for truth for the world to see. Documents on Discord. She's on the hunt. In the hush of midnight, she's on the front. Portuguese pride in the UK sun. She'll solve every case till the morning comes. Daytime bakery, nighttime sleuth. Our true crime addict revealing in the truth.
Hello, hello, hello. I am back. Sorry, I was just finalizing checking the verdict form thingy to make sure everyone is already oh, okay. I hope I know it's not gonna be easy to take such a hard news, William, and I'm really, really sorry about that. It's never easy to take news that's, someone passes that you kind of look up to, no matter who that person is. It's always hard, so I'm really sorry, and I'm sending a hug for your mom, William. I hope she copes well with the news, and my apologies for that. So we are almost there, I think. I don't know, I have no clue, because we don't know what kind of difference we are right now. um Oh wow, like, see, that's the thing. Like, some people do see um either public figures or something that you get kind of close to in a way, and you kind of have a high regard, and it's like losing a family member, and it's, yeah. um yeah, but it's still, I understand that, William, but yeah. um Oh, it's okay, Pickles. We understand, girl, that you are very busy right now, and but just you being here, I absolutely appreciate that, and we do miss you, and are hoping that things get a bit easier for you, my friend, because um you definitely need that. You definitely need to be able to rest up. But hey, we're still gonna be here until late, until you finish, so then you can probably catch up with us, and that would be absolutely amazing. And Garden Bot, I know we do need to do our books. I need to do my taxes. It's not tax season, but we can file our taxes if we want to. So we definitely need to get that done. And I want to, but I don't want in a way because I know it's gonna be the first year I am a like I have a self-employed tax to file, and that is gonna be hard. But it's gonna be okay. I do love taxes. I do like it. I like to numbers and organizing things and do all of that type. But I have not been on top of my taxes. Definitely not. Like I haven't put amounts on a spreadsheet or anything. 'Cause yes, I do have a spreadsheet for my taxes for garden bot taxes and everything. And yeah, I definitely need to keep on top, but I haven't. I know it's not good. Um no, I know, not me, Zio. I know. It's very, very bad of me. It's horrible, it's shocking. And um yeah, I know, I failed. I'm sorry guys. I absolutely failed there. But I will catch up and I'll get it done. It's not a problem. Because actually I haven't told you. Uh I finish work Wednesday and I have uh 10-15 days off. So I think my boss at the bakery, I don't think I don't I think he thinks that I don't work there anymore because I am more often than not. So oh no. But that's funny. Um, no, I did not tell you Zero, and I am so sorry. I I've already been to my regular shift. I was there today, but last week I worked 2 days. This week I'm working my full week, the 3 days, and then I'm off from next Wednesday until not the following the other week. So basically in May. So hang on, let me see the calendar. Where's the calendar? So I finish on the 23rd. That's gonna of April. That's gonna be my last day of work, and I'm only gonna go back to work on the 5th of May. And then that same week that I go back, I work that week. But then the following week, I only work 2 days because it's the week me and Garden Bot are going away to the concert. So I think my boss thinks that I barely work now there. I do still, but it's just I just have a lot of holidays and stuff um planned. I think they are back. Hang on. I can hear noises. Yes, we are back. Hang on. I have another feed on the background and this one hasn't catch up. Hang on. I will share this one instead and pause this one. I was just a bit worried about that. Let me see if this one catches up and we'll see. 1 second. Jerry's just getting in now, so it's no bother.
The parties are present. The jury is not present.
There you go.
We'll bring in the jury. Instructions to the facts as you determine them. You must follow these jury instructions. They are the rules you should use to decide this case. It is your duty to determine what the facts are in the case by determining what actually happened. Determine the facts only from the evidence produced in court. When I say evidence, I mean the testimony of witnesses and the exhibits introduced in court. You should not guess about any fact. You must not be influenced by sympathy or prejudice. You must not be concerned with any opinion that you feel I have about the facts. You, as jurors, are the sole judges of what happened. You must consider all these instructions. Do not pick out one instruction or part of one and ignore the others. As you determine the facts, however, you may find that some instructions no longer apply. You must then consider the instructions that do apply together with the facts as you have determined them. Evidence to be considered. You are to determine what the facts in the case are from the evidence produced in court. If the court sustained an objection to a lawyer's question, you must disregard it and any answer given. Any testimony stricken from the court record must not be considered. Rulings of the court. Admission of evidence in court is governed by rules of law. I have applied those rules during the trial and resolved any issues concerning the admission of evidence. If an objection to a question was sustained, you must disregard the question and you must not guess what the answer to the question might have been. If an exhibit was offered into evidence and an objection to it was sustained, you must not consider that exhibit as evidence. If testimony was ordered stricken from the record, you must not consider that testimony for any purpose. If evidence was admitted for a limited purpose, you shall consider that evidence only for that limited purpose. Do not concern yourselves with the reasons for my rulings on the admission of evidence. Do not regard those rulings as any indication from me of the credibility or weight you should give to any evidence that has been admitted. Direct and circumstantial evidence. Evidence may be direct or circumstantial. Direct evidence is the testimony of a witness who saw, heard, or otherwise sensed an event. Circumstantial evidence is the proof of a fact or facts from which you may find another fact. The law makes no distinction between direct and circumstantial evidence. It is for you to determine the importance to be given to the evidence regardless of whether it is direct or circumstantial. Redacted exhibits. Some of the exhibits that have been admitted into evidence have had portions deleted from them for legal reasons. Do not concern yourselves with the reasons why some portions of the exhibits have been deleted. Do not speculate upon what the deleted portions might or might not reveal. Indictment is not evidence. The state has charged the defendant with a crime. A charge is not evidence against the defendant. You must not think a defendant is guilty just because of a charge. The defendant has pled not guilty. This plea of not guilty means that the state must prove each element of the charge beyond a reasonable doubt. Self-represented defendant. The defendant in this case represents herself. All instructions I read to you that include references to lawyers or attorneys apply equally to the defendant's self-representation at trial. The defendant's decision to represent herself should not be considered by you when determining the facts. Comments are not evidence. In their opening statements, the prosecutor and the defendant talk to you about the law and the evidence. In a few minutes, the prosecutor and defendant will give their closing arguments and will talk about the law and the evidence. What they said or say is not evidence because it is not sworn testimony, but it may help you to understand the law and the evidence. Credibility of witnesses. In deciding the facts of this case, you should consider what testimony to accept and what to reject. You may accept everything a witness says or part of it or none of it. In evaluating testimony, you should use the tests for truthfulness that people use in determining matters of importance in everyday life, including such factors as the witness's ability to see or hear or know the things the witness testified to, the quality of the witness's memory, the witness's manner while testifying, whether the witness had any motive, bias, or prejudice, whether the witness was contradicted by anything the witness said or wrote before trial or by other evidence, and the reasonableness of the witness's testimony when considered in the light of the other evidence. Consider all of the evidence in the light of reason, common sense, and experience. Testimony of law enforcement officers. The testimony of a law enforcement officer is not entitled to any greater or lesser importance or believability merely because of the fact that the witness is a law enforcement officer. You are to consider the testimony of a police officer just as you would the testimony of any other witness. Expert witness. A witness qualified as an expert by education or experience may state opinions on matters in that witness's field of expertise and may also state reasons for those opinions. Expert opinion testimony should be judged just as any other testimony. You are not bound by it. You may accept it or reject it in whole or in part, and you should give it as much credibility and weight as you think it deserves, considering the witness's qualifications and experience, the reasons given for the opinions, and all the other evidence in the case. Defendant need not produce evidence. The state must prove guilt beyond a reasonable doubt based on the evidence. The defendant is not required to produce evidence of any kind. The defendant's decision not to produce evidence is not evidence of guilt. Defendant need not testify. The state must prove guilt beyond a reasonable doubt based on the evidence. You must not conclude that the defendant is likely to be guilty because the defendant did not testify. The defendant is not required to testify. The decision on whether or not to testify is left to the defendant. You must not let this choice affect your deliberations in any way. Mere presence. Guilt cannot be established by the defendant's mere presence at a crime scene, mere association with another person at a crime scene, or mere knowledge that a crime is being committed. The fact that the defendant may have been present or knew that a crime was being committed does not in and of itself make the defendant guilty of the crime charged. One who is merely present is a passive observer who lacked criminal intent and did not participate in the crime. Voluntariness of defendant's statements. You must not consider any statements made by the defendant to a law enforcement officer unless you determine beyond a reasonable doubt that the defendant made the statements voluntarily. A defendant's statement was not voluntary if it resulted from the defendant's will being overcome by a law enforcement officer's use of any sort of violence, coercion, or threats, or by any direct or implied promise, however slight. You must give such weight to the defendant's statement as you feel it deserves under all the circumstances. Jury not to consider penalty. You must decide whether a defendant is guilty or not guilty by determining what the facts in the case are and applying these jury instructions. You must not consider the possible punishment when deciding on guilt. Punishment is left to the judge. Presumption of innocence, burden of proof. The law does not require a defendant to prove innocence. Every defendant is presumed by law to be innocent. You must start with the presumption that the defendant is innocent. The state has the burden of proving the defendant guilty beyond a reasonable doubt. This means the state must prove each element of each charge beyond a reasonable doubt. In civil cases, it is only necessary to prove that a fact is more likely true than not, or that its truth is highly probable. In criminal cases such as this, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find her guilty. If, on the other hand, you think there is a real possibility that she is not guilty, you must give her the benefit of the doubt and find her not guilty. Evidence of any kind. The state must prove guilt beyond a reasonable doubt on the evidence. The defendant is not required to produce evidence of any kind. The decision on whether to produce evidence is left to the defendant. The defendant's decision not to produce any evidence is not evidence of guilt. Voluntary act. Before you may convict the defendant of the charged crime, you must find that the state proved beyond a reasonable doubt that the defendant committed a voluntary act. A voluntary act means a bodily movement performed consciously and as a result of effort and determination. You must consider all the evidence in deciding whether the defendant committed the act voluntarily. Absence of other participant. The only matter for you to determine is whether the state has proved the defendant guilty beyond a reasonable doubt. The defendant's guilt or innocence is not affected by the fact that another person or persons might have participated or cooperated in the crime and is not on trial now. You should not guess about the reason any other person is absent from the courtroom. Motive. The state need not prove motive, but you may consider motive or lack of motive in reaching your verdict. The charged offense. I will now tell you about the crime with which the defendant is charged. Count 1, conspiracy to commit first-degree murder. The crime of conspiracy to commit first-degree murder requires proof that the defendant, on or about July 11, 2019, with the intent to promote or aid in the commission of first-degree murder, agreed with Alexander Cox that at least one of them or another would engage in conduct constituting the offense of first-degree murder. The crime of first-degree premeditated murder requires proof that a person, 1, caused the death of another person, and 2, intended or knew that he or she would cause the death of another person, and 3, acted with premeditation. Premeditation means that the defendant intended to kill another human being or knew she or a co-conspirator would kill another human being, and that after forming that intent or knowledge, reflected on the decision before killing. It is this reflection, regardless of the length of time in which it occurs, that distinguishes first-degree murder from second-degree murder. An act is not done with premeditation if it is the instant effect of a sudden quarrel or heat of passion. The time needed for reflection is not necessarily prolonged, and the space of time between the intent or knowledge to kill and the act of killing may be very short. Elements of conspiracy. The crime of conspiracy to commit first-degree murder requires proof. 1, the defendant agreed with one or more persons that one of them or another person would engage in certain conduct, and 2, the defendant intended to promote or assist in the commission of such conduct, and 3, the intended conduct would constitute the crime of first-degree murder, and the defendant knew that such conduct was a crime. Scope of proof of conspiracy. To prove a conspiracy, it is not necessary to show a formal meeting or an express agreement. A conspiracy may be inferred from circumstances showing a common criminal objective and does not require proof that all means set forth in the charging document were agreed upon or actually used, nor that every person involved was a member of the conspiracy. Proof of membership in conspiracy. One may become a member of a conspiracy without full knowledge of all the details of the conspiracy. On the other hand, a person who has no knowledge of a conspiracy but happens to act in a way that furthers some object of the conspiracy does not thereby become a conspirator. Before you find that a defendant or any other person was a member of a conspiracy, the evidence must show beyond a reasonable doubt that the conspiracy was knowingly formed and that the defendant or another person knowingly participated in the unlawful plan with the intent to promote or assist the carrying out of the conspiracy. One who knowingly joins an existing conspiracy is as responsible as an originator or instigator of the conspiracy. A person understanding the unlawful character of a plan who knowingly encourages, advises, or assists in the undertaking thereby also becomes a conspirator. In determining whether a conspiracy exists, you should consider the actions and statements of all the alleged participants. However, in determining whether a particular defendant was a member of the conspiracy, you should consider only that person's acts and statements. A person cannot be bound by the acts or statements of other participants until it is established that a conspiracy existed and that person was one of its members. Justification for self-defense physical force. A person is justified in using or threatening deadly physical force in self-defense if the following two conditions existed. 1, a reasonable person in the situation would have believed that deadly physical force was immediately necessary to protect against another's use or apparent attempted or threatened use of unlawful deadly physical force. And 2, the person used or threatened no more deadly physical force than would have appeared necessary to a reasonable person in the situation. A person may use deadly physical force in self-defense only to protect against another's use or apparent attempted or threatened use of deadly physical force. Self-defense justifies the use or threat of deadly physical force only while the apparent danger continues, and it ends when the apparent danger ends. The force used may not be greater than reasonably necessary to defend against the apparent danger. The use of deadly physical force is justified if a reasonable person in the situation would have reasonably believed that immediate deadly physical danger appeared to be present. Actual danger is not necessary to justify the use of deadly physical force in self-defense. You must decide whether a reasonable person in a similar situation would believe that deadly physical force was immediately necessary to protect against another's use, attempted use, threatened use, apparent attempted use, apparent threatened use of unlawful deadly physical force. You must measure the person's belief against what a reasonable person in the situation would have believed. A person has no duty to retreat before threatening or using deadly physical force in self-defense if the person, 1, had a legal right to be in the place where the use or threatened deadly physical force in self-defense occurred, and 2, was not engaged in any unlawful act at the time when the use or threatened deadly physical force in self-defense occurred. If evidence was presented that raised this justification defense for count 1, conspiracy to commit first-degree murder, then the state has the burden of proving beyond a reasonable doubt that the defendant or co-conspirator did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Justification for defense of a third person. A person is justified in using or threatening physical force in defense of a third person if the following 2 conditions existed. 1, a reasonable person in the situation would have believed that physical force was necessary to protect against another's use, attempted use, apparent attempted use, threatened use of unlawful physical force against a third person, and 2, the defendant used or threatened no more physical force than would have appeared necessary to a reasonable person in the situation. A defendant may use deadly physical force in defense of a third person only to protect against another's use, attempted use, apparent attempted use, threatened use of deadly physical force. Defense of a third person justifies the use of or threat of physical force or deadly physical force only while the danger continues, and it ends when the danger ends. The force used may not be greater than reasonably necessary to defend against the danger. Actual danger is not necessary to justify the use of physical force or deadly physical force in defense of a third person. The use of physical force or deadly physical force is justified if a reasonable person in the situation would have reasonably believed that immediate physical danger appeared to be present. You must decide whether a reasonable person in a similar situation would believe that 1, physical force was necessary to protect against another's use, attempted use, apparent attempted use, threatened use of unlawful physical force against a third person, and or 2, deadly physical force was necessary to protect against another's use, attempted use, apparent attempted use, threatened use of unlawful physical force against a third person. You must measure the person's belief against what a reasonable person in the situation would have believed. The state has the burden of proving beyond a reasonable doubt that the person did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Use of force in crime prevention. A person was justified in threatening or using physical force and or deadly physical force against another if and to the extent the person reasonably believed that physical force or deadly physical force was immediately necessary to prevent another from committing or apparently committing the crime of aggravated assault. There is no duty to retreat before threatening or using deadly physical force. There is no requirement that any threat to the person's safety exists before the person may use physical force and or deadly physical force. However, physical force and or deadly physical force can be used only to the extent it appears reasonably and immediately necessary to prevent commission of the crime of aggravated assault. The person's use or threatened use of physical or deadly force is not limited to a person's home, residence, place of business, land the person owns or leases, or conveyance of any kind, but includes any place in this state where a person has a right to be. The person is presumed to have acted reasonably if the defendant reasonably believed he or she was acting to prevent the imminent or actual commission of aggravated assault. The person is justified in using physical force and or deadly physical force against another person, even if that person is not actually committing or attempting to commit the crime, if the person reasonably believed he or she was preventing the commission of the crime. Actual danger is not necessary to justify the use of physical force or deadly physical force in crime prevention. If evidence was presented that raised this justification defense for first-degree murder, then the state has the burden of proving beyond a reasonable doubt that the person did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Non-justification for threat or use of physical force. A person is not justified in using or threatening physical force against another in response to verbal provocation alone, or if the defendant or co-conspirator provoked the other person's use or attempted use of unlawful physical force, unless 1, the defendant or co-conspirator withdrew from the encounter or clearly communicated to the other person the intent to withdraw with the reasonable belief that the defendant could not safely withdraw, and 2, the other person continued or attempted to use unlawful physical force against the defendant or co-conspirator. The state has the burden of proving beyond a reasonable doubt that the defendant and or co-conspirator did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Definitions. Intentionally or with the intent to means that a person's objective is to cause that result or to engage in that conduct. Intent may be inferred from all the facts and circumstances disclosed by the evidence. It need not be established exclusively by direct sensory proof. The existence of intent is one of the questions of fact for your determination. Knowingly, willfully, or knew means that a person is aware or believes that his or her conduct is of that nature or that the circumstance exists. It does not require any knowledge of the unlawfulness of the act or omission. If the state is required to prove that the defendant acted knowingly, that requirement is satisfied if the state proves that the defendant acted intentionally. A defendant is criminally accountable for the conduct of another if the defendant is an accomplice of such other person in the commission of the offense, including any offense that is a natural and probable or reasonably foreseeable consequence of the offense for which the person was an accomplice. Accomplice means a person who, with the intent to promote or facilitate the commission of the offense, does any of the following. 1, solicits or commands another person to commit the offense, or 2, aids, counsels, agrees to aid, or attempts to aid another person in planning or committing the offense, or 3, provides means or opportunity to another person to commit the offense. Act means a bodily movement. Aggravated assault means a person intentionally, knowingly, or recklessly caused a physical injury to another person, or intentionally put another person in reasonable apprehension of imminent physical injury by either 1, causing serious physical injury to another person, or 2, using a deadly weapon or dangerous instrument. Conduct means an act or omission and its accompanying culpable mental state. Deadly weapon means anything designed for lethal use, including a firearm. Dangerous instrument means anything that is readily capable of causing death or serious physical injury under the circumstances in which it is used, attempted to be used, or threatened to be used. Deadly physical force means either 1, force which is used with the purpose of causing death or serious physical injury, or 2, force which in the manner of its use is capable of creating a substantial risk of causing death or serious physical injury. Unlawful means contrary to law, or where the context so requires, not permitted by law. Jury foreperson. The case will soon be submitted to you for your decision. When you go to the jury room, you will choose a foreperson. The role of jury foreperson is important, but please remember that the foreperson's opinion about the case is not more important than that of the other jurors. The opinions of each juror count equally. The jury foreperson's responsibilities include the following. 1, make sure every member of the jury is present during all discussions and deliberations. 2, make sure that the deliberations are conducted respectfully and that all issues are fully discussed. The discussions should be open and free so that every juror may participate. 3, all jurors should be allowed to state their views about the case and what they think the verdict should be and why. 4, all members must agree unanimously on any verdict. Therefore, the foreperson should count the votes to ensure that every juror has voted. 5, if you reach a verdict, fill out the verdict form and then sign the form on behalf of the jury. 6, if the jury reaches a verdict, the foreperson will inform the courtroom assistant. When the jury returns to the courtroom, the foreperson will bring the signed or unsigned verdict form as well as any question forms that may have been used. 7, when you return to the courtroom, the court will ask the foreperson whether the jury has reached any verdict. The foreperson will respond yes or no. The foreperson is not expected to read any verdict to the court. That will be done by the clerk. Closing instruction. In a few minutes, we're probably going to take a lunch break, and then after the lunch break, you will hear the closing arguments in this case. After that, the case will be submitted to you for decision. I suggest that you discuss and then set your deliberation schedule. You are in charge of your schedule and may set and vary it by agreement and the approval of the court. After you have decided on a schedule, please advise the courtroom assistant. You are to discuss the case and deliberate only when all jurors are together in the jury room. You are not to discuss the case with each other or anyone else during breaks or recesses. The admonition I have given you during the trial remains in effect when all of you are not in the jury room deliberating. After setting your schedule, I suggest that you next review the jury instructions and verdict form. It may be helpful for you to discuss the instructions and verdict form to make sure that you understand them. Again, during your deliberations, you must follow the instructions and refer to them to answer any questions about applicable law, procedure, and definitions. Should any of you or the jury as a whole have a question for me during your deliberations or wish to communicate with me on any other matter, please utilize the jury question form that we will provide you. Your question or message must be communicated to me in writing and must be signed by you or the foreperson. I will consider your question or note and consult with counsel before answering it in writing. I will answer it as quickly as possible. Remember that you are not to tell anyone, including me, how you stand numerically or otherwise until after you have reached a verdict or have been discharged. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or social media to communicate to anyone any information about this case or to conduct any research about this case until I accept your verdict. All 12 of you must agree on the verdict. You must be unanimous. Once all 12 agree on a verdict, only the foreperson needs sign the verdict form on the line marked jury foreperson. You will be given one form of verdict. The verdict form reads as follows, and there is no significance to the order in which the options of guilty or not guilty are listed on the verdict form. So this is a sample verdict form at the end of your instructions. It indicates this is a sample. An official verdict form will be given to you by the courtroom assistant in the jury room. Verdict, count 1, conspiracy to commit first-degree murder. We, the jury, duly impaneled and sworn in the above entitled action and upon our oaths, do find the defendant, Lori Daybell, as to the crime of conspiracy to commit first-degree murder occurring on or about July 11, 2019 as follows. Check only 1, and the options are not guilty or guilty. In order to break up the closing arguments as little as possible, we're going to take our lunch recess a little early and start a little early with those closing arguments after you recess. So we'll go ahead and recess for your lunch break. If we could have everyone ready to go in the jury room at 12:45, please remember the admonition.
All right, for the jury. All right, so they gone on lunch. Let's see. Hang on. They are on lunch right now, so I am just right. So now court is gonna be back in real time in 45 minutes. For us, is gonna be in an hour and 15 minutes. I think I'm doing it correctly. So yeah, we'll see what happens and when exactly. I absolutely agree. So court is gonna be back in 45 minutes real time, but then we have to wait half an hour. So they will be back at 4:15 Eastern, and they will be starting the closings for the Lori Vallow Daybell case. I think it's going to be quite a rather quick a verdict reached, so I don't think they are gonna take too long in terms of reaching a verdict. I think it's just gonna be getting there, choosing a foreperson, and then just sign the paper. She's guilty and come out. So about half an hour, I think. I think it will be very quick verdict. I don't think it's gonna be a very very long verdict watch, because the thing is that I was thinking, if it was a rather long, like the Linda Stemmer case, that I think that they ask a lot of questions and they took a while to deliberate. In this one, they didn't, so it was pretty straightforward, the guys. So I think, yeah, I agree with you. The paperwork was definitely take the longest. Well, over an hour, yeah, of the break. So an hour and 15 minutes, they will be back. And I absolutely agree. I think it's going to be a very quick verdict. It's going to be being Bosch done, I think we are gonna be like chatting it up. The verdict will come out, and then we'll be like, "What's happened?" And yeah, it's gonna be an early night. So you still, if you haven't played the verdict game, I think everyone has already played. So I'm gonna take the night bot, repeating that for every half an hour. Um, but yeah, so if you want to play the verdict game, you can do in chat or you can do on the forum. But I'm taking that on off the time. So I was thinking I need to walk a little bit because my hip is starting to hurt. So I need to stretch my legs. I was thinking during the lunch break, because we haven't watched. Okay, change your time to under 2 hours. Where are you, Paula? Where are you on my list? Paula. Um, where did I put you? Oh, there you are. So, Paula, under 2 hours. Okay, I'll put under 2 hours, because I need to sort out the clock to see if I can plug GardenBot's computer back to the other screen, and have the clock so we can have the clock for verdict. Otherwise, I'm gonna have to do somewhere else, another way. But I'm gonna play because we haven't watched this, and we can watch the first hour and a bit now, and then the rest while we are on the deliberations. I'm gonna be playing the Alex Cox interview by the police after the pew pewing incident with Charles Vallow. So almost the whole reason that we are here. So I'm gonna share this tab here. The sound is a little bit loud, so let me put it down a bit so we do not get like, yeah, and then
check you out, or?
No, I think it's more adrenaline than anything.
Gotcha. Do you have any medical issues that might be underlying that?
Yeah, I'm slightly overweight.
Yeah, okay, well, yeah, join the club. Other than that, high blood pressure or anything, or you take medication that you need to have?
No. Just,
Okay.
It was a little high in my last physical, but not,
Oh, okay.
nothing major, no medication or anything like that.
Groovy, okay.
Okay, Rob, if you don't mind hanging tight, do you need another water or are you good? Oh, you got one?
I got an extra.
Perfect.
Thank you very much.
Uh-huh. We'll be right back, Rob.
Yep, all right.
You didn't mind.
Nice sit a lot, when I type, sitting in the car, driving around, it's like I want to stand a lot of the times, but sometimes it's just too hard to write and stand.
Yeah, that's fine. No, we're right here. I'm all set, Robin.
Okay.
If you're good.
I'm good. The only thing is, what he was using to
Okay.
clean his head. Other than that, this is all his property.
Okay.
I did call a night detective to have that.
Photograph, you did?
No, I did not.
Okay.
I did not.
If you could have, call one for
Yeah,
the
I'll
interview
do that
room
right now.
downstairs, thank you.
bet. Are we still on pot?
I think they were gonna clear it, but I had my radio off. All right, Alexander, my name's Nate Moffett, I'm in the Detective Police Department. I want to walk through what happened today. Let me just write a couple things down. 83744, 837. So, are you still living out on
Yeah.
Cherie Street?
Yeah.
Okay, so. STV 8514. Are you working right now?
I'm off this week.
Okay, where do you work at? What do you do for them?
On drive a truck. Mostly hauling has waste.
Okay, what's the cell phone number for you? Okay, what about Soch? Okay, I have very little understanding or knowledge of what happened. Patrol kind of, Rob, or the officer that talked to you out there, it kind of turns into the phone game. So, you know what I mean? When they go, yeah, this is what he says, but they're kind of rambling through it real fast. And same with your sister. Your sister's name is Lori or Lauren?
Lori.
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 Okay. So the big thing I want to do is just make sure that we have all the details accurate and factual.
Yeah.
So, because kind of some of the information we got from patrol didn't really match up what Lori told us compared to. So walk me through what happened today.
Well, I stayed the night at my sister's.
Okay.
We were planning to go do something fun day. We hadn't really decided. I was thinking maybe I was going to take her to the range.
Okay.
Or go do something.
Okay.
I don't know, take JD to some water park or movies or whatever. So I stayed there last night, and this morning Charles showed up, and I don't know what started it.
And Charles is your brother-in-law, he and Lori are married?
Yes.
Okay.
So he showed up, he was, following her and yelling. And then I got between them. And then Tylee came out with her bat. And I had separated for a minute, and then my sister walked around me there in the living room. And then Charles was following Lori and yelling. And Tylee told him to get back. She took her bat like that and shoved him, and he took the bat away. And I said, "What are you doing?" And I got between them, and then he hit me. And I just went down, and when I got up, he was still yelling. And so I went into the bedroom where I was staying, grabbed my gun, and I came back.
Okay.
And told him to put the gun down, or the bat down. And he came at me and was saying, "What are you gonna do?" Like that, and coming to me with the bat. I said, "Put it down." He wouldn't. He came at me, so.
Okay. So when that argument first started between Lori and Charles,
Yeah.
where in the house were they?
I don't know.
Okay. Where did you first?
I was in my bedroom.
Okay, so you were in your
Where I was
bedroom
staying.
and you heard the argument.
When they came right towards me.
Okay, so they were coming down the hallway towards the bedroom?
Yes.
Okay, so you hear the argument, you step out, what's the first thing that you see?
Charles chasing after Lori and yelling.
Okay. Had Tylee already gotten the bat? Did he already have the bat? Okay.
No.
So Charles is coming towards Lori,
He's
they're coming your
towards
way.
Lori, and I shoved him back.
Okay,
And I said, "What are you doing?" Because he's coming at her aggressively.
Okay.
He's a big dude, so he's not gonna hurt my sister.
okay. So he's coming at her.
Yeah.
And you shoved him back.
Yeah.
What happened right after that? And that's I'm sorry to interrupt you.
He got back up and he comes right to me, doesn't look at me, and continues to yell at Lori.
Okay.
So he's maybe this far away.
Are you in the hallway of the house or where are you?
Right close to the doorway
The-
of that bedroom.
Of the bedroom you were staying?
Yes.
Okay. So you're right near the bedroom?
Yes.
Okay.
So then, I don't remember why, he backed up, and then my sister came around behind me, and they ended up in the living room, and then while they were on the way to the living room, Tylee comes out of her bedroom, which is adjacent to the one I was staying in,
Okay.
with her bat,
Okay.
yelling at Charles. Actually, she was behind Charles at first, and then she got around in front of him in the living room.
Okay. So he then they went back towards the living room
Yes,
after
back in.
you shoved him. Did he
Yes.
fall to the ground when you shoved him?
Yeah, I think so.
Okay, so he falls to the ground, he gets back up, you're blocking between him and Lori.
Yes, yes,
And he basically is talking past you, still yelling at Lori.
yes.
What's he
exactly.
saying?
I don't remember.
Okay. So as you're standing there between them, what happened right after that? Is that when Tylee came out with her bat?
No, he backed up.
Okay,
He yelled something, and then he backed up, and then Lori went by me and around me in the hallway.
mhm,
So he backed up, I had cleared the doorway. So then she came around, and then Charles was behind her, pursuing her again aggressively.
okay,
Tylee came out, yelled at him with the bat.
okay. And are you guys in the living room then, or still in the
Yeah,
hallway?
It starts in the hallway and then goes to the living room.
Okay,
So Tylee gets around him in the living room, he stops. Tylee goes around to the front of him, tells him to back off.
what I find it easiest to do in situations like this is to just kind of draw like a rough
Yeah.
floor plan.
Sure. So we'll make this the living room. All right, and then this is the hallway,
Okay,
and then this is the kitchen. So Tylee's bedroom is here, my bedroom is here, and then the living room is here.
okay, we just put living room on there, so I know, and then you said that's kitchen,
Yeah,
and then
so the doorway's here.
okay, is this area of the house where all of this incident was focused
Yes.
at? Okay,
Yeah. And then there's another bedroom here. This is JJ's bedroom.
okay. So that you first get involved when they're down by your room.
They come all the way she comes in the room, and he comes right here, and I stopped him right here.
Okay, so she came into your room.
Yeah.
Okay, so she comes into your room, he's coming at her
Yeah.
aggressively, and
Yeah.
that's when you pushed him.
Yep.
So you push him down.
Yep.
And then he gets back up.
Yep.
And,
And then he yells, and then he backs up,
okay,
and then Lori goes around him, and they're still going at it.
okay,
And then Tylee comes out when she hears what's going on. She has her bat.
Okay. Is it a metal bat?
Yeah, it's
Plastic
a
bat?
aluminum bat.
Okay.
So she comes at him because she's tiny, so that's like her thing. You know, she doesn't have anything, but she wants to help defend her mom.
Okay.
So she comes at him, and then when
And they've already moved back
right,
towards the living
so
room.
they're going this way.
Okay.
So Lori's here, Tylee's here, Charles is here. I'm here. Tylee goes at him with the bat. Then he takes the bat away from her, and I step towards him, and he turned around and cracked me.
Is that foot injury that's
Yes.
caused on your head? Okay.
Well, there was some shoving first, and I got spun around.
Okay.
And then popped. So I go back here, grab my gun, and come back out. He's still yelling and threatening me.
Okay.
And then, so I was standing here, and he was there.
Okay. So you're standing right there. He's right here.
He's there.
And you said, what happened? What happened when you came out with the gun?
I said, put that bat down. He's like, what are you going to do? It's like, you're going to threaten me? I was like, no, I'm just going to defend myself. So you put that bat down. And he goes, what are you going to do like that? And he came at me.
Okay.
And he'd already hit me in the head.
Okay. So he came at you at the bat. What
Yeah.
was he doing with the bat when he came at you?
It was in his right hand like this.
Okay. So he's holding it low and he's coming at
Yeah.
you? Okay. So you gave him, how many times would you say you told him to like put the bat down?
Once.
Once? Okay. And then he started advancing towards you?
Yes.
How many shots did you fire?
I don't know. A couple.
Okay. Were Tylee and your sister?
I didn't see him, so I don't know where they were.
Where's JJ at during all this?
He's already out in the car.
Okay, so he's sitting out in the car.
Yeah, I think.
Okay. But you, as far as you think or understand, you're not sure where they were.
Correct.
He's in the corner of the living room.
They were no longer in the room
Okay.
when I come back out.
Okay. So they're out of the room, so
Yeah.
it's just you and him.
Yes.
And he basically comes at you with the bat.
Yeah.
You tell him to put it down.
Yeah.
He's like,
Yeah.
what are you gonna do about it?
Yeah.
And what'd you tell him?
I didn't say anything. He's coming at me, and I'm holding the gun.
Okay.
If you're gonna attack someone with a gun, you gotta be ready for the repercussions.
Yeah. So I just want to make sure, because
Yeah.
he basically, you had said earlier that he had the bat.
Yeah.
And he asked like, what are you going to do about it?
Yeah.
And you had already told him to put the bat down, and then he just came at you
Yeah.
and you shot him.
Yeah.
Okay. And you're thinking a couple times?
It was more than one shot.
Okay. So more than one shot. What kind of gun was it?
45.
Okay. What make?
It's a Springfield XDM.
Okay. So it's an XDM 45.
Yeah.
What type of ammo were you carrying in it? Do you know?
Just standard.
Like full metal jacket?
Yeah.
Target shooting? Okay.
Yeah.
So you fire a couple times.
Yeah.
You don't know where they're at.
They're gone.
They're gone. What happened right after that?
Right after that, I went to the kitchen and rinsed my hands off because I had blood on the back of my head. And then I went back into the room and put the gun down and grabbed my phone. And then went back into the kitchen and called 911.
Okay.
He lives in Houston.
Okay. For work, or are they separated, or?
Separated and for work.
Okay. So both. How long have
They
they been
split up,
separated?
January.
Okay. So 6 months or so, 6, 7 months.
Yeah, he's had some pretty erratic behavior since that split up.
Okay.
He came and threatened me and Tylee at my house. I don't remember in February or March or whatever.
Okay.
And there was a little confrontation from mostly between Tylee and Charles.
Were the police involved in that one?
No,
Okay.
I was just supervising to make sure that he didn't hurt her.
Okay. So, was he working out of state before January? Or?
He always has worked out of state.
Okay, so he always works out of state. What's he do for a living?
He does annuities.
Okay. So, what was he in town for today? Does he come into town often or?
Occasionally to see JJ.
Okay. Is he JJ and Tylee's dad?
He's JJ's dad. Well, actually, he's Charles's nephew. He's his niece's kid.
JJ is.
Yeah.
Okay.
And she was a meth addict, and they adopted JJ.
Okay. So they adopted JJ,
Yeah.
but Tylee is not.
Not his.
Okay.
So he would be a stepdad, I guess.
Okay. So stepdad. When's the last time he's been in town, or when's the last time you've seen him?
Last time I saw him was at my house in February, March.
Okay. Was he here last night? Did you guys have any interactions
No.
last night?
No.
Is there any history of domestic violence between Lori and Charles?
Not physically that I know
Okay. So, how old is Charles?
of. 60, maybe. I don't know.
Okay. How old's your sister?
44 or 5.
Okay.
Is it sad that I don't know?
I have to do the math every time, so don't worry about it.
It's hard enough remembering my own age.
Right. Each birthday, you're like, that didn't happen.
After 45, who cares?
Is there anything else that you could think of that I didn't ask about, but I need to know right now?
I can't think of anything.
Okay. Did Lori ever say, like in the last couple of days, that Charles was coming to town?
Yeah, she said he was coming to pick up JJ.
Okay. So you guys were expecting him to show up today?
Yeah.
Okay. So you knew, okay. It wasn't like he just showed up unexpectedly?
No, it wasn't
Okay.
a surprise or anything like that.
But you don't know what they were arguing or
No.
fighting about?
His behavior was a surprise, but him showing up was not a surprise.
Okay. Let me just walk you through my understanding of it.
Yeah.
To make sure that I'm accurate. You were in your room.
Yeah.
Had you even gotten up and like been out of your room this
Yeah,
morning?
brushing my teeth.
Okay. So you're in your room, you hear,
I'm just on the phone, and then I just hear them coming around the hall quick.
had you seen Charles before or like that morning?
No.
Okay, so
No.
you hear them arguing.
Yeah.
And.
First time I see him is at the doorway,
At your
and
door.
I shove him back.
So Lori comes into your room.
Yep.
You're in your room.
Yep.
You get up at the doorway and basically get between him and Lori.
Yep.
You push Charles back.
Yep.
He probably fell down to the ground or did fall to the ground.
He stumbled back.
Okay, so he stumbles back. He comes right back up
Yep.
and he's talking past you,
Yes.
still yelling at Lori.
Yes.
But you don't know what he was yelling
I don't remember.
Okay. So at some point in time, Charles backs up. Lori comes out and they both go around you and towards the living room.
Yes.
Tylee comes out of her room with a bat.
Yep.
And basically they've made their way into the living room.
Yes.
So Tylee pokes her dad in the back.
In the front, in the
In the
chest.
front. Okay, so
Or stomach,
she's
yeah.
come around this way.
Yeah.
Okay, so she's come around.
So this is Tylee, and that's Charles.
Okay, so she pokes him in the back,
Yeah.
or in the chest with the bat.
Yeah.
You know how many times about, or?
Just once, and
Just
just
once.
grab the bat.
So he grabs the bat, takes it away. You come towards him.
Yeah.
And then what happened right after that?
He shoved me and spun me around,
Okay,
and then cracked me in the back of the head.
cracked you in the back of the head. He hit you one time?
Yeah.
Okay, so you go back to your room.
I stumbled forward, yeah, and then I went back in there.
Did you fall to the ground when you got hit with the bat?
No, my head bounced.
Okay, so you go back to your room.
Yeah.
Get the gun.
Yeah.
Come back to the living room.
Yeah.
Now, Tylee and Lori are gone.
Yep.
And,
It's just me and Charles in the living room.
okay, and Charles, what's he doing again?
He's got a bat,
Okay,
and he's looking at me, and he's going, "Wha-" and I told him, I said, Charles, put that bat down. And he goes, what are you gonna do about it?
how are you holding the gun when that happened?
Holding it right
Okay, so
at
you
him.
pointed at him.
Yeah.
You tell him, Charles, put the gun down,
Yeah.
or put the bat down.
Mm-hmm.
And what did he say?
He's like, what are you gonna do about it?
Okay,
And then comes at me.
okay. And then you fire a couple times.
Yeah.
But you're not sure how many. You know it was more than one.
I'm pretty sure it was 2,
Two? Okay, 2 shots. Where were you aiming on his body?
just center.
Okay, so you're pretty sure 2 shots center mass.
Yeah.
He falls to the ground. You don't see Lori or Tylee anymore.
Correct.
You go to the kitchen, grab a rag for your head,
Yeah, toss some paper towels and wash my hands off.
and then go back to your room, put the gun down,
Yeah.
grab your phone,
Yeah.
come back to the kitchen and call in.
Yeah.
Okay.
And then they walked me through, I tried to do CPR.
Okay. Anything else that you can think of that I need to know, or that's important to this?
So that's all there is.
Okay. Trying to think if there's anything else that I need to know. I'm gonna get a tech out here to take some photographs of you, if you're okay with that.
That's fine.
So if you wanna hang tight for me, you need the restroom or anything?
I'm good.
Okay, all right, hang tight for me. I'll be right back. I'm gonna go have somebody take some photographs of your head.
Yep.
Put this back in there. All right, I'll be right back.
Thanks. Is there a bathroom? I want to. Yeah. We'll get you one. Bathroom? Yes. Okay. Thanks. Yeah.
Hello.
Hi.
I'm just here to take some photographs of you. I've got to do some swabs of your hands too,
Yeah.
and then of your injuries. Would you spell your last name for me?
COX.
And what's your first name?
Alexander.
And what's your birthday?
Well, I would say that's about the easiest last name to spell in a long time.
Come on, spelling.
And while she's getting stuff there, I'll just ask you some questions about it. So I see you got this on your, is that from today?
Yeah.
Okay. And you got something on the back of your head. Do you have any other injuries? You feel any bruising anywhere else?
I don't feel anything.
Okay. Maybe we'll take a look at his back.
Yeah, well,
Might have you take your shirt off and take a quick look and see if you got any marks or injuries back there.
Sure.
so I know you're hit in your head. Are you okay to stand up?
Sure.
Okay. I'm gonna have to stand up just right against this wall right here.
All right.
And then I could drain my bladder after this.
Yeah, absolutely.
Okay,
then we'll
so
get
go face me first.
What's that?
So
Face
turn and
us.
face me
Oh.
first. Basically, I'm gonna do a set of overall photographs, and then we'll do your injuries one by
Okay.
one, okay? And then I'll swab your hands, and it won't take that long. Just look right at me.
Now, were you, these are clothes you were wearing at the time of everything? Okay.
Okay, look right at me. Okay, turn and face that way with your whole body.
There we go.
Face the wall so your back's to me. Turn to your right. Okay, face me again. All right, and then if you
You know
put,
what's sad when you're posing for photographs and you don't have a good side?
put your hands like this. Okay, lower them just a little bit, so you're tilted down more.
Okay.
So you're like this, tilt.
Oh, hands
Okay,
tilted.
Yeah,
Okay.
so you can stand up
All right.
straight. There you go.
Turns out we can move the camera around.
Okay, and then palms up. Okay, so I'm gonna swab your hands right now,
Sure.
just so that
Yeah.
I'm not manipulating so much.
And then, yeah, as soon as she's all done here, I'll get you into, we're gonna, next we'll take some pictures of each of your injuries. We'll check your back out and I'll let you go use the restroom and I'll get you a new water. Or do you want soda or anything?
No, I'm good.
Okay.
Water would be good after, but
Okay.
Not before.
Face mask, do you?
What's that?
Do the face mask?
Yeah.
Okay.
Yeah, absolutely. I am a full service shop.
Thank you.
You're welcome.
that's either PPE or she's Chinese.
Maybe I'm feeling sick. No, I've been sick.
Knowing her, I'm gonna go with sick.
You never know. We all have a little piece of everything, and that's right.
No, around here, we come in contact with so many different people. And then everyone's got kids.
Yes.
And then you next thing you know, one person's sick, and it could be in the middle of summer when there's nothing going around. And within a week, everyone's sick.
Yeah.
This is more just so I don't have my DNA on your
Very good.
swabs. I just don't need to have that mixed in there.
I miss the old days when I wasn't in the office. I was out in the field. Then I knew that I only had to deal with the people I was coming in contact with, not all this going on.
Yeah.
Is that your house down there?
No, I live in San Tan Valley.
Oh, okay.
No, it's my sister's house.
Oh, okay. I was like, that's a pretty nice neighborhood. I've never been in that neighborhood ever before.
It's a maze, isn't it?
Oh, yeah. I had to sit forever to try to get a code to get inside.
I took Google Maps and I'm like, you're still not taking me where I need to go.
Everything south of Queen Creek is like that down there. When they built all those neighborhoods in the early 2000s, it was more aesthetically pleasing if it was circular and the roads didn't go straight.
Meandered and nobody could get in or out
Yeah.
without a Sherpa.
I grew up in the North Valley where everything's straight lines, but not down there. You can put that on. That one, relax it.
Okay, this way.
How far out in St. Tan are you?
Combs and Ironwood.
Okay.
They finally finished Combs and Riggs. It connects.
Oh, wow, about time.
15 years too late.
Yeah, yeah.
They shut down Rittenhouse for a month to do that exchange of Combs and Rittenhouse.
Uh-huh.
You know, where it's a stupid
Yeah.
one lane left turn.
Yeah, if you want to go up to the pork shop.
So they shut that down for a month to do this redo on this road.
Of course, the one area where most of the like tourist traffic for over in there is the worst traffic.
Oh, yeah.
Yeah, we shut that down. And
Federal Drake, Madam Young Robert, 7765.
that's Pinal County, right?
I think so.
Yeah, that would explain it.
Okay, I'm gonna do a swab of the inside of your cheek. It's just to get your own DNA
Sure.
that way. So you'll just open your mouth. I'm gonna take the swabs, rub it on the inside on both sides.
Sure.
Okay. Good. Okay. All right, let me finish with your photographs.
Sure.
So on the inside of this hand, there's no injury, right? That's
Right.
just dry blood.
Yeah, that's
So
Charles's.
that's new. Okay, so if you can just put your arm like this.
Yeah.
Okay. Do you know what that one's from?
This,
This one?
when we scuffled
Okay.
on the Sunday.
Okay, just put it back.
Mhm.
Okay, this one. Is that just an old scar?
Yeah.
Okay.
You know that? Okay.
Isn't that his desk? Go back, yeah, see something?
Yeah, and no injuries on the top of your hands at all, right? Okay. Nothing else hurts on your arms?
Nope.
So the only other thing is the back of your
Yeah.
head? Okay. Does it hurt only on this side or on this side too?
No, just on the,
Just
just
where
right
that
there.
actually
Yeah.
is? Okay.
Yeah, it's just pebbles and I got those ugly red moles.
Okay. I just wanted
Looks
to
like
make
it's
sure
a
that
little-
wasn't another,
I don't-
another mark.
I don't know, I can't see the back of my head, so I'm sure it's not pretty.
No, actually, your haircut's pretty decent.
Except that,
Boy, so you're still thinking. Except for the lump there. Man, that was fancy.
Just a little bit.
Mhm.
Helps when someone's taller, you try to get more level to where they're at.
Yeah,
Not everybody uses this.
I've never seen it used before.
I do it all the time.
No, it's fantastic.
step stool?
I have a viewer on my camera, so I can.
Oh,
hold
nice.
The camera.
Yeah, yeah.
I was just saying, I've never seen this.
I've got the adjustable LCD on my Sony.
Okay.
They're really nice.
Yeah, it makes you be able to see different angles without having to.
Yeah, you can shoot crazy angles and still see what you're doing. You don't have to have your eye behind the camera. It's really nice.
It's not perfect for me, so.
Yeah.
All right, I'm gonna have you sit just so I can do a couple more.
Okay.
That one is like the other one's maybe I should get out of it because it's heavy to hold those.
Especially when you're holding up at an angle like that.
It'll be exciting when they switch to the new mirrorless. Those things are light.
My wife has one of those.
I love that thing. I just got one 6 months ago.
You said the Sony?
Yeah, the A7 III.
I think she has the A6 something.
Right. That's 600?
Yeah, I think that's
6,000. I think
it's more than. It's like, she doesn't let me use it.
Let me get your shirt.
Sure.
I just know what it costs.
Yeah. I own this one at home and this is an expensive can.
We even also use it commercially too.
What's that one?
This one is the 700s or
Nikon.
750.
Oh, the D750. Oh, those are really nice.
So it's full frame.
Oh,
It's
yeah.
really nice.
It's 32 meg. That's good resolution.
So I'll have you stand up. I think we want to check under your shirt.
Yeah,
Sure.
Can I take my shirt off?
Sure.
Let's see. It was spin around.
Normally a little red right here.
Yeah.
Okay, just normal. Okay.
And just take a photo.
Just want to show. I'm just gonna take
Sure.
a photo that there's nothing there.
No, I don't see anything.
Okay, and then face me.
Obviously, if you later on
Yeah.
realize or feel you got a bruise
Sure.
forming, it may not be visible now, let us know and we'll get a photograph of it.
Okay.
Okay, so like I said, your neck's pretty red, but that's normal, right?
What's up?
I just want to make sure, so you're pretty.
Yeah,
red
that's
there.
more from driving when the sun's always on my
It's just
neck.
the
Yeah,
sun, okay.
we can't
Just
ever
wanna
get
make
enough
sure.
shade
No.
driving the truck.
All right, so
That's it?
that's all I need, right?
Come on, let's go.
Yes.
Okay.
Thank you. My daughter. Good to see a smile on your face, sir. Good.
Sorry about
That's
sorry
all right.
about that. Thanks for your patience.
No worries.
All right,
It's
so
fun staring at nothing.
just want to kind of go back to a couple things
Yes.
real quick.
Yep.
Your sister had mentioned something kind of historically. I guess she said she just recently moved back. She went to Houston or somewhere, and then recently moved back about 3 weeks ago. She was saying something about Charles texting your other brother. Is it Andy?
Adam?
Adam? Do you know anything about that? Okay.
No.
So I'll kind of walk through an order.
Sure.
When the argument initially came your way, you said you were on the phone?
No.
Okay, you were just in the room?
Yeah.
Okay, I thought you said you were on the phone.
No.
So you weren't on the phone with anybody?
No, my
You
phone
were-
was in that room.
Okay, your phone was in the room, so were you?
Yeah.
And then they came your way?
Yeah.
And then you're not sure where Lori and Tylee were when you came
When
back?
I came
with
back
the
out,
gun?
that's correct.
Okay. Where was your gun at in the room?
It was in my bag in a case at the foot of the bed, so the
Okay.
bed was here, and then the gun was here in a case.
Okay, inside like a duffel bag or something?
Yeah, it was like a zip, a little orange bag,
Okay.
and then my case was in there.
Okay, is it the hard plastic?
Yeah, the hard
case?
plastic with the foam and the extra clips and everything.
Okay. Is there a reason you spent the night there last night?
No, not really.
Okay,
Just hang out. We were gonna hang out today.
okay. Did your sister ever tell you she was concerned for her safety or well-being for Charles coming there?
No,
Okay.
but watching him interact with her, I was.
Okay. So, do you normally carry a gun with you?
Yeah.
Okay. But you didn't have it on your person during this?
No.
Okay. When we talked about Tylee basically having the bat, Charles taking the bat
Yeah.
away from Tylee, you said there was a struggle after that.
Yeah.
What happened?
I grabbed
to
her
the
from
best-
behind,
Okay.
and then we went to the ground, and then we separated, and he hit me, and then that's when I left.
Okay. So you grabbed him from behind.
Yeah.
And how come you grabbed him from behind?
Because he was in front of me, and he was going after Tylee with the bat.
What was he doing with the bat?
He just grabbed it from her, and then I jumped in. I don't know what he was
Okay.
doing with it.
So he was going after Tylee with
Yes,
the bat,
yes.
and you grabbed him from behind,
Yes.
around the neck, or
Over the shoulder like this.
okay, you grabbed him from behind.
Yeah.
You pulled him back, and you guys
I
both
pulled him
went
back,
to
we
the
both
ground.
went to the ground, yeah.
Okay. Did you see him swing the bat at you?
No.
Okay. So you pulled him to the ground. You got back up.
I got back up, he hit me in the back of the head. I don't know if it was with the bat or not. I assumed it was, because
Okay.
he had it.
Okay.
So
he hit you at the back of the head.
Yeah.
And you go to the room.
Yep.
Okay. And you don't know where Lori or Tylee are when you go back to the room.
Correct.
Okay. You come back from the room.
Yeah.
And you basically get, you initial or mark kind of here on this corner.
Yep.
That you're basically at the corner of the living room.
Well, this is a hallway here, so there's like a wall here that divides the kitchen.
Okay.
So I'm somewhere in this area.
Okay. And he's in the living room.
Yes.
And he still has the bat.
Yes.
Is he now focused at you, or is he
Yes.
focused at Lori?
He's
Or
focused at me, and he's
Okay.
yelling at me, and then he moves towards me.
what was he saying to you? Do you remember?
Not really.
Okay.
I just remember yelling.
Okay.
And then I was watching more body language. And when someone aggressively comes at you,
Okay. Are you, do you have your CCW?
Yeah.
Okay, so so he's basically coming at you and he's yelling, you're watching his body language.
yeah,
And you said you told him, and I didn't, when we're talking, I'm trying to not take notes and listen to what you're saying.
I'm trying to calm the situation.
Okay,
I'm gonna drop your bat, and he's fuck you and whatever
Okay.
coming at me. And
did you ever tell him to leave, or did you say drop the bat, or,
first I just said drop the bat.
okay. And then did you say anything else after that?
I didn't have time.
Okay. So he came after you with the bat, and he's
Yep.
kind of holding it in his
Yeah, I
hand.
got in his right hand.
Okay. You fire a couple times.
Yep.
And then you go to the kitchen,
Correct?
and then back to the bedroom.
Yes.
Okay. When you went back to the bedroom, you washed your hands.
No, watch
Or, I'm sorry, you washed your hands in the kitchen.
Yep.
You put your gun back in your room.
Yep.
Where'd you set it at?
Just on the floor.
Okay, so you set it on the floor. Get your phone.
Yep.
Call 911.
Yep.
And then when did you realize Lori had gone? Did you call her?
No.
Okay. So you called 911. Did you have to do CPR on him?
I did.
Okay.
I tried.
Okay. But you weren't on the, I must have mistaken you. I thought you said you were on the phone when
Oh, yeah, no.
did you hear them arguing about his phone?
I don't. All I heard was her say, "Don't touch me," and then him
Okay.
coming right after her.
Okay. You said that a couple months ago, Tylee was at your house and he came over. What happened? Tell me a little bit more about that.
He was going insane trying to locate Lori because Lori wasn't talking to him.
Okay.
They had split up. So he was bugging everybody in the family, blowing up their emails, phones, just sending text messages, just anything he could do to try and get somebody to tell Lori to contact him. So he was just spazzing out. So Tylee and I were pulling up to my house and he followed us and then he sped up and blocked my driveway. And he got out and ran up to me real aggressive, like he was going to do something. And he just stopped and talked. And then Tylee got out and yelled at him. And then that lasted, I don't know, 15 minutes in the front.
Okay.
A lot of screaming at Tylee at Charles, and Charles trying to leave and her not letting him because she wanted to get everything out that was bothering her.
Okay. So he didn't go after Tylee at that time?
Physically, he did not do anything.
Have you spent a lot of time around Charles?
Yeah.
Is he hot-headed?
Not normally.
Okay. So have you ever, besides the argument between him and Tylee, have you ever seen him like you saw him today?
No.
Okay.
No.
How would you describe him today?
Very aggressive.
Okay.
Physically aggressive. Going after Tylee, going after Lori, going after me.
Okay.
I've never seen anything like that. I've never seen him behave like that. I was shocked.
Okay. How long have they been together?
15 years, maybe?
Okay.
Oh, a good while.
And did they live here before?
Yeah, they lived here a couple times.
Okay.
They lived here. They lived in Austin. Then they moved. And they moved to Chandler. Then they moved to Hawaii. And they moved back here. And then I think they split up. And then she went to live with in Houston for 2 months, and I wasn't working out. So then she came back here and got a place.
Okay.
And then he had just come back out here.
And he got a place, or she came back out here and got a place. How long ago was that?
I don't remember.
Okay.
Within 2 months.
Okay. So the last couple months. But she never said anything about having you come over because she didn't feel safe with him or because he was showing up or anything like that. Okay. Is it normal for you?
She had expressed that he had threatened her in some email and text messages.
Okay.
Saying he was going to stop her or destroy her or something to that effect.
And when did she tell you that?
Well, I don't know. A couple weeks ago when she got the text.
Okay. So that was a couple weeks ago.
Yeah, we talked about it, but it wasn't anything.
Gotcha.
On
So
the top of my head.
you weren't under the impression that she had you there to make sure that he was, didn't cause an issue or anything like that.
Mm-hmm.
And you had the gun, so you didn't bring a gun for that purpose.
I always carry it.
Okay.
I had my other gun in the truck, and my niece just gave me a gun. I thought we'd maybe go to the shooting range, because my niece gave me a 380.
Okay.
She didn't want it anymore.
Gotcha.
So I was going to take it for my sister because she's got tiny hands. I was going to let her shoot it.
Okay. Just recreational for sport, not because
Always,
you needed it for
no, targets.
Self-protection or anything.
No, I never considered Charles to be violent or a threat before today.
Okay. And when you grabbed him, when he was going after Tylee and your sister, you grabbed him around the shoulder, you yank him to the ground, but you never saw him swing the bat at you at that time.
Correct.
Okay. When you got up, what happened right after you got up?
Well, we went to the ground and separated, and then I was getting up like this, and just my head bounced.
Okay. So as you were getting up is when you felt the strike to the head. And then you got up. What did you do? Did you go?
I just went straight to the room.
Okay.
Because I said, hey, this needs to calm down.
Okay.
And that's what I was hoping would happen.
So when you got back with the gun, you were assuming that he was gonna.
I thought he would back down at that point.
Okay. And he didn't.
It did not.
Okay. Anything else you could think of that I need to know that we haven't talked about?
I can't think of anything.
Okay. You don't need any medical attention for your head?
I'd like to get that cut cleaned up.
Okay. I think we're almost done.
Yeah.
So if we're almost done, we'll probably get you and Lori and Tylee back to the house. You won't be able to go in.
Yeah.
because we're, working as
Sure.
a scene.
Absolutely.
How did the injury on your arm happen?
I'm guessing somewhere in the tussle.
Okay. Were there any strikes thrown besides you getting hit in the back of the head?
No, just me shoving him.
Okay. And that was initial in the bedroom?
That was when exactly.
Okay.
That's when I got involved.
Okay. And then the only other time we got physical with anybody is when he was going after Lori and Tylee, and you grabbed him around the neck.
Correct.
Dragged him back, and you both fell to the ground.
That's correct.
Okay. No, we're just running a criminal history to make sure that you're not a prohibited possessor, so there's no felony convictions. No.
Correct. There was a confessed felony, aggravated assault.
Okay.
In Austin, Texas in 2007. I think.
Have your rights been restored, or are you legally able to? So your rights are restored, you're
all done.
Able to possess a
I was
firearm?
never convicted.
Oh, okay.
Pled guilty, but they had deferred adjudication in Texas, so I completed probation and then.
Gotcha.
That was that.
Okay, so it was an open-ended thing, so it's a
Yes.
misdemeanor now.
Well, whatever, it's just on there as a, whatever, I don't know what the technical record is.
Okay.
I know I went to court and she said, all your rights are restored, and gave me the paper and I'll find out.
Gotcha.
After 4 years.
All right, hang tight. I'm gonna go see if they're done with Lori. We'll get you guys all together so we can get you out of here. And just make sure that the people that are monitoring don't have any other questions that I need to ask.
Sure.
Okay?
Yeah.
All right, thanks. I appreciate your patience, man.
No problem.
You go by Alex or Alexander?
Yeah, Alex.
Alex? All right, we're just gonna walk over and we'll go where your sister is.
Sure.
Here's that. Oh, is that what you were wearing when all this went down? Okay, just make sure. There you go. Yeah, there's one back here.
All right. So I think, yeah, that is it. That was it to the interview of Alex Cox. After the incident that happened with Charles Vallow. So court is still on break for us. They are back in real time with a half an hour, but yeah, I found that actually quite interesting. I'm not gonna lie, how the story, it was a bit weird because the way he was describing, how everything happened and everything, it was a little bit weird. I'm not gonna lie. So sorry. I'm just trying to set up. I don't know which one we're gonna use feed, but it depends on which one is like more ahead. I am not sure about that, Maria, that if he was before or after. I mean, I can like a quick Google search. Was Brandon Bordeaux? I don't even know how to do that. Lori Vallow. Let me see. Let me have a look. When did that happen? So right, was in October 2019. So oh yeah, absolutely. So the Brandon Bordeaux situation apparently happened in October 2019 when Charles happened in July of that same year of 2019. Brandon Bordeaux happened in October, but before Alex died. Yeah, exactly, before calling 911. And I mean, I was like, I I think they did not had enough evidence to prove that wasn't oh, it was not even typing. This keyboard sometimes. When did Alex Cox die? Because I want to know. December 2019. So July. No, of course, no worries, Maria. So July 2019. Alex Pew Pew's Charles Vallow in self-defense. October 19, the Brandon Burdo incident happened, and then in December 2019, Alex, um, well, was deleted from the face of the earth. So, yes, Charles was the first one to go. Oh wait, no, hang on, no. Oh my days, there's so much happening. Hang on, when did Tylee and JJ happen? Um, because now where do they fit in that timeline? Kylie, Ryan, when did it? Okay, so new line, yes. So Charles was first. Kylie and JJ was September. Then we had October Brandon, and then December we had Alex. Yeah, it is nearly time. Journeys indeed. Um, thank you for, yeah. Well, I did not did that to no one, just to make sure. um. So, my days, this is confusing. Oh yeah, Tammy. Hmm, hang on, when did Tammy? They were busy. That is for sure. Tammy, Daybell. That was her name. My days, like they were indeed Tammy Daybell. Yes. She was October as well. All right, new conspiracy, new thing. Charles, JJ, Charles, JJ and Tylee, Tammy, Brandon Burdo, and then Alex. So this was crazy. So first one was Charles in July 2019. Then was JJ and Tylee. Then was Tammy Daybell. Then was Brandon Burdo, the attempted, and then Alex went bye bye. Who is confused? I am. Um, like this. This is crazy. I. I. Joe Ryan. Who's Joe Ryan? Who's Joe Ryan? Am I confused? Who is this new person? New character unlocked? Oh, let me Google who's Joe Ryan. Like this is a lot of players in one case. These dudes are even crazier than I thought. Joe Ryan, Lori Vallow. Who is Joe Ryan? Oh, as an ex-husband? Oh, it's another plotted. Oh my days. Jeez, Louise. She and tried to delete him out of this world. Um, so was she charged about him? Well, I think yeah. They well, that's that's the assumption, yes, that oh, we have a feed. We are about 10 minutes away. Um I I don't know what Nancy like right now I don't know anything. So this is just weird. Uh this case is just too weird. Like I mean, um it's just wild. Because who's so Joe Ryan, where did Joe Ryan fit in this whole story? So everything starts with him. Oh, she got it. Oh my days. This is more complicated than I was actually thinking. I'm not gonna lie, you guys. Um, there's like so many players in this case that it's like of who's who craziness. Oh, And this would be the perfect trial to do a family tree to like whew, absolutely understand this craziness. And I'm finally starting to feel the cold, which is good. Um, but um, I just don't know. This is too crazy to even think about it. Wow. Oh, so he wasn't alive. Oh, I know, Nancy. Can you imagine if they find her not guilty? Which is not gonna happen. I'm just saying. Oh, I will link you to call for sure. Hang on, come doing it. There we go. Then, um, it's just wild. Like I should have done a better homework on this. Uh, that mm, that's the thing. Hello, hello, hello.
Hello, hello, hello.
How are you doing? Sorry, I
I'm
was here.
well. Okay, let
Yes,
me
go ahead.
clear let me clear things up. Joe Ryan is Tylee's biological father.
Oh, okay.
So Joe Ryan is also Lori's third husband. So she married a guy right out of high school. They weren't even married a year
Mm.
and were divorced. Then she met husband number two, who I can't remember his name, but he is Colby's biological father. They divorced, and right after Colby was born, and she told him that if he would sign away his rights to Colby, she would never ask anything of him, and he did. So he signed away his rights. Joe adopted Colby. So that's why
Yeah.
Colby's last name is Ryan. And
Oh.
then they had Tylee together. If you caught right at the very end of Alex's interview that we just watched,
Yeah.
he was talking about the charge that he did 4 years of probation for in uh, Austin, Texas.
Oh, so where was
That was
that what
because
he was talking?
he tried to kill.
Oh?
Um, he tried to kill Joe and got caught. Joe died about 2016, 2017. They say he had a heart attack.
The same way Alex died by natural causes.
Right.
I think I think he wanted Journeys wanted to say 2018, but she put 2028. So I think he died in the future. Just a joke. Sorry. In chat. Never mind. Just me being funny.
Hold
You
on,
can
my
hear me.
Bluetooth my Bluetooth disconnected. Hold on. Really?
Okay, just technical difficulties on the side of Denise. Yeah, sorry, I saw that Journeys that 2028. Well, it's in the future analyzing. I wouldn't be surprised that Laura would be able to do that. Um, people are saying you sound better this way. Are you connected again? I don't know. Are you? Can you hear me? Can you guys hear me? Yes, indeed, Journeys. You better be faster. I can't
Okay.
hear you.
I'm gonna
Oh,
hang up. My Bluetooth is died and I can't hear a thing.
Oh no! Hopefully resurrect soon. Well, not that you
But
can hear me, but
yeah, I'm gonna plug it back in for a couple minutes, but hopefully that cleared everything up.
yeah, yeah. No, we can hear you though. But yeah, absolutely, it's absolutely did clear up. I really, really appreciate that and helping me because I never know anything.
That's right, because you don't speak English.
No, I don't. ¿Qué? No hablo inglés. No.
Okay, I'll see you guys in
But
chat. I
I
just wanted to clear
see
that up for you because y'all were going crazy.
I'm still it's confusing. It's too many people in this involved in this thing, man.
Yep.
But
Yep.
yeah.
Okay.
But thank you very much
See you
for
in
coming
chat.
up. I'll see you in chat. Bye.
Bye.
All right. Thank you very much, Denise, for calling in. So, if she ever got, there will be more. Oh yeah, definitely. I absolutely agree with that, Nancy. Absolutely. Kobe was not. Oh, okay. Maybe isn't. Yeah, he was giving the names kind of as if he was adopted, so it's not here or there. But thank you for that for the clarification. But yeah, um, well, too many plays in this case. So, and I think if Lori gets the not guilty on this case, which I don't think she's gonna get, it's gonna be she's I think she's gonna say that she feels like vindicated somehow, that like they were trying to pin to pin on her things, and she's going to try to get her Idaho conviction overturned. I think they are supposed to be back in about 2 minutes, Nancy. So they already are live, but they are not back yet in court. So this is what the court shows at the moment. Well, at least this feed. Let me have a look. Other feeds, no, other feeds still don't show anything in any anyway. So still all just this. So in about 2 minutes they should, 3 minutes max, I don't know, it depends on how they were actually late or not, but I can see heads rolling around in court. So yeah, so since because I actually I thought that interrogation was gonna be actually the 2 hours that it said it was gonna be, because obviously it was a 2 hour long, but of actual interview was only a few minutes. Is that what I think that's what she's gonna say, because on her openings, right, Laurie said the evidence will show about 500,000 times, right? And now she's gonna have to say evidence showed that basically what Nancy is saying, I did nothing wrong and I'm not a wacko. um Evidence did show that I'm guilty as, yeah, I know, absolutely, because that's what she was saying all the time. It's like the evidence will show, but I did, the evidence did not show anything what she said, but in my opinion, but we'll shall see the disclosing. I hope she doesn't do that for the whole closings. I will absolutely be very annoyed if she does. Um, but yeah, so remember that you have until the end of closings to play or change your verdict for the verdict game. And in terms of clock, we're gonna have a clock. Um, our verdict watch might be a little bit laggy because I'm gonna have to do it from my own computer and not Garden Bot's computer because it's not working, and I really want to have the clock. So but I'm sure it's gonna be fine. Evidence shows that everyone thinks I'm guilty but me. Yes, definitely. Absolutely. She's in the Delulu land. A state will object so many times. Well, we can guess. What's your guesses? Either objects, the state objects, or Lori objects. So it's I think it's gonna be both of them objecting, and well, I don't know if Lori knows how to object without the council saying, but okay, that's a good guess. 4 times. All right. I think I don't know. the openings were kind of smooth. So state 15 objections. I need to write this down. And then we'll see. Oh, I did this in the wrong paper. Ah well. So objections. Objection. Daisy 15, Journeys 4. Right. Lori 76. That's state. Laura's gonna be 76. Right, I like that. Depends on. She said it's gonna be less than an hour. You know, you're joking. That is a great joke. She says she's gonna be less than an hour. The state said that they are gonna be about an hour long. So uh and she said, oh, I'm gonna not take that long. So I think she's gonna take about an hour. So this fate is still far behind, man. Gonna have to do this one.
Go ahead and get the jury lined up, I guess.
Well, apparently something is really strong. Maybe the smell. Ooh, courtroom seems packed. That's wow. Did you guys see that? The courtroom seems very, very packed. Which is good because everyone is there to watch her go down. Oh, it's fine. I can't spell half of the day. Oh, I know. That was funny.
All right, the jury's now present. Please be seated. This is time set for closing arguments. The state can proceed with its closing argument.
July 18th of 2019, just 7 days after this defendant and her co-conspirator Alex Cox shot and killed Charles. This defendant texted her soon-to-be next husband, Chad Daybell, about Charles's life insurance policy. Her words tell us that she was involved in this killing. Her actions and her words of texting Chad Daybell tell us the motives behind this murder: Chad and money. The morning of that 18th of July, Lori Vallow texted Chad and said, quote, "I just got the letter from the insurance company saying that I am not the beneficiary. It's a spear through my heart. Who do you think he changed it to?" Later that day, after she spoke with the life insurance company, she sent Chad another text. Quote, "So I talked to the insurance company. He changed it in March. Probably it was Ned before we got rid of him." Lori Vallow's words 7 days after Charles was shot and killed tells us that we was her and Alex killing Charles. Why? For that money. But Lori Vallow's plan to kill Charles wasn't just known by her lover, Chad Daybell, and her accomplice and co-conspirator, Alex Cox. It was also known by her brother, Adam. Adam told us that he knew about Lori's beliefs. He knew what she had been saying about Charles's concerns for himself. And he told us that he knew about this plan for an intervention to talk to a stakeholder. That morning of July 11th, when Charles arrived at Lori's house, as she knew he would, he texted Adam and said, "Al is here." Adam texted back, "They are planning something." He knew. And 3 days later on Saturday, when Adam finally learned, when his friend Googled Charles, that he had been shot and killed by Alex, Adam told us he went back and talked to his mother and he confronted her about this. And he told his mother, Lori and Alex conspired to kill Charles. He knew, and he was right. Lori's ex-friend, Christina Atwood, she told you about that very uncomfortable dinner on June 9th, a month before the murder, where Alex Cox was talking about just wanting to kill Charles. He said this multiple times, and this defendant didn't care. In fact, she talked about how she had been drugging Charles. Christina told you she was so disturbed by this, she actually went and saw Lori the next day, June 10th, and told her, if something happens to Charles, I'm going to have to go to the police. Christina knew. She was right. And Nancy Jo Hancock, now she had just met Charles a few days before, and they had talked and texted and had been on the phone for hours, you heard. Charles had told her all about Lori, the things she was saying, the things she was doing. She told you that she knew that Charles was concerned for his own safety. And she understood the motive. She told Charles the night before, you probably should just tell Lori that you've changed the beneficiary, that she's no longer going to get that money. Nancy Jo knew, and she was right. Lori Vallow wanted the $1 million, and she wanted Chad Daybell. And she and Alex used that twisted religious beliefs they had so that they could kill the evil, possessed Charles and be like Nephi. The evidence that has been presented in this trial will prove to you beyond a reasonable doubt that this defendant is guilty of conspiracy to commit first-degree murder. So I want to split up my closing into 3 sections. First, I'm going to talk to you about the timeline and the motives in this case and the evidence that supports those. Second, I want to talk to you about the jury instructions and the evidence that's been presented to you in court. I'll remind you that anything the defendant said in her opening was not presented at trial through a witness or through an exhibit, and it is not evidence. Using the evidence that has been presented and admitted at trial, the state will show you how, again, the defendant is guilty beyond a reasonable doubt of this crime. And finally, I'm going to talk to you about those justification defenses, the excuses and the reasons why the defendant would like you to believe that they had a valid basis for shooting and killing Charles on July 11th. And we'll talk about how, in fact, there is no justification for what they happened. What happened that morning was a first-degree premeditated execution of Charles Vallow. So let's go through the evidence. The timeline really starts, and we know it goes back much further than this, but the big change occurs on June 29th or 30th, when you learned that Charles Vallow learned about these KK Walker emails. He learned about that affair with Chad. Now he knows Lori is cheating on him. We know that he contacted Chad Daybell about it. He contacted Chad's wife about this. He told Adam about it, and he told the defendant about it. So everyone knew that Charles now knew this. July 9th is now the first time that Charles is going to be coming back to Arizona. We know from the time he learned about that affair, he hadn't been back until this planned visit to see his son, JJ. We know at 1:13 p.m., Charles texts Adam and books him a flight for the next day. At 1:21, we know that Adam is contacting Alex. And they talk for 20 minutes. And Alex lets Adam know, sure, you can stay with me. Of course, Alex doesn't know the plan yet, the mission. Lori then starts talking to Chad Daybell. We know that she knows about this intervention. She knows about Adam coming. And we know this because, again, of her text messages. We see Lori then starting to round up the troops. Why does she do this? Because she wants to ensure that on July 11th, it is Charles and only Charles coming to the house and not the intervention of Adam or Brandon or Zach coming over to help him. So she has Melanie. Tells her she can't go to this wedding. She has to stay here. It's coming to a head. This week will change everything. Call me. Then we have July 9th, the text messages with Alex. She tells him, so the plot thickens, call me when you can. He doesn't call her initially. So she sends him another message. This one really letting him know. She specifically tells him, I'm going to need you to stay close to me the next couple days. Mel too, she can't go to Utah. She's got a job. They are planning some kind of intervention, but want Mel out of the way, so I'm left alone. She talks, I need to come get the stuff at your house tomorrow and secure it. Lots to do. Thank you for standing by me. It's all coming to a head this week. I will be like Nephi, I am told, and so will you. And then what happens? This gets Alex to call, and they talk for almost an hour. An hour planning how they're going to stop the intervention, how they're going to be like Nephi. As we get to the 10th of July, and we continue through this timeline, we see Lori again talking religiously with Chad. 149 minutes that morning. She's also texting Melanie Boudreau, Melanie B, telling her that it's important for the mission, for Melanie to help her by keeping Brandon distracted. And we saw those messages where Melanie says she'll pretend to be sick. We know that on the 10th, Adam arrives in Phoenix. And now we have Summer helping the defendant, letting her know what is going on with Adam and Zach. Everyone is covered to ensure that Charles will be alone on the 11th. We have the continuing talks with Chad, her soon-to-be husband. As we get into the 10th in the afternoon, we know that per their agreement, Adam calls his brother Alex. Hey, I'm here. Brother doesn't answer. He sends him a text. I'm here. No response. Why? Because the night before, his sister Lori told him, we have a mission. We must be like Nephi. Charles is coming into town. You must stay at my house the night of the 10th so you can be here the morning of the 11th. We also know that Summer gave Lori an out. Hey, you can stay at my house. No one will know where you are. We're going to be out of town. You can hang out here. Lori doesn't take her up on that. She has a mission to do. As the night grows on the 10th, Adam continues to try to reach his brother Alex. Again, no response. And by 45 or so minutes after that last text by Adam, we know Alex is already at Lori's house. He's there with his gun and a garbage bag of some underwear. Why? That gun is important. A loaded weapon, 2 extra magazines of ammunition with him. He is ready for his mission. And again, Summer is updating her, telling Lori that Zach and Adam are still at her house. They're going to go stay at Mimi's. And she even tells him that Adam is still waiting for Alex to get back to him. Still, he doesn't understand. Why isn't my brother responding to me? I was supposed to stay there. And again, what does Adam bring over? Gun and a garbage bag of clothes. That's all he needs to be part of the mission. When we get to July 11th, we still have Lori talking with Chad. We see those text messages going back between them. And then we start learning from the GPS from Charles Vallow's phone as he arrives. 7:35 a.m., he arrives at 5531 South Four Peaks. That's where we have at 7:36, Adam texting Charles. They are planning something. There is no reason why Alex should be there. And that explains why Alex wasn't responding to me and didn't let me stay there. We see that last outgoing text message by Charles Vallow at 7:37. And in fact, what we see is at 7:37 and 12 seconds, Charles sends out his last outgoing message. And at 7:37 and 29 seconds, there's an incoming message from Adam. It's not read until 12:13 p.m. What becomes important here is in this timeline, how long is Charles at the residence here? You hear in her interview how she says it's so fast. Charles comes inside. He's angry. He's jerky. And she tells him, take JJ. Go get him Burger King. They get JJ out to the car. And then she holds onto the phone. And this argument erupts, and it's just so fast. But what we know is it's actually 12 minutes long. This is not a fast incident. In this 12 minutes, Lori Vallow and her brother Alex Cox are doing their mission, and they are being like Nephi. We know at 7:49, it's over. Lori has left in Charles Vallow's car with his phone and JJ and Tylee. We know that there are 2 phone calls between Alex and this defendant after she leaves. As Charles is laying, dying or dead on the floor, 7:52, 8:06, they talk. 47 minutes passes before Alex calls 911. 47 minutes to stage the scene. The police are advised when they arrive that the shooting just occurred and that CPR was given. Why is that important? Because you heard even during the interviews, the police were trying to figure out this timeline. Didn't make sense. At 8:48, almost an hour later, Lori Vallow returns. And then we see that around 9:40, she is being interviewed at the Family Advocacy Center. We know that Lori Vallow has Charles's phone that entire afternoon. You saw the PowerPoint from Detective Werther showing that her phone by about 12:36 is already her phone, Alex's phone, and Charles's phone are all in the area of Alex's house out in Sandham. You see on her records that she again calls Chad Daybell. We see that Detective Enclan calls her and leaves her a message. They don't leave immediately because what do we know? We know at 2:13, Alex is taking photos of Adam's or flight reservations from Charles's phone. Not screenshots, but photos of the phone. At 2:18, Lori Vallow, who has not told Charles's kids, his family, about his murder, is calling the mortuary. A little bit after that, they still haven't left. She's calling Chad again. And then by 3:11, we know that Charles's phone, through the GPS data, is back at 5531 South Four Peaks. And when asked about it, the defendant and Tylee hand it over and provide the PIN. They have no problem on how to get into it. They've already looked through it. They don't need it anymore. That evening, Lori and Chad are talking all night. You can look through the exhibits and see the multiple calls of them discussing. These aren't calls to Charles's family. They're not calls to his kids. They're talking with her lover, her soon-to-be husband, Chad Daybell. So let's talk about the motives of this case. Money. We see that from the text messages and the anger that you see through them when she learns that that's been changed and she's not going to get it. Chad Daybell. We didn't go through those text messages, but you can look at them. They are already very romantically involved by the time that Charles is murdered. And it's clear that Chad knows exactly what's going on because he's asking her about the car, about the insurance. All of those things Chad knows. And then there's that religious belief system. The zombies, the Z's, the possessed evil spirits. And her being like Nephi. All a reason and a way to kill someone, just like Nephi, a justified killing. There's that first call when we talk about money motive. To Banner Life Insurance.
And what was the cause of his passing? Well, he was shot. Okay, so I don't know how I want to put that. Okay, all right. And I hate to ask, but is it? Yeah, you can just say yes or no. Was it a homicide? No, it was an accident. An accident.
So what we hear here is Lori Vallow being untruthful to Banner Life Insurance. We'll talk about credibility later, but it becomes very relevant that even in the smallest of things, this defendant exaggerates, minimizes, and is completely untruthful to various people. We all know that she was not the beneficiary. She didn't. But we also know that Charles Vallow was not accidentally shot. She told the police she was there. She knows that her brother intentionally shot him. Of course, they want to claim it's self-defense. There's no accident about that when you shoot someone twice. Motives for money. What we see again here is Lori Vallow talking to Chad about the motive. Telling Chad about the fact that it was changed. I just got the letter from that insurance company saying I am not the beneficiary. It is a spear through my heart. Who do you think he changed it to? Brandon? Or probably Kay? He left nothing for JJ. What do we know? Again, we see that Chad knows about all of these things. And what does he talk about in that morning as you have those entire messages? Exhibit 230. It would be interesting if he got changed after he had 2 bullets to the chest. Again, as we talk about the murder, we have later in that day the message that I talked to you about. So it was probably Ned before we got rid of him. We, not I, not my brother Alex, but we did. And then the other thing in this text message that is of importance is the fact that Lori Vallow knew a month before she went to Social Security how much money she was already going to get for the death of Charles. Here she says, I will still get the $4,000 a month from Social Security. When we talk about that motive and the anger by this defendant over not being the beneficiary, we know that even on July 28th, so 10 days later, she goes into Charles's computer to find the change of beneficiary form. She texts that to Chad to show him, and she sends it to Kay and confronts her about it. Money. That's what she wanted. And Chad. So let's talk about Chad. The affair with Chad Daybell. We know that she knew him as far back as November of 2018 when he came to Arizona and stayed at Lori's house. You were told by Detective Duncan that there were recordings on her Lori for Style iCloud account of Chad Daybell here in Arizona for that Preparing the People conference. You also heard that in the Lolly time, the later account that was created later, that in March of 2019, there were screenshots of flights to Idaho and back to Arizona with both Lori Vallow and Chad Daybell. This is during that time when she disappeared and Charles was taking care of JJ, and she's off flying to Hawaii and Idaho, living the good life with her soon-to-be husband. And then, of course, we know that come November 5th, she actually marries Chad Daybell. That KK Walker email address, this was that June 29th, big change. What do we know? That on April 21st, she created that account. She used her own phone number in creating it. And then she sent messages to Chad Daybell, brother Daybell. You have that exhibit. She pretends to be Karen Walker and invites him to Houston, because that's where she is at that time. She offers to use Charles's money to fly him out there and that he can stay at the house with her and her husband. In June of 2019, we see that Lori again uses that same account, but this time she pretends to be Charles and invites Chad out to Arizona to help him with a book. And again, in Exhibit 289, you have those letters. Charles finds those. And he lets everyone know he did. And he confronts Tammy, lets her know. Confronts Chad, lets him know. And he certainly lets the defendant know that he knows. And now the jig is up. We see in these text messages that were recovered from the iCloud accounts, whether they're under the Bubby context or under the Melanie 2 contact, this relationship between Lori and Chad. If you want to read the story, it kind of mimics them meeting in November, hooking up in hotels, and discussing their love for each other. When we are talking about a motive and a person who wants money and who has not worked for 13 years, who has had her husband pay for her homes, her phones, her cars, allowing her to go to the temple and work out and go to lunch in restaurants. This is a big change in life if she loses all of this. But if she gets $1 million, it's not so big of a difference, along with that Social Security she'll be getting. And then obviously we know that once Charles was out of the way, Lori and Chad were able to get married. But what about those religious beliefs? Everyone that Lori knew, who she expressed them to, told you that they were not in line with the Church of Latter-day Saints. Everyone told you that she said things like she didn't need to repent, she didn't need forgiveness, she could do whatever she wanted now, that she was in a celestial state, translated, that she is spiritually and physically changing, that she's above the priesthood, that she knew who was dark and evil. You saw those text messages, both about Charles and heard from people, as well as about Brandon and Zach and Adam. People who were helping Charles were also dark or Z's. And ultimately, what did we learn? That she associated herself with Nephi, a prophet, a holy man, who was justified and asked by God to kill Laban because he was an evil, wicked king who had the tablets that God wanted him to go get. Lori was just like that. She was justified in her killing. We heard from her brother, Adam, that their relationship had ended when she told him some things about her beliefs that he disagreed with. That she was turning into that celestial state, that she didn't need to eat, that she had more authority than the priesthood.
Yes.
You yourself personally, were you aware of Lori having outside? Lori having any beliefs that were outside of what is accepted by the LDS religion?
Yes.
Can you tell us what you were aware of that you knew to be outside the LDS religion?
Lori told me that she was in the process of translating from a mortal human being to an immortal human being, a celestial state.
That's something that the LDS religion supports?
I haven't heard of it in that it's happened here on Earth yet.
Serena Sharp told us about, again, the not repenting and Lori changing physically and spiritually. Members of the LDS Church.
Yes.
During this time, did Lori ever tell you things about her beliefs that seemed to go against what you understood or what you were taught through the LDS Church?
Yes.
Did Lori ever tell you that she did not need to repent?
Yes, she did.
During this weekend, did Lori talk to you about her husband, Charles Vallow, being possessed?
Yes, she did.
What do you recall about her talking about her husband being possessed?
I recall that she spoke about her husband being possessed by an evil spirit, and she named the evil spirit.
Do you recall what the name was?
Yes.
What was it?
It was Ned.
N-E-D? Ned?
N-E-D.
Now, Serena Sharp was someone who met Lori in November, texted or talked with her for a while, and then was invited to that girls' weekend. One of the jury instructions you're looking at, and we'll talk about more though, is the credibility of a witness. Serena Sharp has no dog in this fight. She knew Lori for a little while. She was invited to, I'll call it the inner circle. The defendant told her some things that went against her religious beliefs. And she said pretty much after that, the defendant stopped talking to her. Now, how do we know she's being truthful? Well, we see Ned in lots of text messages. This just helps tell us that this is something Lori was telling lots of people, that her husband is possessed by this evil spirit, Ned. And we learn later that, like Nephi, she can get rid of him. Do you recall Lori Vallow telling you that her husband Charles was no longer Charles, that he was now this possessed person?
Yes.
When Lori was talking to you about Ned, was she explaining that this evil spirit was now in the body of her husband?
I don't know if she used those exact terms, but that was the impression I got. Yes.
So the word she used expressed to you that idea that this evil spirit Ned was now in her husband's body.
Yes.
The other thing that Serena Sharp told us was Lori using that term zombie. You remember how upset the defendant got by her saying that. But again, why would Serena make up any of this? She has no reason to. What she recalls is that that is a term that this defendant used when speaking of people like her husband who were possessed by these evil spirits. We heard from Christina Atwood as well, the same concept that Lori Vallow repeatedly would say. Did she tell you, as well as the other women who were at this meeting in February, that her husband was possessed?
Yes.
Okay. So it wasn't just you in a private conversation?
Correct.
She was open about it?
Yes.
So again, we see this ongoing timing of Lori Vallow talking of her evil, dark husband, who she later is authorized under her religion to get rid of. We know as well from Christina Atwood that there is a progression of these beliefs becoming more deviated from the LDS religion as she is meeting with her between February and June when she finally hears those words. From the time you started meeting with these gatherings in February through to June, did you start to see sort of a progression of things that Lori was telling you that seemed outside of your faith?
Yes.
Did she make statements to you that you believed went against your religion?
Yes.
Did she at any point tell you that she did not need to repent anymore?
Yes.
What is that? What is that meaningful to you in your religion?
We believe that every single person outside of Jesus Christ has reason to repent.
Other than Lori Vallow, according to her words to multiple people. So let's take all of this, the motives and this timeline now, and talk about some of the jury instructions and all the evidence that supports proof beyond a reasonable doubt that this defendant is guilty. I want to start with talking to you about direct and circumstantial evidence. You have a jury instruction that tells you that evidence may be direct or circumstantial, that direct evidence is the testimony of what a witness saw, heard, or otherwise sensed, and circumstantial evidence is proof of a fact or facts from which you may find another fact. You're told the law makes no distinction between direct and circumstantial evidence. And this is relevant. The witnesses have often been questioned. Did you see, hear, or do that? What you are told is you can actually use circumstantial evidence to convict anyone. But let me give you an example of this. Imagine you are sitting on a beach. Just you, it's quiet. Off to your right, there's some rocks and you can't see around that. While you're sitting there, a person walks by, you watch them walk by and they go around the rocks and you can't see them anymore. And then someone runs up 5 minutes later and they say, hey, did you see someone come by here? You say, well, yeah, I saw them walk that way. That is direct evidence. You saw it. Now imagine you're on that same beach and it's completely empty. You close your eyes for 5 minutes. Just relax. Before you closed your eyes, the beach was completely pristine. And when you open them up, now you see footprints. You can see the toes facing off to your right, the heels, and you see them go all the way around the rocks there. Somebody again runs up 5 minutes later and they say, hey, did someone come by here? And you go, well, I mean, I didn't see them, but they must have gone by in the last 5 minutes because you can see their footprints. They went that way. That is circumstantial evidence. You can infer from that that someone went by and where they went. The burden of proof. The state has the burden of proof, as we absolutely should. So let's talk a little bit about what it is and what it is not. You're told that the burden of proof is proof beyond a reasonable doubt. And the instruction tells you that that leaves you firmly convinced of the defendant's guilt. You're told there are very few things in this world that we know with absolute certainty. And in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find him or her guilty. So I want to start by saying what proof beyond a reasonable doubt is not. It is not proof beyond all doubt. It is not proof beyond all conceivable doubt. It's not proof beyond all possible doubt, and it's not no doubt. You're told that there are very few things in life we know with absolute certainty. So just because someone says, what if? That is not a reasonable doubt. What you're told is it's proof beyond a reasonable doubt. As we go through the evidence and apply it to the crimes, we will show you that there is no reasonable doubt as to this defendant's guilt. So let's start with the crime itself. Conspiracy to commit first-degree murder. There are 3 stages in this, or 3 things the state must prove. 1, that the defendant or her co-conspirator caused the death of another person. Well, we know that Alex Cox shot and killed Charles on July 11th of 2019. Alex called 911. Alex indicated he was the shooter. He was the only one home. It was his gun. His credit card or debit card was in there with the gun. And we know that Lori told the police that her brother killed Charles. So we know that he caused the death of, so that. 2, that they intended or knew that she or a co-conspirator would cause the death of another person. When we are looking at this case, we are looking at the defendant's words, actions, and motive. The words and actions of having her brother Alex come over on the 10th with a gun so that he would be there when Charles came over to pick up JJ. The actions that day of taking Charles's phone, ensuring that he could not leave, that he could not take his son to school. The defendant told the detectives how angry and screaming Charles was about the phone, but she didn't just give it to him, throw it at him, tell him to get out, whatever you might do. She She held onto it and told the police that she walked away with it as he's trying to grab it. The defendant's actions and words show us that she is the only reason why Charles stayed in there and the only reason why Charles was shot. Then there's those 12 minutes. Defendant tried to pretend that this was a quick, angry scuffle. But Charles is there for 12 minutes. The defendant is there for 12 minutes. Alex is there for 12 minutes before she leaves. We look at her actions when she came back. She told the police her brother was hit in the head with a bat. She never asks how he is. She's not concerned about his injury. She's not concerned about her husband being dead on the floor of her house, her child now without a father. The lack of words that she said there and her demeanor show again that she was well aware of what was going on and part of this incident. We look at her words to Chad, that Charles changed his life insurance policy before we got rid of him. They show her intent to kill Charles. And again, we look at the motive, money and Chad. When did this happen? The first time Charles came back into town after he found out about the affair. Finally, the state has to prove that the defendant or the co-conspirator acted with premeditation. So I'm going to talk to you about premeditation. You have a jury instruction for it, and it tells you that the defendant or the co-conspirator intended to kill another human being or knew she or the co-conspirator would kill another human being, and that after forming that intent or knowledge reflected on the decision before killing. It is this reflection, regardless of the length of time in which it occurs, that distinguishes first-degree murder from second-degree murder. You're also told an act is not done with premeditation if it is the instant effect of a sudden quarrel or heat of passion. It's where you remember those 12 minutes and the calmness of her walking around with that phone and her demeanor. You're told the time needed for reflection is not necessarily prolonged, and the space of time between the intent or knowledge to kill and the act of killing may be very short. So I'm going to give you an example. It's a lot of legalese, and then we'll talk about what we really have here. So imagine again, you are driving your car. You do every day. And you're coming up to an intersection and you see the light turn yellow. And in that second you think, do I want to run it? Or do I want to slam on my brakes and hit it? Stop before I go into the intersection. You think about that, and then you decide, I'm going to slam on my brakes, and I'm going to stop. That is the time it takes to reflect. That is the time it takes for premeditation. But we have a lot more than this because we have planning, not just premeditation that morning. So when we talk about the premeditation that we see, it starts at least back in June, when we have Christina telling us about Alex Cox saying that he wanted to kill Charles, Lori having no reaction to that, and instead talking about drugging Charles. Did you hear Alex making some comments?
Yes.
And you told us that they made you uncomfortable. What were these comments?
He stated he wished that he could just kill Charles.
Okay. Was Lori around when he's saying this?
Yes, one of the times.
Okay. So he said it more than once?
Yes.
Can you describe for us, Kurt, his demeanor when he's saying this about wanting to just kill Charles?
It was jocular, just as I probably was standing up and just talking about it pretty loudly.
And you said one of the times that he said this, it was around Lori.
Yes.
Did she react in any way to hearing her brother say that he wished he could just kill her husband?
Not that I recall.
By July 9th, or when we start having this planning that we're talking about, we know that Lori Vallow is living in a house paid for by Charles Vallow. We know from even her statements to Detective Enclan that she doesn't like Charles, is what she says, but Charles won't file for a divorce. We know from her words and text messages that she wants to be with Chad Daybell, but Charles is her cash cow. She hasn't worked. He pays rent, car, cell phones, her travel. And so as far back as June 9th, we're already hearing that Alex and Lori would like to not just get rid of Charles, but kill him. But if you think that June 9th wasn't the beginning of this planning, this idea, this concept that Lori and her brother have of getting rid of Charles, this evil, dark, possessed person, that we know on the 9th that there is definitely a plan by this defendant. And we see that through those text messages with Melanie, with Summer, with Alex, where she speaks of the mission, where she talks about telling Melanie, you can't leave. You got to pretend to be sick and stay here and keep track of Brandon so he doesn't come help Charles. You can't be in the picture. We need to stay here to defend ourselves from an intervention. The 10th, again, we have Melanie who is talking to her and saying, that she wants to just go to this wedding. And what does Lori tell her? No, you have to stay here for the mission. The mission of stopping an intervention? No. As we continue through the 9th, we see Lori getting everyone lined up to help her. Alex, where he again is told that he will be like Nephi, just like her. Now Lori tells him it's an intervention. Everyone knows, Adam told you what's an intervention? It's talking to someone. It's common language. But that's not what the defendant wants to happen. She doesn't want Charles to divorce her and lose his money. She doesn't want this intervention to happen where she loses her temple recommend. What she wants is to be like Nephi and get rid of her husband.
Well, Nephi was a prophet in the Book of Mormon. It's the first chapter. He was a prophet, very humble and faithful servant of the Lord. Ironically enough, his brothers tried to kill him at one point. But he actually ended up going to Jerusalem to get these plates back, and he was run off, came back, and then went back again because the Lord asked him to. And when he did, the King Laban, who was actually a wicked king, was laying on the ground drunk in front of him, and Nephi was told to kill Laban.
Who was he told by?
The spirit, or God.
So God was using a Holy Spirit to tell him to kill Laban, and
Yes.
did he?
Yes, he did.
Was that something he anguished over?
Yes.
But ultimately, it was a justified killing.
Yes.
You heard from Detective Duncan that everyone he spoke with gave this same story. And again, the defendant questioned others about this story. But what we've heard is from Detective Duncan and from Adam that Nephi is this justified killing. When we think about her religious beliefs and what she's been telling people about not needing to repent, about telling people who is dark and evil, a zombie or a Z, that she is above the priesthood, it makes sense that she feels justified in determining who should live or die, just as she told her brother on the 9th. And we know that in fact we're talking about a justified killing because Alex brought a gun over. He didn't bring the Book of Mormon to talk to Charles about something. He didn't bring a friend to try to record Charles saying something. He brought a gun with him. And then he waited there for his sister's husband to come into the house so he could kill him. What we see is a very planned out, premeditated murder. But let's talk about some additional premeditation. Again, as we're looking at Summer, we see on the 10th that Lori is having her sister update her on where Adam and Zach are staying, so she knows they're not with Charles. They're not coming over. They're not going to be interfering with their justified killing. And there's that 12-minute time where the defendant desperately wanted to rewrite the timeline as they told the police that day. This just happened. It was very quick, but it wasn't. It was 12 minutes. Charles arrives at 7:37 and Lori leaves at 7:49. During this time is when that plan, that premeditated murder occurred. So let's talk about that as well. The evidence at the scene, the physical evidence, supports this premeditated murder. Alex fired 2 shots. One of them went through Charles' center mast, exited out his back, and went into the floorboard. The second one, Charles was on the floor, on his back, bleeding out, still able to move, and we know that because he had blood on his left hand, and he was executed as he lay there on the ground. In that time, when we talk about premeditation and reflection, as Adam had to move his hand down, reposition the gun, and discharge and pull the trigger one more time, that is premeditated first-degree murder, no matter what you believe before that. Again, when we talk about that physical evidence, we saw the fact that the location of that bullet defect in the ground matched right under Charles's left shoulder. And we heard from Dr. Baumgartner. Dr. Baumgartner told you that this was a classic shored wound. And no matter how many questions could be asked about him of maybe a bamboo shirt might stop a bullet in one location but not in another, or how many matrix-like hypotheticals where maybe Charles bounced back up and then on his way down, the bullet slowed down through him and waited till he hit the ground again before it exited. Dr. Baumgartner told you, no, those hypotheticals, those issues did not make sense. He's never seen a t-shirt stop a bullet in one location or at all. And we know Charles didn't
bounce because we know he had no injuries to the back of his head. This also tells us a little bit about the shooting itself. When Charles was shot that first time through center mast, he did not fall straight back and land onto the ground, laying there on his back. If he had, he would have had bruising, abrasions on the back of his head when he hit the ground. He didn't have anything on the back of his head. Where did he have abrasions? On his knees. When he fell to the ground after being shot, do we know how long it took him to roll over, to fall onto his back before he was then shot a second time because he's still alive? You heard it could take up to 2 minutes for Charles to have died, and then he could have spoke and moved during that time period. What we do know is that he eventually ended up on his back. And while he was on his back is when he was shot the second time by Alex. This defendant and her brother in that house waiting and making sure that Charles was dead, murdered, executed. Words, actions, motive, and physical evidence all tell you what happened that morning. So let's talk about conspiracy. And I know there are a lot of layers here, and I'm just building them up for you. You're told in your jury instructions that conspiracy requires proof. One, the defendant agreed with one or more persons that one of them or another would engage in certain conduct. So again, we look to Lori Vallow's words. What she had been talking about for months, Charles being possessed, being dark, wanting to kill him, the discussion on June 9th, poisoning him or drugging him previously. And then when we got to July 9th, it is all coming to a head. We will be like Nephi. Her actions, having Charles come to the house, instead of him staying there, she had him stay away. Why? Because if Charles stayed at the house, couldn't have Alex come over with a gun and be ready to shoot him, right? You got to have him come in. Her actions of inviting her brother over with a gun the night before so he would be there. She knew when he would show up. He texted her, "I'll be there at 7:30, pick up JJ." But most importantly, why did Charles stay in the house? Lori told the detective that Charles initially was like, "Oh, I'll just stay here for 20 minutes and then I'll take JJ to school." Well, she wasn't going to kill him in front of JJ. No, take JJ to Burger King. Get him out of the house. Go put him in the car. And he does that. But then she takes his phone. And she won't give it back. What she told the detective was, before this alleged Tylee bat, whatever thing you want to talk about there, that she had Charles's phone and was asking him about texting Adam. Of course, that's interesting because how would she have known that? But we know she had the phone actually for a while before she did that interview. She tells the detective numerous times that Charles is telling her to give him back his phone, and she will not. That she's walking around. He's trying to get the phone. She won't give it to him. Why? Because she needs Alex to come out. He brought that gun over for a reason. So she agreed with one or more persons, her brother, Alex, that she intended to promote or assist the commission of such conduct. Well, of course, we know both the promote. She is the one who on the 9th said, "We will be like Nephi. It's time to stop this whole thing." Charles trying to take my temple recommend, all this stuff that's going on. Time to kill him. And of course, she assists by ensuring that Charles stays in the house when she takes that phone. And of course, they knew that it would constitute first-degree murder. That's what Nephi did. Only unlike Nephi, where it was justified, here, ladies and gentlemen, this murder was not justified. Finally, think about the demeanor when you're thinking about, again, words, actions, motive, and demeanor. When Lori comes back to the house, she is very, what did we hear that word many times? Nonchalant, calm, no questions about her brother, no questions about her husband, no questions about the house, just laughing about her neighbors. She is in absolute agreement with what has happened. She knows what's happened and she's calm and good with it because she doesn't need to repent. She is able to determine who should live and die, and she has done that. So when we talk of the scope of conspiracy, you're told that to prove a conspiracy, it is not necessary to show a formal meeting or express agreement. But we see that from the night in that conversation that she and Alex had, where she tells him, you are going to have to stay near me for the next couple days, and we will be like Nephi. You're also told that a conspiracy may be inferred from circumstances showing a common criminal objective. So, just because you don't have someone who says, I heard them say, we shall conspire, you can infer that from the conduct of what happened on the 9th, the conduct of what happened on the 10th, and the conduct of what happened on the 11th. All infer to you a conspiracy of Alex coming over with his gun to shoot and kill Charles. As we again look at this in this conspiracy, again, we're looking at the same words and actions. March, Charles is no longer there. There's just an evil spirit in his body. June, Charles is still possessed, and now Alex is saying he wants to kill him. Lori is fine with this, and she says she's drugging him or had been drugging him. And then 2 weeks before, all of a sudden, Charles knows Lori's been having this affair. Lori's words, actions, motive, and the physical evidence. Conspiracy again, we see that Lori and Alex know exactly when Charles is showing up. Alex doesn't go to the door according to Lori and confront Charles or tell him we'll send JJ out and you can leave with him. The world is so difficult. How hard would that be? Bring JJ right to the door and let him leave with his dad. No, you aren't going to shoot him outside. You want to make it look like self-defense inside. As you go through this and we think about what's going on, the defendant doesn't even care. She wants her husband killed so bad that she's willing to let her brother bring over a loaded gun in an unlocked gun case in a house with a 7-year-old autistic child. That's fine. When the defendant was questioning Detective Enclan, she was talking about how hot it was outside. JJ's out in the car. But she has no problem with an unlocked gun in the house with the kid, and she's worried about her child out in the car. She's not. We know that because she's the reason Charles doesn't go back out into the car and leave. She keeps him there in the house. She is why JJ's out in the car alone. She has to keep him there until Alex comes out and can shoot and kill him. When we talk about that premeditation, obviously we're talking about that message. We know from the 9th on, they are premeditated, they are conspiring, and it's all heading to July 11th. We look at the timing of this, and this is actions and non-actions. Charles is in the house for 12 minutes. After those 12 minutes, they wait 47 more minutes before they call 911. Why? To stage the scene. No CPR is performed. They wait for Charles to be dead, and then they talk during this time period. They talk. They could call 911, but nope, they're going to just talk. So again, you're looking at their actions, what happened and didn't happen, and the motives. There's the gun that was used to kill Charles. We're going to go through a couple of these exhibits, some of what Lori said, and it's exhibits 192 and 197, where she again says that Charles came over and said he was just going to hang out at the house for like 20 minutes, take JJ to school. She, of course, tells him to go. And when JJ is out in the car, she has Charles's phone, and she won't give it back. And no matter how much she says that Charles is screaming at her to give the phone back, she won't. And all of this conversation about Charles demanding the phone back is prior to her statement to Detective Enclin that Tylee comes out with this bat. This is all her doing. This is her as an accomplice assisting and promoting this murder. Lori is setting up Charles so Alex can shoot him.
And with JJ? And so he put it in the car, in the driveway, and then he came back in, right? So I kissed JJ goodbye. He came back in, and his phone was on the counter, and I had his phone. And he was like, give me my phone. And I was like, why don't you show me your text that you've been texting, blah, 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 you know, whatever. Because he's like acting really weird, like he's plotting something against me. Like, I'm like, why are you even here? Like, what did you come here for? You know, he's been talking to my other brother, and my brother came into town at the same time last night. And I haven't talked to my brother in a while, my other brother. And I was like, and so he was texting him on the phone when he first got to my house. And I'm like, why are you texting Adam? Like, do you even talk to him? Like my other brother.
So when you listen to these clips and the interview of Lori Vallow, you have to put into context. This is 9:52 in the morning when this part of this interview is occurring. And she's telling the detective that she confronts Charles about texting her brother Adam. Now, she's had the 47 minutes she's been driving around, and then that time at the house when she's waiting outside to learn all of those texts and what's been going on between her brother and Adam and Charles. And so she is now mixing this in to her interview. And so when you're listening to her interview, we know she's trying to work out this, what happened? How did this go? You can watch her demeanor as well. And as you're going through this, see how she's just telling a story here, like what happened, almost chuckling about it.
Okay. So this morning he comes back in and... He comes back in, I haven't given his phone, he was screaming at me to give him his phone. He was very worried about whatever was on his text that he did not want me to see. And so I was just holding it there and he was screaming at me. And I was kind of walking towards around the house with it so he couldn't get it. He's like reaching for it and stuff like that.
So again, JJ's in the car, Tylee's not out, Alex isn't out, and she is making sure that he doesn't leave. She's walking around the house, holding his phone, refusing to give it to him, making sure her autistic child is sitting out in the car even longer so that she can ensure that exactly what they've been planning happens, that Alex has time to come out with the gun that he brought over and shoot and kill Charles. This defendant is the only reason why Charles didn't leave with JJ. This defendant is the one who provoked Charles by taking his phone and refusing to get it back. This defendant is the one who ensured that Charles was inside without JJ so Alex could shoot him. And this defendant is the person who set up Charles so that her brother Alex could shoot him. So let's talk about staging the scene. We know obviously from the first responders that when they arrived, no CPR was given. You heard from Officer Wierzbecki that when he felt Charles's neck, he thought he was dead already, but they still let the first responders in because they've been told CPR had been given. And what do we know? That they arrived within a few minutes. No one had ever tried to save Charles. No blood had been pushed out of him from CPR, whether strong or light. He had been dead for quite a while. His skin was mottled when they started cutting open his shirt and looking to the back, and lividity, the blood pooling, was occurring already. So they kind of knew something was off with that timeline. So what about the scene itself? The bat. It is placed to the right of Charles to look like he was using it. Got shot and it went flying behind him. Well, obviously we've heard from Kay, Charles's sister, that he was left-handed. We know from the blood evidence on his hand, he was left-handed. There's no damage to that mirror. There's no damage to the drywall. There's no damage anywhere, like this bat is being swung around in this horrific fight that's going on of grappling. The injury to Alex Cox's head. You heard it was a small 1-inch cut that he was using a paper towel to pat, and at times, as you watch that Exhibit 1, rubbing it, making sure it stays bleeding. There is no blood at the scene from this giant grappling thing going on that Lori Vallow wanted them to believe. His head is bleeding and they're grappling around and he's being beat with this bat, and yet not one drop of blood on the floor. Not one drop of blood going down the hallway when he put that gun away. Not one drop of blood on the gun itself. And then the shoes, left by the door to look like Lori Vallow had run out in fear after this horrific incident that they planned. But what we know from the Walgreens video is that she did enter the store with shoes, something on her feet. So we're going to go through. We know Charles again, left-handed.
Field with your brother.
Yeah. What position did your brother play?
He was a pitcher. He was very, very good. He was a left-handed pitcher, and they're very hard to hit against.
Okay. Did he bat right or left-handed?
He was left-handed.
Did he do everything left-handed?
Yes.
Left-handed? So we know that Charles batted left-handed, not right-handed. And what we know is Lori Vallow had a story about how Charles was using that bat. And it becomes very important as well when we're talking about the staging of the scene. This is Exhibit 193.
Yeah, she was outside, and then what happened? Then they got up from that, and my brother had like stepped back, I guess, and then Charles was coming with me to that and yelling at me to give him his phone still because I had it in my hand. It was all really quickly, and then when I went around kind of in the circle, then my brother was there.
When you said when you were going around and he was coming at you with the bat, how was he holding the bat?
Just like that, like backwards.
Like he was swinging, but like swinging it backwards? He would have done like
he would have swung it backwards at me, not frontward.
Okay.
So Lori Vallow, detective, and planned that Charles is swinging the bat backwards. Now, if the bat was like this when he was shot, his arm would have been shot. Covers his center mass. So we know he wasn't here. So if he's out here, where would the bat go? Down, out, somewhere that way to his left. It would not end up thrown up above him. And if it wasn't there again, Charles would have been shot through the arm. Obviously, Alex forgot that Charles was left-handed. So when he placed that, like he was coming at him with a bat, their stories didn't quite match up with the evidence. So if we rely on Lori's story of how Charles was holding the bat, then there's zero way that that bat would end up where it ended up. And again, we know he's left-handed from not only Kay, but his own admissions of that blood on his hand. So we see the scene is staged, this bat that is so necessary to try to ensure this justified killing is legally justified and not just spiritually justified. When we talk about the scene as well, and you're looking at where Charles was, at least when that second shot went through him, you can see in the photograph to the right, the shot to Charles's chest, right between his nipples, and the shot to Charles's abdomen down lower. We know that that first shot through his chest, that Charles would have been facing a little more towards the open area there where we see the hallway and the kitchen. We know that because there was the bullet trajectory Detective Coons told you about that entered that far east wall. We know there was stippling, and so the defendant would have been, well, her brother would have been within 2 to 4 feet of the muzzle of that gun within Charles, 2 to 4 feet. We know from the lack of that injury to the back of his head that he didn't fall straight back. We know from the blood on his hand that he was still alive after he was shot. And we know the lack of stippling for that shot to his abdomen and that trajectory, and even the defendant's own statements that she saw her brother at Charles's feet, that he would have stood there at Charles's feet when he fired that second shot as he was laying on the floor. You have the bat, Exhibit 249. You can look at the edge of it. You see the photograph of the edge of it. There is no blood and no damage to this bat. Regardless of how many times the defendant was hoping that blood was invisible, we have all cut ourselves and seen that blood is red. And there was no blood on this bat. There is no blood on this bat. There is no damage to this bat. So you have a semi-professional baseball player who has a bat in his hand, and he sees someone with a gun and doesn't beat him with it, take his head off with it, knock him unconscious with it. Instead, all we see on this bat is 0 damage and 2 partial prints. No prints of a body or smushed skin on it. Someone that's sweating from a fight that's left a large arm print on it or anything else. Nope, just 2 partial little prints on it. When you think about what is there and what isn't there, does the evidence of this bat fit in at all? It doesn't. We look at Charles's watch. No damage to it, no scratches to it, no dings to it as he's grappling on the floor like Lori wants you to believe. We know that at some point, Charles is standing and shot, and we know that final shot, he's on the ground. We know he fell to his knees at some point. And when you look at that physical evidence and the lack of damage or anything on that bat, again, what makes sense is that Charles fell to his knees after that first shot. We know that there is 12 minutes where the defendant and her brother are still together there, so that Alex can get this 1-inch cut to the back of his head that's barely bleeding, that he uses a paper towel to dab at and rub. The shoes that the defendant ran out of on her way out. You have the exhibit. You can see black straps across her toes as she enters and exits the Walgreens. And then you see that she's wearing the flip-flops when she comes back to the scene. What do we know? That the police did not search Charles's rental car. Credibility. You are given a credibility instruction and you use it for everyone, including the defendant. You're told that you really evaluate people the same way. You're looking for any inconsistencies in their stories, any reasons why they may have a motive or bias to lie, any prejudice they may have, and then you look at everything in light of reason, common sense, and experience. When you think of the testimony of the people who come here and talk to you, Christina Atwood, Serena Sharp, Nancy Jo Hancock, Adam Cox, Dr. Bumgardner, the detectives, Robin Smith Scott, Mark Zari, what benefit do these people have in being untruthful to you? They have body cameras, they have prior documents, and they have memories of what this defendant said. But the credibility of Lori Vallow is something you do need to consider. And you start with her demeanor that day where she wasn't worried about anything when she arrived. Her brother has allegedly been hit in the head with a bat by her husband who plays semi-pro ball. She doesn't even worry about him. She knows he's not hurt. He's fine. And why does she know that? Because that was staged. When she's there and we see her on body cam arriving, she's just nonchalant and calm. And I know the defendant wanted to make sure that it was clear that everyone else was calm, but no one else had just allegedly seen their husband get shot and killed by their brother. When you were looking at the reasonableness of her testimony, you have to consider it in the light of reason, common sense, and experience. And the way that she was acting and reacting that day, as well as her own statements, do not fit the evidence, do not fit the physical evidence. And you will see her credibility throughout this whole case has been questionable. Her credibility with Social Security. What did we learn? That on July 11th, she tells Detective Enclan that she and Charles are separated. Exhibit 187. We are not living together. Charles rented her house. We're separated. But on August 12th, when she needs to make sure she gets some money, she tells Social Security, when they ask, are you living together at the time of death? Yes. You also learned that she was not truthful with Social Security when she got remarried. She did not tell them about that either. So we know she's been untruthful to Social Security twice. Why is that relevant? Because you're judging the credibility of Lori Vallow throughout all of this. Life insurance. We know that she said Charles was accidentally shot. We know that was not true. She wanted to make things seem like she had nothing to do with the murder. But we know that Alex Cox intentionally shot Charles. Whether or not she wants to claim it's self-defense or not, there was nothing accidental about shooting him twice. Then that second call to Banner Life Insurance, where she tells Robin Smith Scott a few different things to garner sympathy, and she asked her if she could do anything about the change in beneficiary.
I really can't give too much information, but I can tell you that the beneficiary was changed in March of this year. Okay. Okay, I'm trying to figure out what he was doing since we have 5 kids and we've been married for 15 years. Oh, I'm sorry.
So Lori tells this woman, we have 5 kids, which if you want to count them all and admit that 3 of them are adults, then okay. Really, they have one kid in common. Tylee, you learned, was actually getting Social Security survivor benefits from her dad's death starting in 2018. Lori's son Colby isn't living with them. Charles' son's never lived with them. Why does she say these things? She can't help it. She's just wants to just make herself seem better than she is. What about the credibility of her interview, even during the police interview? We talked about a few things, but one of the things she told the detective.
That I didn't file anything or whatever. And then he filed something against me and said, I'm only gonna get supervised visits because I'm crazy and blah, 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 you know, the story. And so I just didn't talk to him for like 30 days and let him take care of him and let him see what I've been doing.
So again, she can't even be honest and say 2 months. It's gotta be like 30 days. I was kind enough to just leave my husband with my son for 30 days. What we know is that Lori Vallow was gone a total of 78 days, 58 while she's flying to Hawaii, going to Idaho and back with Chad. And who's taking care of JJ? Charles. And Kay is coming here regularly to help take care of JJ, to help run the business. And then eventually on March 28th, that's when Charles finally decides he hasn't been able to find Lori. He doesn't know where she is. He's going to move to Houston to be closer so his sister can help him more easily. And this is when Lori finally shows back up. So again, even the simplest thing of just trying to be honest about how long she's been gone, she has to minimize it and make herself seem better.
You with your cross.
The shoes. Oops. If this will play. When she was questioning Detective N-Clan, she was asking her if it was hot in July and if she would need shoes to go take her son to school. But of course, what we know is that we saw her with those shoes on as she went into Walgreens. So again, it's continued trying to garner sympathy and just being untruthful about whatever she feels like being untruthful about. And then we look at the credibility and that timeline, that body cam.
You know, now that you're not in Santan, this is your home?
Right,
Gotcha.
right.
Okay.
We just moved in here.
Gotcha. How long have you guys lived here?
Okay.
How long have you lived here?
Like 3 weeks.
Oh, geez. Yeah, okay.
That's why the neighbors took us.
Gotcha.
Like, hi neighbor, sorry.
Are you working?
So here she is, 47 minutes after leaving the house, laughing and smiling with the detective about the fact that her husband is dead inside the house. Her brother is sitting on the curb, allegedly with this very serious injury from a baseball bat. When you look at that credibility of the defendant, you have to look at everything together and what fits, again, with the physical evidence and what doesn't. Finally, let's talk about the justification defenses. What we know is that Lori Vallow thought she was like Nephi, that she was justified in killing Charles. That her brother, who was supposed to be like her, was also justified in killing Charles. But Lori Vallow is not justified under Arizona law, nor is Alex. So let's go through the different justification defenses. First thing that you have to consider for every one of these, self-defense, defense of a third person, or crime prevention, is the non-justification for use of deadly physical force. You are told if a person is not justified in using or threatening physical force or deadly physical force against another in response to verbal provocation alone. So Charles yelling and screaming at her to give his phone back does not justify you shooting him. Or a person is not justified in using or threatening deadly physical force if the defendant or co-conspirator provoked the other's use or attempted use of unlawful physical force. So we know here Lori provoked Charles by taking his phone and refusing to give it back. So again, when we look at every one of these defenses, you'll see not only do they not apply, but none of them is the defendant entitled to. This is not self-defense. In self-defense, you're told that a person, a reasonable person, can use deadly physical force if they believe that deadly physical force was immediately necessary to protect against another's use or apparent attempted or threatened use of unlawful deadly physical force, and the person used or threatened no more deadly physical force than would have appeared necessary to a reasonable person in this situation. We know that Lori Vallow used Charles's phone to get him to come back inside, and she used his phone to keep him inside and give her brother time to come out and shoot and kill Charles. We know from the physical scene itself that Charles did not use a bat. We know from the physical evidence of Alex's 1-inch cut to his head and the lack of blood or concussion, the lack of damage to the mirrors, the walls, the location of the bat in relation to Charles, they all tell us that Charles did not use a bat. We know that Charles was a semi-professional baseball player. This would not have ended that way if he had had a bat. But even if you somehow think that he did have a bat and he was swinging it at Alex, the defendant, whoever, he still was not justified in shooting him when he was on the ground. It has to be immediately necessary to protect against another's use. When Charles is on the ground and he is shot that second time, there is no threat to anyone. And so that is not self-defense.
Counsel, I need to give my court reporter a break unless you think you'll be done in the next 5 minutes. Okay, go ahead.
When we look at the physical evidence, again, we know that Charles was on the ground, shot, and so this is not self-defense. And we know from the physical evidence at the scene, projectile into the floorboard, this is not self-defense. Third party. You're told that a person is justified in using or threatening deadly physical force in defense of a third person, I presume here Lori Vallow. If a reasonable person in this situation would have believed that deadly physical force was necessary to protect against another's use, again, of unlawful deadly physical force against a third person, and they used only what was necessary for a reasonable person under the situation. What do we know? Lori Vallow told Detective Enclan that she wasn't even in the room when she heard the shot, that she had gone around into the kitchen. Who's he protecting at that point? What third person that's no longer there is he protecting? You can't protect against a future, what might happen, or what already occurred. It has to be now. And Lori Vallow herself put herself outside the room when her brother shot Charles. So there is no third party defense. But again, the same thing applies. Even if you thought so, that second shot removes any possibility of being justified. Crime prevention. This is the exact same thing, only in a slightly different stated way. But like self-defense, it allows a person to use deadly physical force against another to the extent a reasonable person would have believed that deadly physical force was immediately necessary to prevent Charles from committing aggravated assault against Lori Vallow. We know she's not in the room. Even if he had that bat and had been coming at her and then she left the room, that crime is over. And again, even if you believe he had the bat, You cannot shoot him while he's on the ground. That is not what crime prevention permits you to execute a person. Finally, there's mere presence. You're told that guilt cannot be established by a defendant's mere presence at the crime scene, mere association with another person at the crime scene, or mere knowledge that a crime is being committed. Lori Vallow wasn't just present at this crime scene. She brought her brother to the crime scene. She ensured that he brought a gun with him. She ensured that JJ was outside, and she ensured that Charles stayed inside. She was not merely present. She was a person who was actively participating in this crime. Ladies and gentlemen, we have talked about the evidence in this case. Evidence that was presented to you through witnesses who took the stand and exhibits that were admitted for you to review. Remember the evidence of Lori Vallow's motive. Charles's life insurance, Chad Daybell. Remember Lori Vallow's own words of wanting to get rid of Charles, of drugging him, her acceptance of her brother's statements that he wanted to kill Charles, how she used Melanie and Summer to plan her mission and ensure that Charles didn't have help from Brandon or Zach or Adam. Her words to Alex about it all coming to a head, that he had to stay near her and they would be like Nephi, justified in killing Charles. And finally, her words to Chad Daybell on July 18th, confessing to the killing when she said Charles had changed the life insurance before we got rid of him. Look at her actions and demeanor, having her brother come over on the 10th to her house with a loaded .45 caliber handgun, creating the one and only reason why Charles stayed inside the house, why he didn't just take JJ to school. The 12 minutes that Charles is at the house before Lori leaves in the car, the 47 minutes after that before they call 911, her demeanor when she comes back, not caring that anyone has been hurt, her demeanor on the body-worn camera, during her interview, what you heard about during the drive. Think about her credibility, how she cried for you in her opening statement. You certainly didn't see her cry on that body camera footage. You didn't hear about her crying as she was being driven to the Family Advocacy Center, and you did not see her cry in her interview. Finally, think about the physical evidence that proves that Lori and Alex staged this scene, that Charles was never in possession of that bat when he was shot by Alex or either of the shots, that instead he was executed that day for this defendant's benefit. The physical evidence disproves beyond a reasonable doubt that Lori Vallow and Alex Cox were justified under the law in killing Charles. The jury instructions tell you to use reason, common sense, and experience. Charles Vallow is dead today because this defendant and her brother Alex Cox conspired to kill him. They planned it out, and they had their weapons, and they orchestrated a way to ensure that Charles was back in the house where he was shot and killed for money and Chad Daybell. The evidence proves to you that Lori Vallow Daybell is guilty of conspiracy to commit first-degree murder, and the state asks you to hold her accountable and find her guilty. Thank you.
All right, we're going to take our 15-minute afternoon recess. I'll remind the jurors to remember the admonition. We'll resume in 15 minutes.
All right, for the jury.
We made it to break time. Yes, it's break time finally. Indeed. I mean, they spent 67K because, when Lori's third husband was bye-bye, yeah, they had 67K that they blew up probably within like a day or something. But yes, finally, that part is done. Now we have only a 15-minute break before our lovely Lori, that sounded, ugh. Lori starts her closings, and I wonder how long she's gonna be, because it's already 3 o'clock right now in Arizona. So I don't know how long she's gonna be, but if we have any deliberations, I don't know how long they're gonna be today. It's I don't Looney Lori, definitely. We had Looney Sarah, Looney Booney earlier last year, and then now we have Looney Lori. That's a tongue twister for very late at night time. Um, yeah, he had nothing left. It's absolutely, yeah. Um, yes, indeed. You definitely can call me. You can join the stream yard. I can post the link in the chat, and you can call in. It's free. You don't have to have the camera on. You can just be audio and just follow that link. You can be literally audio on. You can chat with me, chat with chat, and I don't have to talk for 15 minutes straight in your ear about everything and nothing at the same time, because I'm gonna let you into a secret that is not secret. It is oh, definitely. If you're doing something in this break while I'm talking with Noand, get popcorn ready. Get that popcorn ready. Get a snacky snack. Get healthy snack if you want, Maria, like fruit. No, I'm joking. Get some snacks because it's gonna be good. It is gonna be good. I am not gonna say anything else, but it's gonna be good. She's doing she hit all the points, and I agree, Forrest Nelson. And by the way, thank you very much for the gift, the memberships, and thank you very much, Lois, for that. I really really appreciate it. But yeah, she did hit all the points. She said what she had to do, and to be fair, I don't think she has to do much. And hello.
Hello, I have something to say.
Ooh, yes, go on, say it.
So my name is Sissy, and I call from South Carolina, but I wanted to say I think the prosecution has done an amazing job, but I think she polluted the closing so much. I mean, I just think they've been bombarded with all this crap, and then she went over every single piece of minutia. I would have picked 3 points, 3 arrows, and just drove them home. I would have said, this is evidence. This is evidence. And you saw this is fact, and this is fact, and this is fact. I don't think she had to go over the entire timeline, which she also did in the opening. What do you think?
True. I was like, people are literally agreeing with you in chat. Rubber says yes, too much information. Mel says agree. It was really long. It was really long. I thought she said she was only going to be an hour. Yeah, that was the longest hour of my life. Willow says agrees. I agree with you. She could have cut down a lot that closing. That is for sure. But she rambled on it a bit. But
she just went over the entire, sorry to talk over you. She went over the entire timeline, which she also did in the opening. So right away, there's an hour and 35-minute opening of, again, listing minutia and then saying, we're going to show you why, and then more minutia and we're going to show you why. The facts are bad enough. Are bad enough. You did this, you took the phone off a dead man and drove around this town, and you're barely sane, and you're going to represent yourself. You can't say stuff like this, but that's the fact. Anybody looking at you in that goofy, Jolly Rancher makeup face, that, you're not with it. You're not in the same zip code as everybody else. I'm just saying.
Oh no, yeah, she's in the Kukulkan zip code. That is for sure. Lois is saying that you need to do the closing. I think you should have done that. I think you should have
Sign me
gone.
up.
to Arizona, and definitely indeed.
Sign me up. I'm going to be like, look, boys. So first of all, we know it's the majority of the jury, like high majority. I think there's one or two women, but most are men. And I'd be like, look, boys, let's just look at the facts here.
Yeah,
You
that
know,
is
blah
true.
blah blah. You got to speak to people on a more, I don't know, to me, but I'm not an attorney. Well, but what I do know, you know what I am is a bartender. So what I do know is how to talk to people. So
And
and
making drinks.
how to persuade them to spend their money. So you know, look, boys, this is what we got. We got Killa here sitting here saying she's, you know, she's not, you know, that the evidence will show, and she's going to follow me and say the evidence did show, but you and we saw something else, and there's just too much piled up against her.
Oh yes, it is. I don't. That's what I say. I think even though we are close to the end of the day, I think we're still gonna have a verdict today, and it's not gonna even go past 5 o'clock. I think it's gonna be rather quick. Everyone is literally agreeing and saying that they love
Oh,
you.
good.
Denise is saying, "Oh, Susie, I love you so much," and everyone is agreeing with you. And as always, no one is agreeing with me, but that's fine.
And
But
she gets
no,
into the legalese, and she literally says, okay, a bit of legalese here. You know, somebody ring the gong, press the buzzer, tell her, stop, 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 stop.
well, the
Nobody
judge
wants to
did.
hear the
I mean,
legalese.
like Journey just said, the judge did tell her to move on. It's like not just because the court reported needed a break, but also she needs to wrap it up, otherwise she would still be there, because she can go to the risk of losing the jury, and literally just, okay, the jury's been listening to too much, and
You know
it's
who else we saw that was like this was the state of Florida, the special prosecutor for Collins' case, and I know you don't want to talk about that anymore, but he didn't play to the jury. He thought the facts just added up so plainly, so simply that this is this, where there was no emotion, there was no, you know, playing to the. I think there's an amount of. Absolutely right. I couldn't be attorney. I pretend I'm an attorney and I play one on TV, but I couldn't be one. But there's an amount of humanity, of you know, the personality. And who did get this right in recent history was the Nicole Rice lady. Her attorneys were extremely, you know, just put the human label on it, and you know, brought up the fact it was 10 years. There's just a matter of, you know, you've got to mix some of that, you know, still be a person. Don't stand up there and just dictate what it says on your notes. You've got to still be persuasive. You've got to be someone they like. They want to side with you.
And I agree with you. I know I don't like to talk about Colin case because I'm still very upset about it, and I know Denise is gonna tell me off that I need to move on, but I will never move on. I don't think at this point.
Me neither.
But I think the prosecutor in that case, he was a little bit too cocky. That he said, "Oh, I am here by myself, nothing on my desk. I can just
Yes,
do
he
this."
never had an assistant. He never gave any personality. If he stood up, his hands were in his pockets, and he has perfect posture. And you know, walk around a little bit, but use your hands a little bit. You know who was good at that was Wolfgang.
It's exactly. So it's like literally it was a little bit too cocky. And the Nicole Rice attorneys, they did their job at the end of the day. I did not like, I don't think no one liked the celebration that they did in the end, but in the end of the day they did their job. They got the not guilty for their client, and they were good at it to present the reasonable doubt, and that was it. So and I agree, and I would like more judges to have that. Journey says that some judges have a time for closing, and that should be the end, because like otherwise the attorneys can just go on and on and on and on and on, and it's just like, for example, the Linda Sturmer case. Oh my days, I am so glad that we watched those closings, because they literally took almost 2 hours each.
Yeah,
So
It just you get in your own way. You've got to remember, and I don't know, you know what? I'm going to ask someone on X or someone, I don't know if I know attorney and, I meet a lot of people, but, is there a class on being persuasive and let the facts and let the evidence lead the way and all that, but also you got to kind of be a talk show host. You got to be, doesn't this, let's add some humor. Anyway, I'm sure other people want to call. I don't want to dominate this whole thing, but I couldn't let
No,
her
more
just
than one
be.
people can call at the same time, so it's not a
Oh, okay.
problem.
Oh,
And
okay.
it's less talk that I have to do it. I can just let you
Right. Well,
talk
that's
and
why I thought I'd rescue you because I know it's almost, is it midnight or past midnight where you are?
no, it's 45 minutes to midnight, so it's 11:15 at night, nearly quarter
So
past 11.
if it's 11:15 here where I am, I'm not going to talk like this. I'm going to be sad and sleepy. So
Yeah, I
I'm
am
only
getting
like this during
sleepy.
the day.
I did take a nap earlier. When I
Oh,
said
good.
I'd be right back, that was me just sitting in my chair taking a nap because I was falling asleep. So
Who could blame you? You've had quite a week, and now you got to go back to you got to go back to making the donuts.
Oh, I know. It's crazy, but it's almost finishing. We are on a home stretch for Lori Vallow. I'm gonna miss it. I'm not gonna lie. In a way, I'm gonna miss this trial for some reason. I do like I don't like the lateness, but I like the spiciness of it. The spiciness was very, very good. Um, so, um, um, Hockey. Sorry, I think that's how you say the name, and I
Hawkeyes.
hope Hawkeyes.
Hawkeyes. Yeah.
Thank
And
you.
also, our new people should know that Katia speaks 7 languages, and English is like way down on the list. I've been a mod for her for a while, and I've been a member for her channel for a long time. She still calls me the wrong thing, but
I do not
it's
speak English.
50, not fizzy. But we don't correct her. We just appreciate her intellectual ways and her lovely welcomings and big heart and the way she approaches things. That's
I
what we
I I don't speak English. I'm gonna plead the fifth right now.
do. Well, I am
Definitely gonna
thrilled to
plead
be
the
here.
fifth right
Yeah.
now. See, I'm learning the Constitution. I can plead the fifth, even though I'm not in the US. I can still gonna.
Yeah, you absolutely can. And if you can't plead one, I'll help you find a 5th.
All right. So I am gonna do is just before we carry on, I am gonna start the clock because jury has officially started deliberations.
Okay,
Uh,
you do that. I'll let you go, and we can wrap it up, and then we'll all listen to Lori.
yes, we're definitely gonna have to listen to her for a little bit. Oh, hang on. Why is this not working? So yeah, okay. Or you can carry on while talking while I fix this issue that I'm having
Okay,
of the extra camera.
okay.
You can entertain everyone.
Oh, now
And
what? What am I going to
yes,
say?
well, exactly what you're saying right now, talking to me, giving your
Oh,
opinion about the case, and
I'm
well,
kind of snarky in chat. I like to be sarcastic. I like to,
Mhm.
but I also have like I'm one of those that'll walk away and listen to the case and listen to the attorneys and the evidence through what do you call these ear pods, earbuds, whatever they're called. They're new to me and they don't stay in unless I put them in the wrong ears. And so anyway, but then it's something, whatever the way I learn or the way I absorb things is wrong. Can you believe that? I mean, that's obvious by listening to me, but I have to come back and say, wait, did this happen? Am I wrong about this? And I don't like to do that because it distracts from what's going on currently. But I don't get much done if I'm sitting here watching and I have to absorb, and then I learn a lot from the comments, right? Like I really
Yes, for sure.
appreciate people going, "Oh, that was bad," and go, "Wait, what?" What? Because I thought it was good, and it's extremely, extremely enriching to me. It enriches my life because I retired like 5 years ago. And so I sit here with my associates. You know, everybody knows they're really
I
dogs,
think they're
but
coming back.
okay, good. Now it's on you again. Okay, very good.
Thank you very much, Susie. Hope to see you
Bye,
very
guys.
soon. Bye. All right, so court is coming back very soon. Um, we're gonna hear Lori's deliberations. I have the timer on my phone and I have it on my computer, but I don't know why I can't have a second camera, but I'm gonna just kick this out. I am so sorry. Um no, I don't want to do that, StreamYard. Yeah, we should be back soon. Well, feed, yeah. Oh, it is not live actually. There you go.
The state of Arizona has the 100% burden of proving that I committed a crime, a grievous crime, conspiracy to commit premeditated murder of my husband, Charles Vallow. The state has the burden of proving to you that this event was not self-defense. In your jury instruction under the instruction, use of force and crime prevention, the last line reads, if the state fails to carry this burden, then you must find the defendant not guilty. In the law, under your jury instruction titled Justification for Defense of a Third Party, the last line reads, if the state fails to carry this burden, you must find the defendant not guilty. Under your jury instruction titled Justification for Self-Defense, the last line reads, if the state fails to carry this burden, you must find the defendant not guilty. In your jury instruction under presumption of innocence, it states, the law does not require the defendant to prove innocence. Every defendant is presumed by law to be innocent. Under the burden of proof, it explains that the state's burden is this. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. If, on the other hand, you think there's a real possibility that he is not guilty, you must give him the benefit of the doubt and find him not guilty. In Arizona, self-defense is defined as not being a crime. So let's look at what we've learned in this trial. We learned that a shooting occurred and that 911 was called, that law enforcement was notified. We learned that fire, EMS, and Chandler police arrived at the scene. We learned that my brother, Alex Cox, came out of the house with his hands up as directed by 911 and was questioned by the police in the driveway. We learned that I came up with my daughter Tylee, and we were told to wait by the car until police would speak with us. We learned from Detective Inklin on the stand that we asked for Tylee's medication from the house for her panic attacks, but it was not given to her. We learned that eventually my brother Alex was taken in a police car to the Chandler Police Department uncuffed. We learned in this trial that my daughter Tylee and I were also taken to Chandler Police Department in a police van. We heard from Detective Inklin's testimony that her goal was to make small talk with us. And
The jury will determine what the testimony did or did not show. Go ahead.
that her goal was to make the small talk with us and all the way to the station so she could speak with us separately before we would talk about what actually happened. We learned that all three of us were separated and taken to 3 interview rooms where we each told police of the events of the day, each from our own perspectives, and answered all questions asked of us. We saw snippets of that interview in the trial here. The state did not show you the entire interview. Most of my police interview is admitted, though, into evidence in this exhibit. It's number 286. And I would encourage you to watch that entire interview when you start your deliberations. It is important. It is important for you to determine for yourselves my demeanor and not listen to anyone else. You can see it with your own eyes and hear it with your own ears. We heard from several witnesses that because this event was almost 6 years ago, that their memories of the events and statements were probably better back then. Well, my police interview happened that very morning, and I told the police the events from my perspective at that time. It is admitted into evidence and will answer many of your questions. You did not see Tylee's interview, but we did learn from Detective Inkland that she did an interview that morning as well. You did not see Alex's interview, but we learned that Alex was interviewed that morning by Detective Moffett, the original case agent, whom we did not hear from in this trial. The state chose not to show you those interviews.
Object, Your Honor.
Or let you listen to the 911 call.
Right.
The jury shall disregard that last statement. Okay, the jury can only consider what was admitted into evidence.
We learned in this trial from Officer Kautheim's testimony that Alex was injured on the back of his head with a bump, and according to his testimony, a 1-inch laceration. We did not see those pictures documenting that injury as well. We learned in this trial that we did not know, the three of us, that our interviews were being recorded. We learned that Alex's phone was taken by police and put into an evidence bag, according to Detective Duncan, and that no digital copy of Alex's phone was taken by the Chandler Police Department, even though this is their normal protocol. We learned that Alex's phone was returned to him that same day with no further inquiries. We learned that after my interview and Tylee's interview that we were introduced to a victim's advocate and that gave us further instructions in another room where Tylee and I were reunited. We learned that soon after that, all three of us, Alex, Tylee, and myself, were taken in another van and dropped off back at our house. We learned that we were instructed at that time that we could not enter the house yet, that we were directed by law enforcement to take the rental car, since all three of our cars were inside the police tape. We were directed to return later in the afternoon when the scene was cleaned up. We learned in this trial that we did as directed and left the house in the rental car close to 12 p.m. We learned that we did not return to the house until contacted by Detective Inkland to return to the house so that Alex could walk the detectives through what they call a walkthrough. We learned that many detectives were present during that walkthrough with Alex. We learned that Detective Duncan was there, Detective Coons was there, Detective Moffett was there, Detective Werther was there, and an officer with a body cam was there. And yet, we were told by Detective Duncan, the case agent on this case on the stand, that because of some problem, the walkthrough is not recorded. Detective Duncan also informed us that he does not know if any of the people present wrote a report about it. We can infer from Detective Duncan's testimony and the fact that we don't have in evidence any body cam footage of the walkthrough and no reports talking about it, that there are none, even though this would be crucial evidence for you, the jury, to have.
Sustained, the jury should disregard that comment. Again, the jury can only consider evidence that was admitted into testimony. I'm sorry, testimony that was admitted into evidence or exhibits that were admitted into evidence.
The state of Arizona has the obligation to show you evidence to prove that this event was not self-defense, as stated by the only three witnesses. So why not show the jury all the evidence that they gathered?
Again, sustained, the jury can only consider the evidence and testimony that was admitted into evidence.
We learned in this trial that Alex fully cooperated with law enforcement. We learned that my daughter Tylee fully cooperated with law enforcement. We learned that I fully cooperated with law enforcement. We learned that law enforcement treated all of us that day kindly and courteously on July 11th, 2019. That law enforcement treated us that day like this was self-defense. We were not given instructions to stay in town. We were not given instructions that we were under investigation of any kind. On July 11th, 2019, we were interviewed by Chandler Police and released with no further instructions. We learned that Chandler Police put out a press release that day on July 11th.
I'll sustain that objection to the extent the jury is to determine what the facts did or did not establish.
Under Arizona law, I had the right to self-defense. Tylee had the right to self-defense. Alex had the right to self-defense. This event was not planned or expected. It was shocking. We learned in this trial that Chandler Police Department neglected to do a thorough investigation. We learned that they did not swab Alex's hands for gunpowder residue. We learned that they did not swab my hands for gunpowder residue. We learned that they did not swab Tylee's hands for gunpowder residue. We learned that they did not luminol the gun. We learned that they did not luminol the bat. They did not test the DNA on the bat that they collected. They did not test the floorboard. They did not test the projectile. They did not test my husband's shirt. They did not search the rental car. They did not search any of our 3 cars that were there at the scene. They did not test the gun until over 5 years later. The Chandler Police Department did treat this event just like it was, self-defense, and a tragic family event. We learned in this trial that Charles and I were obviously having marital problems. Regardless of what was happening in our marriage at the time, on July 11th, this was self-defense. When Tylee came out with the bat to protect me, her mother, Charles did not have to take the bat from Tylee and start swinging. At 62 years old, Charles had a choice that day and could have put the bat down. A 2-minute period changed our lives forever. How are you supposed to choose between 3 people you love? Your husband, your daughter, your brother?
Testifying at this point?
All right, hold on. All right, I'll caution the defendant not to testify about things that were not entered into evidence.
How can you decide for another person if they feel threatened? Why does the state want to blame to someone?
It's a reasonable person standard, not the standard of the person.
I'm sure you'll point that out in rebuttal. I'll allow the argument as that inference. Go ahead.
Why does the state want to blame someone for this tragic event? What evidence did the state show you in this trial that I wanted harm to come to my husband? We learned in this trial that I was praying for my husband. We learned in this trial that even though my husband and I were having marital issues, that we were both trying to do the best things for our son with special needs, JJ. We learned in this trial that I was shocked that Charles had changed his life insurance policy, but I was not angry as the state alleges. In the phone call we heard from the insurance company, we heard that I was disappointed for our children, our grown children, as well as our children still at home, but I was not angry. My husband Charles was providing for our children still at home. I had no motive to change that. We heard a lot in this trial about the Book of Mormon prophet named Nephi. This is the state's evidence to murder over self-defense, and it is utterly ridiculous. We heard from Detective Duncan, who admitted on the stand that he had no idea what I meant in the text message when I said, "We will be like Nephi." In Mormon culture, Nephi signifies strong faith, perseverance, and courage.
All right. Sustained.
The state's attempt to misconstrue the positive text message about a wonderful religious figure, Nephi, and try to turn it into an order to kill someone is absurd. This is an attempt by the state to try to retrofit a crime that doesn't exist. This event was not a crime. It was a tragedy. Don't let them turn my family tragedy into a crime. When I'm done speaking to you, the state gets to get up and rebut all that I've told you. They've got to have the last word, so to speak, because it is 100% their burden to prove to you that I committed a crime. And you won't be allowed to hear from me again. So I want you to remember that it is the state's job to prove to you that I committed a crime. And if you have not seen the evidence that leaves you firmly convinced that I have committed this very crime, then the state failed to show you the evidence that you need. Because I did not commit this crime. The only interview the state entered into evidence is mine. So I encourage you to go watch it. I told you just what happened that day, just the way it happened. The state put forth a bunch of evidence in this trial in an effort to make you dislike me, to try to attack my character, so that you would just say guilty no matter what evidence they showed you. But only you get to decide. The state put up witnesses that had zero knowledge of a conspiracy. The state did not show you evidence of an agreement to commit murder. They showed you evidence of a family tragedy, and then they showed you the sad effects of a family torn apart because of that tragedy. That's all.
All right, the state does have the burden, so they have the right to open and close the argument. Do you want to give a rebuttal close? Go ahead.
The execution of Charles Vallow is not a family tragedy. There is nothing that you can say about shooting a man as he lay on the ground that you can try to construe in any way to make that a family tragedy. This case is about the defendant, not Alex Cox. Alex is involved in it because that is her co-conspirator. We are not here to determine his guilt, albeit it is quite obvious. This defendant wants you to just look at one piece, and she wants you to hope that there's only a person who will say, I saw, I heard the conspiracy. But what did you hear in every instruction is that you can look to other evidence to show that. This defendant wants you to forget about her words and pretend that when she told her lover, her soon-to-be husband, we got rid of him, that he changed the life insurance before we got rid of him, that somehow means what? That they killed him. And he changed his life insurance before they killed him. What does that tell you? That tells you motive, and that tells you who did it. This defendant is one of those we, because she's writing it. She wants you to pretend that when she is talking about Charles for months, acquiescing and agreeing to her brother killing him, having people tell her that it's wrong, having people know that they're planning for something, that those words don't mean exactly what they are. We got rid of him, this defendant. The state, of course, has the burden, and that's how it should be. But every one of those justification defenses falls short when you look at the conspiracy itself. When they got rid of him, they did it by planning it. There is no reason that Alex Cox came over to this defendant's house with a loaded gun and waited for Charles to come inside, held there by this defendant using the cell phone. That is conspiracy. That is planning. That is premeditated. You can absolutely watch that whole video. That's why the state included that for you. What you're going to see is that Lori Vallow doesn't cry. She is not truthful, as we've gone through. Her timeline is absolutely wrong. She tells the detectives it's quick, it's 12 minutes. She wants you to believe that the police could understand all of this that day. But what did you hear? Is that all the police could tell initially was that the timeline was off. And then they started learning that the physical evidence seemed to be showing that Charles was executed on the floor, but they needed to see if the medical examiner agreed with them 2 days later. And then they needed to pull all those iCloud accounts, phone records, and go through terabytes of data to bring forth these things that you have now learned and hold. They interviewed these people who learned of the defendant's religious beliefs, that she was exalted, that she was celestial being, that she didn't have to repent. Of course she thought she was Nephi. We learned that the physical evidence on Charles and at the scene show us that he was executed. And every single one of those defenses that the defendant has asked you to look at, the state has met its burden. Because even if you somehow believe that Charles actually had that bat and it wasn't staged like the rest of the scene with the shoes and the lack of blood there, that second shot is not justified for self-defense, crime prevention, or third-party defense. Arizona law does not allow you to execute a man on the ground. The defendant wants you to believe she was shocked and surprised by this, and yet she goes wandering around, goes to Burger King, Walgreens, drops off her kid, comes back and jokes about her neighbors. Not one action of a person shocked, surprised. She wants you to feel bad for her daughter, Tylee. You saw her there. You heard from the detectives. She's also not shocked, crying, upset, worried. And you saw Alex. Same demeanor. Why? They've had 47 minutes to work it all out. Go through Charles's phone, figure out what they're going to say. They've talked on the phone twice in this time period. This case relies upon all of the investigation that the police did. That day, when they knew that timeline was wrong, that day when they started to understand that the physical evidence at the scene was staged and wrong and didn't match what the defendant was saying. And then all of the evidence after that, culminating when this defendant told the man that she married later that she was having an affair with, as many times as she wants to say, Charles was my husband. She didn't want him as her husband. She wanted Chad Daybell. She wanted that life insurance policy, and yes, she was angry about it. And she said, we got rid of him. That is her confession to you. That is why she is guilty of conspiracy to commit first-degree murder. Thank you.
All right. Do we have Izzy coming over? Izzy to be sworn in? All right, members of the jury, there are 14 of you, only 12 of you can deliberate. At this time, we're going to choose the alternate jurors by random lot here. So we have our scientific method here of random numbers.
14.
Juror 14.
5.
Juror 5. I don't think you're 5. Well, maybe you are. Okay, so to the alternates, if I don't see you again, I want to thank you for participating in this process. The admonition still applies to you until we call you and tell you that it's been lifted. I have in the past had to have callback alternate jurors to testify or to deliberate when, for whatever reason, one of the jurors can't continue to deliberate, becomes sick, has a family emergency, etc. So you still could have to deliberate in this case. But again, if I don't see you again, I really do want to thank you for participating in this process. I know it might be somewhat of a disappointment to not deliberate right now, but we will keep you posted and we'll let you know if we need you. The remaining 12 jurors will retire to the jury room and begin your deliberations. First, we're going to swear in my staff.
Do you swear that you will take charge of this jury and protect their deliberations from all outside interference and communication? And when they have reached a verdict, you'll bring them back into court without revealing the verdict to anyone, so help you God. I do.
Izzy, drop those off. Undrop those off.
All right, so the jury.
All right, all right. So we'll see if they say anything before they adjourn for verdict watch. And yeah, I think jury 15 is very sad right about now. He's very dumped. So 1 second, Paula. I'll get back to you.
The jury's no longer present in the courtroom. I've passed out proposed aggravation phase jury instructions in the event that there is a verdict of guilt. The state elects to proceed with an aggravation phase of this trial. So I'll let the parties review that. It's not too long.
I could just spelling mistake on page 3. That's as a 3 in it.
Got it. All right, we'll be at recess until we hear from the jury.
All right.
All right. So they are not sequestered. They go home at the end of the day. And I don't want to burst anyone's bubble, but the jury has gone home. So jury has then deliberated for the day. They have deliberated for 19 minutes officially today. So, and they are coming back tomorrow for the carry on of deliberation. So, literally already finished the day. So, they have deliberated for altogether 19 minutes again. And yeah, they're done. They're done for the day. The aggravation phase, I think it's the sentencing phase. So good night, Nancy. Thank you very much for joining in. So I think tomorrow, Denise, is gonna be about around the same time, but if they go what they go I can't speak anymore. If they go early, I will jump on early, but I've been putting at the same time at I think it's a 1:30 Eastern that I put. I need to check the time conversion. It's late. My brain is not braining. 6 p.m. UK to Eastern. Let me check. I've set up the stream for. Oh, come on. Why is doing this to EST? At 1 p.m. Yes, I put the stream for 1 p.m. tomorrow. I'm very silly at night. You guys don't want to know that. I think you all will go unsubscribe and go all bye bye. I get silly, but oh, okay. Yeah, no worries. Absolutely. I'll try not to cry. But no, absolutely. We know that Karen Reid starts tomorrow. We might be jumping up and around, looking for a trial, see what's going on, maybe finishing the other one that we did start last week, and then do something else and see what's going on in the world of true crime. But tomorrow, I'm also going to have Zizzy here because I want to know her opinions about Lori's closings. But I guess it's gonna be for tomorrow for that part. I will definitely indeed go to sleep because I have to wake up in about 4 hours. I need to go to work in about 4 hours. So yeah, no, I am not talking to babies now, Jason. No, I'm not. So, but thank you very much, mods. Thank you, everyone, everybody. I love you lots. I'll see you all tomorrow, 1 p.m. Eastern. We will be back online on stream, and have a great night, evening, morning, wherever you are. Good night.
And I'm a real-time crime professional.